To mention two order 40 and one matrimonial application.
Matrimonial appeal, no.
Application.
Application.
Application for payment.
May I permit to mention Order 41, Rule 1, injunction against the
With
injunction?
Milord's kind leave, Milord, in this matter, Milord, your lordships were pleased to file directors for filing the paper books, Milord. I am praying for inclusion of the matter, Milord. The paper books have been filed.
Not now. Yes.
Order 41.
That also order 40 and for inclusion.
Order 41 matter.
Yes.
But may I be permitted to mention while I'm mentioning for upgradation of item number 79 of
No.
the argument says that while a planet single judge has imposed a cost, huge amount of the cost upon the petitioner, and the next date of submission of the cost is Friday, my lord. Kindly upgrade it.
Item 79.
Yes, my lord, 79.
But you are challenging on merits also, not only
Yes,
the
yes.
cost.
And on the allegation that the material fact has been suppressed, but whereas learned single judge has failed to consider that the fact has been suppressed at the instance of the respondent authority, my lord. And kindly,
Friday is the date we don't have time. Because tomorrow we will be taking singly.
any date, my lord. Any
Before Friday, it's not possible. Today is the only day before Friday. So we cannot take up today without notice. to the-
instead of Friday, Monday, my lord. If it is
No, no, no. Let it remain.
Your lordship,
Cite the pendency of this matter before the lunch.
lordship,
I am also mentioning order 41.
lordship, I'm mentioning a application, your lordship. It's a very small application, your lordship. Your lordship,
Application is mentioned.
lordship, it may be taken up any date next
Let it
year.
appear in the list first. Yes.
may I permit to mention, so it's I'm mentioning from inclusion, my lord. So which
What?
an appeal out of a matrimonial suit. It is ready
Hearing.
for hearing now.
Yes.
Your Lordship, I'm mentioning for one application and one order 41.
Call on the list.
My lordship kindly to mention one application in connection with the first appeal.
Yes, lordship. In this.
Yes,
Yes,
application.
this is application. My lord has been pleased to pass an order only
Correction, lordship.
Please.
4th November. Kindly see the order. Your lordship has been given liberty to the
No, no,
applicant
we'll, if it's
to
an
file an
application,
application along with
write application and hand over the slip. We'll
yes, my lord.
In this.
His other side. my
Yes,
lord.
because on 25th of August.
Let it appear. Yes.
Let it appear. Paper book is lying ready. He's not telling that paper book is ready for hearing.
But,
Let
But
the
it-
appeal be heard. Along
yes,
with
yes.
Let the application come up. We are not
Well,
adding hearing matters. Yes.
My lord's previous.
Sorry.
Direction was to filing the appeal.
Let the
Paper
application
can-
come up.
Have your lordship kindly for an to mention Milord for inclusion an application in connection with the mandate.
Yes.
May I be permitted to mention one matter for inclusion in the list?
What is the matter? Application order for
First appeal.
hearing? No. Yes. Next. Call on the list. Call করুন। Fight দিন। Yes, Mr. Vedar, what is the
Sir,
correction?
last-
Instead of allowed, you have written dismissed or what?
Dismissed my lord application,
Rejected.
my lord. Last para 19, last page. It was application for injunction, man.
This can to is dismissed.
Can twist.
The appeal has been allowed.
Appeal allowed, my lord, the can to application,
Can to is injunction application.
injunction application.
In the order dated November 11, 2025, comma, in paragraph number 19, comma, instead of the expression double inverted dismissed, let it be recorded as disposed of. Double inverted.
Grateful, my lord.
Grateful, your lordship.
থাকবেন ফাইলটা সঙ্গে সঙ্গে দিয়ে দেবেন।
Item number 2 applied for the petitioner, my lord. This has come up at our instance for other extension of interim order.
The nature of the interim order, Mr. Shen.
Interim order is stay of the final decree of partition, my lord. My lord had passed an order, my lord, on 24th of February 2025, my lord. Interim order was granted till 30th of September 2025. The same was extended, my lord, on 24th of September 2025, my lord.
This arises out of
Partition suit, my lord. Final decree of
final decree.
final. My
That
lord,
was for a limited period.
my lord, my
What
lord
is
had
the, yes, sorry, please.
My lord had granted limited interim order, my lord, that has been extended, my lord.
Right.
Now the extended interim order is it will expire in the next week, my lord. That's why, my lord.
What about the appeal? What is the stage of the appeal?
But the notice of arrival of lower court records has not been served till date, my lord.
Take information whether it's
My lord, subject
have
to
the records
what my
come?
learned friend say, my lord, yesterday I got information that the matter may be settled.
Settled.
No, Lordship, my client has came to us, Lordship, both of my other Lordship respondent also, that according to them, a proposal has been given by the present appellant through WhatsApp.
We'll extend the time for some time and till January. And in the meantime, if there's a settlement, just mention the matter. We'll have it.
But let it be extended for 6 months, my lord. Most probably that by then.
But Lordship, so far,
6 months. If it takes 6 months to arrive at a settlement, it will not arrive.
Lordship, so far the paper book is concerned. Paper book to
Let the interim order stand extended till January 31, 2026. First of next para, since it is submitted by learned counsel for the parties that there is a chance of settlement between the parties, comma, liberty is given to the parties to mention the matter for inclusion in the list whenever the matter is settled between the parties. Whenever it is settled, mention, we'll put it as to be mentioned and disposed.
Application is kept pending, my lord.
Yes, the application shall be listed next in the monthly list of December 2025.
Application.
Item number 3.
Yes. This yesterday's matter?
Yes.
Yes.
Yes. Milord, I will take, Milord, first of all, Milord, I have to address your lordships on 3 points.
No, you said you'll cite a judgment and
Yes,
distinguish the judgment.
Yes. No, first of the 3 attendant point, Milord, I could not answer, Milord, the overcome. Now, Milord, the 81 regulation, that 81, Milord, it defines, Milord, the I will show, Milord, certain provisions, Milord, which I omitted yesterday, Milord, kindly. It is, Milord, I'm sorry.
আচ্ছা কাল হিয়ারিং হচ্ছে এই বইটার উপর এটা থাকবে না সামনে এখানে রয়েছে এইটা হ্যাঁ রাইট এগুলো এখানে তোলা হয়নি একটু এখানে রয়ে গেছে
একটু উঠুন না কেউ ওখানে
ইম্পসিবল আপনার বই হ্যাঁ ইয়েস মিস্টার বাসু
Yes. Milord, the building regulations in respect of lands covered by the Calcutta
You are
Tenancy Act.
relying on which provision?
I am relying on, Milord, only. Holding means 8.
What
The
which
building
section?
regulations,
What section? Which section?
section, Milord, that is regulation 8 of, Milord, the building regulations in respect of lands covered by the Calcutta Tenancy Act.
Don't have that.
এই বইটা দেখুন এই আইনটা
Building regulations. The same book. Then it should be there. Which no.
page 96.
Both are common laws, but regulation is not there. What can we do? It's a
No, yesterday it was
fault of the publisher. Yesterday it was there.
it was shown.
Then
And
it
you
must
got
be
to
there.
read it. একটু দিন না জজ সাহেবকে এইটা আমার বইটা।
Wait. Oof. 1981.
Yes, building regulations in respect of lands
Yes,
covered by the
it's-
Calcutta
it is-
Tenancy,
This is the same publisher. It should be there. Let us find out the
96, 97, is it there?
latest.
আমি কেন ছাপাবো?
না, এটা রেখে দিন। Regulation number?
Regulation 8.
8, yes.
After definition, holding means a parcel or parcel of land occupied by any person as tika tenant under one lease or one set of condition where such tenant has been occupying the land before the commencement of the Act 81. Milord, got it?
Yes.
Then, Milord, the premises. Premises means a holding. Then, Milord, application for permission for erection buildings pakka structure in tika tenanted lands, no person shall be allowed to submit a plan for erection of a such and such to make addition alteration hard pakka structure in the tika tenanted land without in written permission of the tika controller. Calcutta, Milord, subsequently is the Calcutta Municipal Corporation I have shown. So the premises means holding. Then, Milord, Calcutta Tika Tenancy Act, West Bengal Tika Tenancy Act 81. Milord, your lordship would be pleased to find the same definition in a way that is section 3. There is no conflict between the regulations and, Milord, the holding means a parcel or parcel of land occupied by tika tenant or other lands under one set of condition includes a bosti. That is not.
Basu, whatever you argue, put it in a
Bullet point means the landlord says.
No, bullet point, written notes of arguments will take tomorrow.
Yes.
Give it tomorrow.
Tomorrow it's not possible.
We've
Monday.
already argued bullet
Tomorrow,
points only.
Milord, only Milord, I will, and Milord, and Supreme Court judgment I have to Milord overcome, Milord. Milord, the points, Milord, with regard to the existence of the building, I said, Milord, land include premises includes land. If premises includes land, if the Act makes the provision or contemplates, Milord, erection of a Paka structure, and if it says that the moment it is a vacant land, I come within the purview of the Thika tenancy, then Milord, the Paka structure, otherwise, Milord, it leads to the path of discrimination. This cut-off date by the legislature, Milord, and these points were never argued. I will rely on, Milord, of a Salmon jurisprudence, Milord, paragraph page 12, 12th edition, Milord, from a judgment reported in the Supreme Court, Milord, which says when, Milord, the particular point is deemed to be sub silentio. Milord, I am addressing your lordship not to, Milord, unsettled, Milord, this settled law. It is not possible. It's an unreasonable argument. I cannot, Milord, by your lordship's reasonable time. But this weight of silence, Milord, as reflected by the Supreme Court, Milord, while not addressing the parties in the proceeding, did not argue.
So are we supposed to say that the Supreme that
No.
sub-silentio applies and we don't abide by the Supreme Court judgment?
No,
Can we do
question is, Milord, that sub silentio is a
that? If we
relevant.
were at a parallel footing, if
No,
we
Milord,
were also
I am
Supreme
not.
Court,
I am
would have
no,
understood.
but I am not inviting the court, Milord, to say that the judgment is par incurium. But the Supreme Court authorizes the Constitutional Court, subject to correction
By
after reading.
citing sub-silentio principle, Mr. Basu, can we
Milord,
differ from a
No.
specific proportion?
No,
laid down by the
I
Supreme
will say, Milord, because I will also
Power.
no power that I will when Milord a decision, Milord, I will also rely on a Dalbir Singh by State of Punjab,
Yes.
which says, Milord, that two ingredients when it is a shared decisis applies. It says, Milord, combination of one
Dalbir
and
Singh
two.
is all right, it's fine.
No,
But
I
Mr.
know it's a
Basu,
very
it
difficult.
has to apply between parallels,
No, Milord, it has to apply. But
horizontally.
no, I
High
said,
Court
Milord,
cannot say that
no,
the
High
Supreme
Court cannot
judgment
say,
is
but
bad
the
because it's sub-silentio.
no, absolutely not. Milord, but the High Court can say, Milord, whether it is because your lordships were disturbed. Yesterday, Milord, as I have, if I have correctly understood your lordship's mind, that it is Article 141. I bow down because if it is an Article 141, then Milord, what are the ingredients?
Specifically argued, specifically decided.
Specifically argued, but not the all provisions of law issues not decided in complete manner.
Suppose all provisions of law not argued before the Supreme Court.
No, then
The correct ramifications are not argued by the Supreme Court. Still, the Supreme Court comes to a conclusion on a specific finding, on a specific issue, which is argued directly and decided directly.
Yes.
Can we then say, because it's not a question of constructive res judicata sort of thing, that something might and ought to have been argued but not argued, that applies? This is not that sort of a scenario. We are speaking about a binding precedent, Mr. Basu. Whether that estoppel sort of scenario applies to a judgment.
But
because it could have been argued, not argued. Yes, parties may be bound by issue estoppel or otherwise. But if it was not argued, Supreme Court has decided.
If it is not argued, then
there will be no settled proposition of law by the Supreme Court. Every proposition of law you can come up and say this point was not argued.
That is why Milord, Supreme Court says that we are not bound by our own judgment many a times.
There is a subtle distinction between us and the Supreme Court.
Yes, Milord, but I will
subtle.
Yes,
Milord,
I know, Milord, this is a very difficult journey.
High Court Division Bench just cannot say that I don't abide by this judgment because it is sub silentio. We cannot do that.
Milord, I will file my written notes of argument by Monday at 10:30. Give me, Milord.
That will not help that.
No, I will address this issue. I will, Milord, in my humble way.
Address it right now.
Now, Milord, 1990.
Unless you argue it, you cannot put it into
140. I will refer the Dalbir Singh judgment. This says that the stare decisis principle based on
stare decisis, yes.
Yes.
But that was Supreme Court versus Supreme Court.
Yes. No, Supreme Court versus Supreme Court. But if it is that in order to hold that a particular law declared by the Supreme Court comes in the purview of Article 41, what are the ingredients? Because your lordship is disturbed with the facts that there is a judgment under Article 141. Supreme Court says 1990 was not considered.
And Supreme Court in every other matter, Mr. Basu is strongly criticizing High Courts, distinguishing on the ground on some frivolous ground. And here it is not a question of distinction on facts. Here you are saying we have to declare that a binding precedent of the Supreme Court, a judgment, specific point argued, specific issue decided. And we have to say that is sub silentio. Probably that would create a judicial anarchy, Mr. Basu.
Milord,
even if we don't agree with the Supreme Court judgment, we can constructively criticize it. Yes, in our judgments also we can do that because we are as good a citizen as anybody else. But we have to stop there. We can constructively criticize even a judgment of the Supreme Court, but we cannot say that judgment is not binding on me or you. Milord, that is the difficulty we are facing.
Milord,
even if we are convinced by your argument.
Yes, Milord, I am extremely grateful because, Milord, I have gone.
Even if.
Milord, I am,
Grateful, even if we are convinced.
Milord,
Yes.
Milord, my understanding of Supreme Court, Milord, 1990 Supreme Court, Milord, in order to become a judgment within the meaning of Article 41, what are the ingredients? It says, if Milord, your lordships are disturbed with the facts that the law declared by the Supreme Court on this core, Milord, binds, Milord, the High Court. I agree. I have no option, Milord. But the question is, the sub silentio, Milord, comes to the point. It is not an affront to the order passed by the Supreme Court. It is an honorable passage. Milord, it is a handle given to the High Court, Milord, in the moment of disagreement. Milord, I say, Milord, I would not invite the court by any stretch of imagination.
The moment of disagreement will be
disagreement with the parallel.
Will be set on paper. That's the difference.
Yes, Milord, I will.
And that will also be that will also be public records.
No, yes, Milord, your lordship.
Disagreement may come.
No, Milord,
but it cannot be put on paper.
No, I will show, Milord, that you, since, Milord, logically,
Mr. Basu, we also have some responsibility as a court of law, in the sense we are telling you why. Because it may very well happen, I pass a wrong judgment, tomorrow Justice Bhattacharya sitting in some other bench feels it is bad, or some other judge. We always do that. But if it's a judgment of a higher court, hierarchically superior court, then Mr. Basu, that is binding on us. Even our own judgments are binding on us, but we have that option. We can say, single judge, we can say it is bad law. Division bench, we can say it is par inferium. At best option to refer it. But if it's of a higher court, this is not a question of single judge division bench of the same high court. It's a higher court hierarchically. And Article 141 is not available to us, which is available to, we have at best 227 read with court of records concept and chartered high court some extra things. But 141 stares at your face.
Yes.
Even if we say it is sub silentio because some arguments, some sections were not shown to the Supreme Court. It is presumed that the Supreme Court was aware of all the sections, all the law, all ramifications, and came to this finding. Now, how do we get over that? Even Supreme Court does not review its own judgments.
Milord, the same Supreme Court in 2005, Milord, in the 4 SCC 741, Milord, if your lordship look at
If you tell a wrong page, we won't.
No, Milord,
I can't memorize that. So it may be a wrong page also.
Computer welcome.
Sometimes it happens. It is right a judgment,
no, Milord,
which we don't know take advantage.
No, Milord, kindly, Milord,
what was held there?
Held there, in a case of a review, the mistake on the part of the court, review. In the mistake committed by the court.
That principle does not apply
because
to
since your lordship says many a times, Milord, that it is a judgment within the meaning of Article 141. The same Supreme Court says that in order to become if I hold that this particular judgment comes within the purview of Article 141, these are the ingredients. So, Milord, 141 is the essence. That means, Milord, the High Court, it is not for the High Court to follow 1990. If your lordship says your lordship has to follow Supreme Court, this is 2022, then I would urge, Milord, that your lordships are also bound to follow, subject with humility, Milord, that also take note of this judgment of 1990. If your lordship finds a conflict between these two, I said, Milord, is like a parallel line, Milord.
No, 1990 is on a separate issue.
1990, Milord, when
that's on presidentiary value.
No, Dalveer Singh and 1979 and 1990 Dalveer Singh and these other judgments.
If Supreme Court in this judgment overlooked the previous order, judgment of the Supreme Court.
No,
then we could have thought.
No, Milord, so I will
followed the better in point of law or more applicable to the facts of the case.
Yes, I will demonstrate.
Have that option.
I will demonstrate, and not only that, it will not be an affront to Milord, and it will not break, Milord, the concept of, Milord, the judicial committee and propriety and anything. Because, Milord, I tell your lordship, Milord, that this is also based on public policy. Supreme Court says that the presumption that the Parliament, when makes it law, presumption is constitutionality. Supreme Court, Milord, if that is so, Milord, if that is the understanding, Milord, subject to correction, what your lordships are telling, Milord, Supreme Court is prone to error. It says, Milord, the judge says, Milord, it is supreme but not infallible. But that is why, Milord, after 75 years, Milord, different times, different strong.
Try and argue that before the Supreme Court.
No, Milord, I will. If my time permits, after this devastating the catastrophic end of this case. But still, give me a time till Monday. Milord, since your lordship, Milord, invites us to make argument, it is not out of my imagination or innovation.
No, you have made this argument. You can put it on your
yes, I can.
We agree. We fully agree that this is a very good argument.
And Milord,
we'll take that into consideration.
Yes, I said the scheme of the act contemplates.
Don't shut our eyes. I mean, we are hearing you, and we definitely will consider it.
Grateful, Milord, because I
consider it.
I said, Milord, that if the scheme of the act,
so you say the entire scheme of the act not only this act, but the 2001 Act,
81, 2001,
49, all along.
all along.
Along the scheme has been that yes, if a ticket tenant is permitted to make construction with sanction of the court, sanction of the authority, then it cannot be a closure. I mean, it has to be pakka structure as well.
Yes.
And also the definition never said only kacha.
Landlord means the landlord who is entitled to receive other land means vacant land.
Right. And Supreme Court considered Lokimoni and came to
49.
Interpreted all the. Supreme Court has considered all the 49, 81,
2001, everything.
And has held at least up to 1st of November 2010. It could not, ticket tenancy could not include pakka structure.
Yes.
This is the specific finding.
Is the specific finding.
Para 113
yes,
of that judgment.
Yes. And Milord, that is based on the amendment brought about by the legislature.
Not based on the amendment. It says rather before the amendment, what was the position?
Yes.
By the amendment, it has been changed.
Yes.
Includes pakka structure.
Yes.
Therefore, by specific implication, Supreme Court held that since it now includes pakka structure, previously did not. So any structure was, and other aspects were also considered. Other aspects were also considered.
Give me time till Monday 10:30.
No further time.
No further time. Monday.
No further time. We are not giving
time. No, I written notes of argument.
Written notes will give.
Yes.
You have concluded your argument. You said you will cite some judgment.
Judgment, Milord, the judgments are with me, and one judgment which I just referred Supreme Court that is yet to come, Milord.
From the Supreme Court, or it has come?
No, come. No, Milord. The judgment, Milord, I will show two. I will say, Milord.
Give the citation, Mr. Basu, to that.
1956, Bombay. To 219, number 1, which says premises includes land, that was adjudged in respect of Milord the Factories Act, that is Milord says land. I said Milord, I will corroborate premises include land, and here also Milord premises says land.
That's a different state.
Yes, Milord premises includes land. Here I also show, and Milord the definition of landlord I will show. Dalbir Singh Milord, that judgment why I want to rely 1979 3 SCC. It says Milord, in order to become a precedent under Article 141 Statutory principle, what are the ingredients? I say, Milord, I will also take recourse to Order 14, Rule 2, Sub-Rule 2. That issue means that issue of fact and law.
So you give your photocopies along with your written notes.
Yes. And Milord, that is 1990 the judgment. Why Milord, based on Milord, the summon jurisprudence and taking recourse to Milord, the HON'BLE laws of England, Milord 12th edition. It says that is also there. 12th edition. It says Milord that sub silentio is a handle, Milord, given to the court not to affront, Milord, to the higher authority. That means the Supreme Court. And why it is because, Milord, the Supreme Court, Milord, has embarked upon an inquiry so far as the evolution of the not only the precedents, but also, Milord, the legislative journey in 49, 81, 2001. But the Supreme Court has omitted a certain portion because parties did not argue. The presumption of knowing everything, Milord, this presumption applies to Parliament. When it enacts a law, its presumption is that the Parliament is conscious about the previous law. But in case of court, the court will always going through an experiment. That is
presumption is a reverse.
No, I say, because otherwise, the constitution cannot be termed as a transformative constitution. We, the people of India, your lordship and I, both were not born at that point of time.
We are sufficiently pumped, Mr. Vasu. The law doesn't permit it. Sufficiently pumped. You inflate and explode suddenly.
I do not know.
We explode, then they will know.
Whether my argument makes sense or not, I do not know. But at the same time, it
makes absolute sense, perfect sense.
I will try to, I know it's a judicial mind, I can reopen it. So far as, kindly do not take it as a psychophan. I'm not a psychophan. But I have seen,
tell it. We always want affirmation.
I said, that your lordships, whatever your lordships are quoting, with regard to the judicial committee. Apart from that, sometimes, it is not only a court of law, it is a court of justice also. So if I say,
other times it is not.
No, Supreme Court says it is a court of law, not a court of justice.
Yes. Cite sometime that judgment. There we shall consider subsilence issue and
subsilence point I will take, sir.
On that point,
because I will supply them the judgment. Dalbir Singh, 1990 Supreme Court, 56 Bombay.
So that's your answer to this Supreme Court judgment.
Yes.
That it's subsilence issue. Therefore,
yes, and the ticker tenant, the landlord in respect of a vacant land, it applies, and the premises includes land. That is my submission.
And you may have an additional handle that because this judgment of the Supreme Court is a review of a previous judgment.
Yes.
So there are two judgments. This has reviewed undoubtedly. That is the last position. No doubt. But
And
even
and 2215 judgment, it says that this point was not adjudicated.
you have a
because-
handle in the previous judgment which was
Yes,
reviewed by
yes,
this
yes. And not only that, the Supreme Court also said in Nimai Chandra Ghosh's matter, the second time before the review was taken, the judgment was passed in this review, 22 to 15, it says.
I'm not so
paragraph-
adept in remembering. I mean, you
No, no,
give the citations and
22,
give the citations to me,
Yes,
Mr.
yes.
Dhar also.
এই 22-15 এসিসি যেখানে নিমাই ঘোষের জাজমেন্টটা প্যারাগ্রাফ 8 আর 9 এতক্ষণ লাগছে কেন বলতো?
What was said there?
Said Miller that the point with regard to the protection under the umbrella of the 81 Tika Tenancy Act, that was yet to be adjudicated. That is why the matter
It has now been
now adjudicated.
That is the difference.
Yes, yes. But
My Ghosh does not help you
no,
on
no.
that.
But the Supreme Court in yes, that is the So that is the point. My argument is this, Miller. The protection, Miller, the Supreme Court embarked upon an inquiry so far as the legislative evolution, judicial precedent, the evolution of the judicial precedent, everything. But Miller, if I take Miller the issue raised before the Supreme Court, issue of law and fact, I said this was argued, Miller, in a fragmented manner. If it is a question, Miller, that entire law was not placed, the entire issues were not raised. If entire issues were not raised, Miller, the subsidiary principle comes, and Miller, Dalbir Singh Bhandari, and Miller, this particular 1998 says that. That is my argument. I cannot, Miller, that is, according to the best of my ability, Miller, I have tried to make
No, you have argued fantastic.
deeply obliged.
Yes, Professor. What
সাড়ে 10টা আর নামটা দিয়ে দিন।
কল্লোল বোসের নাম জিজ্ঞেস করছেন কি হাইকোর্টে আপনার চাকরি ছেড়ে দেবে?
কি হচ্ছে?
Well, should we give one bullet points as well?
Yes, yes, give. Make those soft bullets. But not long. Bullet points are only 35 pages of bullet points. Just we replace the numbers by
At
bullets.
that point of time, I did not know.
Bullet point means short. Very.
At that point of time, I did not know, Miller, the brevity is the soul of it.
When did you come to know? When exactly did you come to know?
A few years ago.
When you met me, or
Yes.
you have a very good chance in the appeal, but in this appeal. But this will forget. That is the difficult. Anyway, put it in your written notes of our, not the last part.
Yes.
The legal points, put it in your written notes of our. Very short written notes,
At least
and there will be marks allotted to the brevity of the written notes of arguments also. Very, thank you. We'll close our arguments. Hearing is concluded. Judgment is reserved in the matter. Hearing is concluded. Oral hearing is concluded. Full stop. Learned counsel for the parties are requested to file the written notes of arguments on the returnable date. Full stop. The matter shall be listed under the heading to be mentioned on November 17, 2025. You also please complete. Yes.
But your lordships were hearing the
Hearing the-
reply. But Lord, I thought that if your lordship feels, Lord, I give me 5-10 minutes to just refresh what
Please do. Absolutely.
argument, Lord, I had made.
Absolutely. Mr. Bhattacharya is looking very menacingly at us. Please control him.
কি হচ্ছে? Why should I look?
Particularly after Mr. Basu was praising us.
Maybe Lord, taking.
But on a lighter note, Miller, now things have come to such a path, Miller, when two judges bench's order is being reviewed by the 3 judges bench. Even yesterday, Miller,
In our court.
No,
Oh,
there.
This said
Two
that.
judges say something, 3 judges say something different. Same fact.
We will also follow the same pattern.
This is now the rule of the day. Your lordship was saying about sub silentio and per incuriam and everything. Whatever was falling from your lordship, Miller, I was, Miller, hearing it. No, no.
Mr. Basu was.
No, no.
It was rebounded from me.
Yes. Miller, today things have come to such a
Try and say that a Supreme Court judgment is bad on the ground of sub-silence.
one view subject to Miller, with you. Miller, one view is perhaps there. That if your lordship feels that the Supreme Court has not considered another earlier Supreme
That is what
Court
we said.
procedure bench.
That is what we told him, because the judgment cited by the other side is a review judgment. So we said his handle lies in the judgment which is reviewed by this judge. So we can choose the one more appropriate.
Yes, that
But
Miller, is
that
possible
that
with
is
your lordship.
no, but that is not available to us in this case, because if the last judgment considers the previous judgment, then the last judgment is binding. If it overlooks, then everything comes in. And it is a review of that judgment itself, so it has to consider that.
And this is the last judgment considers, my lord, also our special bench judgment.
Everything.
And in
everything.
extensive.
That is
And
right.
Je Jotadhari Do, then Lokshimoni Dashi.
Lokshimoni Dashi,
everything is-
everything, and all the 3 acts.
In fact, this is a very, very well considered judgment. Lord, just Lord, I'll take 5-10 minutes. But,
So that will
because,
be necessary for my learned brother also, because it
because
was
my lord was not there in
not
the
there,
earlier bench. Lord, please come to page 158.
no main.
Lord, the writ petitioner respondent, they own a large chunk of land.
Yes.
Lord, they wanted to construct a multi-storied building. Now, Lord, for the purpose of construction of a multi-storied building, they have to obtain NOC from Lord HIDCO, because it's the authority who grants Lord the no objection. So there was an application. 158, page 158 is the reply. If your lordships kindly, Lord, permits me to place this. It says your prayer for LUDCP.
So this is 150.
Lord, there are 2 numbers, Lord, 125 and 158. Lord,
Let the printed number.
Oh, I see.
kindly go by the printed.
Yes, yes. Yes, yes.
Printed number.
125 যেটা এমনি হাতে লেখা 125 সেটা।
Printed number.
Wait.
Lord,
Yeah.
kindly see the subject, your prayer for LUDCP, this land use development control plan, clearance of your proposed residential project in RS Dag number so and so. Now, Lord, kindly come to the text of this letter. It says, with reference to your letter mentioned above, I would like to inform you that on scrutiny of the land details of your proposed residential project in Mauja Chhapna, it has been found that parts of your RS Dag number so and so in the said Mauja are included in the pending LA case number such and such and fall within the project area of HIDCO. However, RS Dag number such and such within the said Mauja are not acquired and are within the planning area of HIDCO. Under the circumstances, HIDCO may issue LUDCP clearance of your said project as per LUDCP of the new town planning area only for the land plots which are not involved in LA proposal of HIDCO and are located within new town planning area. So, Lord, they bifurcate 5 plot numbers as plots under the land acquisition proceedings, and the other 9 plots they said we are willing to give NOC. This really brought us to the court. Now, Lord, if your lordships, Lord, kindly come to page 195 just for 1 second. But this is the map of the area. Now, Lord, your lordships will find 37, 38 towards the bottom of the page, 37, 38, 45, 39 and 44. These are the plots which they say are under
38, 45.
Yes, Lord, 45,
39.
45 is on the right hand side.
Yes, and 39
and
44.
44. Lord, these are the 5 plots. 38, 37, 45, 39 and 44. So, Lord, the rest of the plots, they are willing to give NOC. This is the plots, they say that it is under land acquisition. Therefore, it is under planning area. The rest is under development area. We give you consent for the development area, not for the planning area.
Yes.
Now, Lord, just one document, because when we acquired this property, we had made certain due diligence. Now, Lord, please come to page 179, just one document. This is again, Lord, that printed mark. It says, with reference to the above, this is to inform that after verification of all available relevant file, it appears RS plot number 43, 44 of Chhapna Mauja, jail number 35, PS Rajarhat are involved in full and part out of so and so, respectively in LA case number such and such for new township project Rajarhat. But after publication of declaration under section 6 in the Calcutta Gazette on 13th of February 2009, the proceedings has been lapsed under the provisions as envisaged in LA Act 1894. This office did not receive any withdraw drop proposal from the requiring body till date. So, Lord, we proceeded on the basis to acquire the property that the proceedings have lapsed. This is the government stand. And your lordships will find that the letter was addressed to Special Officer Land HITCO.
Yes.
And it was forwarded to Somunath Das. It was under RTI that this was given to you. Now, Lord, the main controversy when we came to court,
yes,
was resolved, Lord, by various affidavits which came in. One was by the state, but that was handed over separately to your lordships. Lord, it was not part of the record. It's a report by Arnob Banerjee. Lord, has your lordship got? Lord, please come to paragraph 3. Lord, your lordships will find that these 5 plots, they say, was subject land was involved in the writ petition, RS plot number such and such, that the land needed to be taken by the government at the public expense for public purpose, that is New Town project, Rajarhat in Mauja such and such. The said purpose of the land acquisition, etc., was initiated involving subject plot number 39 and 43 in full and involving portions of subject RS plot number 37, 38, 44 along with other plots. Notification under section 4 was published. Then so and so the notification was published by exercising the power under subsection 4 of section 17.
4, 6 were complied with, but 9 could not be done.
That 9 could not be done. That is what they say. And paragraph 7 is the concluding paragraph, which my lords may kindly take note of. They say that possession was not taken. 2 facts revealed that possession was not taken. Section 9 stage was not reached. These are the 2 admissions that the state made. Now, the state is the authority for acquiring the property. Now, what happens? Lord, the HITCO also had filed an affidavit, which is at page 219. Paragraph 5 at 2220.
Yes.
Paragraph 5, if your lordships take at page 220, it is humbly submitted that the plots of land forming the subject matter of the writ petition situated in Chapna Moja are required for development of New Town project in Kolkata. Then please come to 7. The answering respondent is not fully aware of the exact steps which have been taken by the state authority with regard to acquisition of plot of land, and as such, it is humbly stated that the land acquisition collector, North 24 Parganas, is the competent authority to indicate to this honorable court the steps taken by it with regard to the acquisition of plots of land forming subject matter of the instant writ petition. Then paragraph 8, it is however stated that the plots of land forming subject matter of the instant writ petition fall within the planning area and is also included within the land use and development control plan and also falls within the relevant land use development. So they say that we have no knowledge as to what happened in the acquisition proceedings, and the collector, land acquisition collector, is the actual person. Now, Lord, I just take your
2 stands regarding acquisition. They don't know, and acquisition collector has said up to 6, so it must have lapsed basically. But 8, they take a different stand actually, somewhat different.
So they say that
planning area.
It is planning area because this is planning area because they are still saying that it is under that notification, that land acquisition notification.
Mr. Court, independently of there being any acquisition proceeding, this land should be available to all.
This
There is nothing called planning area separately within the contemplation of
Lord,
HITCO Act or something.
what is happening, Lord, my little understanding, correct me, Lord, if I'm wrong, what they're trying to say,
Yes.
that this is under a project.
Yes, their own project,
their
their
own
planning area. and
planning
something.
area.
Yes.
But this planning area can't be a planning area unless the state has acquired and handed it over to them.
And HITCO independently does not have any authority to over any land.
Nothing.
It's a housing sort of
Or
organization.
it's a developed. It's an authority
Yes.
under, Lord, the
Housing Infrastructure Development Corporation. So it
yes.
will help in housing infrastructure development.
And it is also a planning authority insofar as, Lord, Town and Country Planning Act is concerned.
Does the planning authority under that act have any
No.
authority of this sort to retain some land?
No, unless it is acquired.
That acquisition is
That is why, Lord, they go to the state,
right,
to acquire the property, and state's affidavit says that there was, Lord, a request
to
and
4/6.
up to 4/6. But the whole issue is they have no authority to usurp a property and hold it under any provision. That because that will be contrary to section 300 capital A of the Constitution, and you cannot take away a person's property
Yes.
without paying due compensation.
Right.
That is that the concept is very clear. Now, Lord, an argument, a very innovative argument, has been forwarded before your lordship based on section 17. So I straight away, my lord, take your lordships to section 17
Land
of the
acquisition
land
act.
acquisition. কি হবে স্টেট বলে দিয়েছে কেএমডি তো বলছে আমার প্রজেক্ট নয়
1894 যেটা
পাতলা হবে দেবে
আর এটাও দেবে
পাতলা পয়সা আরেকটা বই দিয়ে দে না ল্যান্ড অ্যাকুইজিশন অ্যাক্ট আরেকটা দিয়ে দে May I hand over, Lord? My learned friend has a spare copy. I'm sorry. আচ্ছা চল চল
করে 80% টাকা দিয়ে নিতে section 17 was never stated by them anywhere and they have to show payment that payment 80%.
Nothing. Now, Lord, only thing is that under the normal scheme, after section 4,
who was appearing for the state on the last occasion? The Banerjee was appearing.
No.
Banerjee is for the authority.
Means that they appeared, right? You don't have any place to sit.
Yes. We have, in fact, inflated.
You ousted the state.
They are the main person.
Yes.
Now, Lord, if your lordship looks at, Lord, at the scheme of the act, I just, Lord, I don't have to go through it. Section 4 is the initial notification intending to acquire property. Then comes section 5A, which is, Lord, the stage for hearing of objection. Then, Lord, section 6,
Yes.
which is, Lord, declaration that the land is required for public purpose. Then, Lord, comes through the various sections up to the section 9, which is notice to persons interested for, again, a hearing. So, Lord, there are two stages hearing, one at the stage of 4, then, Lord, at the stage after this publication of declaration under section 6. Then, Lord, it goes up to section 11, inquiry of the collector. And then, Lord, 11A is the period within which the award has to be published. Otherwise, it lapses. Now, Lord, 17 has a scheme on its own. So, Lord, section 17 here, the 4 notification has dispensed with section 17 subsection 4. The section 4 notification, your lordships will find, I'll just give your lordship the page. It is section 4 notification is at page 146. That dispenses with the that exercises power under section 17(4) and dispenses with the objection stage of 5A. Now, Lord, 17(4) is only, Lord, dispensing with the objection under section 5A and nothing more. And the other part of the scheme is contained in section 17.1 to 17.3a. But 17.4
section 16 হচ্ছে আপনি দেখুন section 16 একবার যান section 16 এ বলছে the power to take possession when the collector has made an award under section 11 he may take possession of the land. কিন্তু 17 এর ক্ষেত্রে exception এটা হচ্ছে সঙ্গে সঙ্গে ভেস্ট করে 17 মানে বলছে ওইভাবে যদি নেয় 80% দিয়ে তাহলে সঙ্গে সঙ্গে ভেস্ট করে 17 এ নিতে গেলে 17.4 এর এই রাইটটা আছে এই নোটিশটা দিতে হবে এটা অ্যাটলিস্ট 5 এ ডিসপেন্স করতে হবে. But here the admit possession was not taken also.
Possession not taken.
17.1 would not have been complied with.
Lord, if it
1, 3A.
1 to up to 3A,
Yes.
Lord, one has to pay 80% of
the
the
specific formulation.
formula. Absolutely.
There is no
Take possession, pay 80%, and then only you can exercise your right.
Yes.
Because then the Supreme Court's judgment comes into play that you have not only taken possession but paid 80%.
And
so
it vests then.
To vest. So therefore, only adjudication is with regard to the quantum of the award.
Yes.
It cannot, Lord, lapse. These are the judgments
Yes.
where, Lord, the proceedings were undertaken and possession was taken, 80% payment was made. Therefore, there is no question of lapsing. But here, it's only 17.4. 17.4 is dispensing with 5A. So one stage of objection is over. But then when you come to 6, you have to again follow 7, 8, 9, 10, 11, you go up to 11. So 17.4 is nothing. You just do away with one objection stage and come to the next objection stage under section 9. And it is an admitted case that neither the objection stage had reached up to 9, nor the possession was taken.
Under 17.1 they had to take possession within that period after the section 9 notice.
Yes. They had to not to possession and Lord 80%. These are the two preconditions. Otherwise, Lord, there is no question of not lapsing. So, Lord, all the judgments which were cited, Lord, this was the main issue, that 17.1 followed by 80%. Now, Lord, if this has been clarified in one judgment that I have cited, which is, Lord, SCC Online 2022, Lord, I just give your Lordship. Yes, this is, I think, Lord, it is in your Lordship's file, 2022 SCC Online SC 1408.
Not in this compilation.
Not in the compilation. I had separately handed over. I think it was in the compilation. I stand corrected.
It's there at
Yes.
page
There in the
383.
compilation.
Yes, yes,
Page
yes, yes.
383.
I stand corrected. Lord, I just request your Lordships to kindly come to paragraph 27.
Lord, may I have your Lordship's leave? Lord?
Yes, yes, yes.
My senior than my lord.
No, I'm
In the same matter, but yes,
I'll come back.
yes.
paragraph 27, Lord, if your Lordships kindly see, there is, that's the conclusion. I'm not troubling your Lordship with the other paragraphs.
Yes, 27.
It says, in the result, we pass the following order. The provisions contained in section 11A of the Act of 1894 shall be applicable to cases in which the acquiring authority has not complied with the requirement of subsection 3A to section 17 of the Act of 1894 by tendering and paying 80% of the estimated compensation before taking possession, since possession in such cases cannot be considered to be taken in accordance with law and the vesting is not absolute. If the requirement is complied and possession is taken after tendering and paying 80%, though there is need to pass an award and pay the balance compensation within a reasonable time, the rigors of section 11A of the Act of 1894 will not apply so as to render the entire proceedings for acquisition to lapse in the existing context of absolute vesting. The right of land losers in such a case is to enforce passing of the award and recover the compensation. So, my lord, today the situation is that admittedly 11.1 to 11.3a has not been complied with. That is the stand of the state. So, my lord, there is no question of the proceedings not lapsing. And my lord, the other point that is taken, that I am a post-vesting purchaser, that is also a frivolous point. Because, my lord, if there is no vesting, the rights remain unfettered of the original owners. And, my lord, the third point I took, that, my lord, this appeal is not maintainable for the simple reason that the stand of the authority who is appellant before your lordship is contrary to the stand of the state. Because when the state says that no possession is taken, no section 9 has not been complied with, compliance of section 17.1 to 3.8 does not arise at all, because state itself is conceding to that point. So, my lord, when state says that there is no acquisition, Lord, the authority can't, Lord, hold on to the land and say that I will not give you no NOC. And that is precisely what the learned trial judge has directed. Trial judge has directed to give NOC in respect of these 5 plots. This is, Lord, in short, what the relief that the learned trial judge has given. These are my humble submissions.
Yes, Mr. Basu, Mr. Sen in reply.
But as Mr. Basu had indicated, our base point was that maintainability. My lord had last day indicated also whether in the writ petition was at all liable to be heard. It is not a question of whether the vesting is there or not. That is not the question. Whether the vesting, the existence of the vesting or the lapsing of the vesting, whether it can be challenged in the writ, whether they could have taken that opportunity, that window, my lord had told.
Why not? Just remind us.
My lord, because the 2 judgments that were shown that post-vesting transfer.
No, if there is no vesting, there is no post-vesting thing.
Yes, but that opportunity cannot be taken. That there is no.
Provided there is a vesting, to ascertain whether this is a post-vesting transfer,
yes,
you have to see whether there was a vesting in the first place.
Yes.
If there is no vesting, there cannot be any question of vesting. For that limited purpose, you have to look into whether there is any vesting or not. To ascertain whether they are post-vesting transfers. Yes. Well, otherwise, it will be a circular logic. Yes. We shut them out saying that they are post-vesting and don't look into the post-vesting. For that purpose, we had to look into vesting, and we see that the state stand is very contrary.
One thing, my lord, that they are saying that they are post-vesting, they have got a proper title to that, but the title deeds have never been disclosed. But that is one point which has been totally overlooked. They
take this point in the first argument.
Could
have made that. This was never argued. But isn't that an admitted position that their post-vesting transferees means they are transferees?
Page 158, Lord, proceeds on that basis. They have never questioned
That
Lord,
has
our
never
title.
been questioned.
They are only saying that we will not give it because it is in the planning area. That's all.
By saying that, you are virtually admitting the text.
And their NOC is they are agreeable to give.
Because your 2 points will be contradictory. You cannot say post-vesting transferee and no transferee.
No, my lord, we are saying that they have not come before the my lord.
The point that they are post-vesting transferee, you have to say that they are transferees. You have to admit that's inbuilt in post-vesting transferee, that expression. And then in the same breath, you cannot say there are no transferees at all. That's a different line of argument.
No, we did not say that they were not a transfer. We are saying that they were not disclosing their, for some reason.
Not because the evidence is sufficient to show that all of you proceeded on the premise that they are transferees. And you even agreed to permit development on some of the plots.
Those were, I believe, the plots which are situated.
Yes, but then they must have purchased the entire thing by the same sale deed. You never took that point in your that. What was the page number, Mr. Corporate, which you first showed us?
158.
158.
Page 158. Yes. Lord, our porcha and everything is there in the.
That is what, which is very strange. They have given the porchas and everything, but the title.
If they want, we can produce it before them. What's the difficulty? They have, for the purpose of giving NOC, if they want to see the title deeds, they are most welcome.
You never took that point in any of your communications.
No.
Which have been annexed here.
Lapse नहीं तो
Even before the appellate court, writ court, did you take that point? That they're not transferred is probably not taken. Not taken. For the first time in the appeal, probably you are not permitted.
In the affidavit that they filed, they never took this point. There is
Never. Before the writ court also, they did not take.
Did they
And
never
they're
took?
not saying that they have taken. In all fairness. I mean. Very well. So anything else?
May I
So you
just
have already
request,
made
my
your
lord,
argument.
let Mr. Basu come back, my lord. Kindly keeps it at 2 p.m.
Mr. Aritra Basu?
Yes.
It will be a truncated hearing, then these are part-heard matters, we'll conclude arguments. If he had to say anything further, he would have told you. He was here for so long. So you can file a written notes of arguments on this also short written notes. Because we have heard your arguments. You have filed your written notes. Mr. Kaur, very short 3 points basically. So file very short.
Will you file it by Monday?
Monday. We'll keep it on Monday, as to mention. Oral hearing is concluded. Practically neutral role here. And you have taken, state has taken its stand by the affidavit. Yes, you have given them.
They say it's not within their planning area or
Exactly.
they have neither acquired the property nor there is any plan so far as they are concerned.
Oral arguments are concluded, full stop. The matter be listed on November 17, 2025 under the heading to be mentioned for the purpose of filing of written notes of arguments by the writ petitioners stroke respondents.
Much appreciated.
Five and six, my lord, I have two leaders who are both on the way. May I assist, my lord, in the meantime, my lord?
You had to argue. They have completed.
My lord, before the previous bench, my lord, hearing was concluded insofar as the appellants were concerned. This is section 37
Mr.
appeal.
Shuman Datta, yes.
Yes, Mr. Dutt had already concluded his submissions. We were
Remind us.
Yes. Sir will recall this is really a dispute. This is a section 37 appeal. First and foremost, the award has been upheld. The appellants before my lord are award debtors. The award is on the basis of a factual or rather a contractual dispute where under OMDC, who's the appellant before my lord, had contracted with my client to supply coal. OMDC was to supply coal. They had a particular stipulated.
Oh, yes, that.
Yes. I will recall that 3 grounds of, I'll just indicate the broad background. Yes. This is a factual background. I'm just indicating. Yes. Contract entered into between OMDC, the supplier, with me, the purchaser of coal. Terms and stipulations there in the contract, which required me to make payment of the amounts that I required per month. The amount, the price of the coal.
$500,000.
Yes.
নোট দিলে আমাদের শেষ হয়নি 2 years তুই তো টাইম নিয়ে শেষ করছিস শেষও করছো এরকম বলবে এরকম বলবে শেষ করো Yes, please continue.
Yes, ma'am. Here there was a contract entered into between OMDC and my client for supply of coal. That contract had several stipulations. They were to supply a certain quantity of coal to me per month. Now, we provided them whatever payments were made. Certain supplies were made for about 2 or 3 months and all, with no disputes between the parties. Thereafter, my lord, supplies were stopped. OMDC claimed that we had committed breach of contract, though there is no contemporaneous correspondence or no contemporaneous objection in that regard from OMDC. We write to them on several occasions, and those are all exhibits which were before the learned arbitrator. We request them to make the supplies as per the contract. They fail to do so. Eventually, there's a refusal really to perform around the end of the contract. Towards the end of the contract, we also make them advance payment of the entire consideration amount, which is a condition of the contract which they had waived. And this is a finding of the tribunal. This is a condition of the contract of prepayment, which was waived by OMDC during the course of the contractual term.
Waived in the sense that they had
By-
supplied to you
yes.
without compliance.
Yes.
For a particular period, which Mr. Dutt says, a limited period not giving you the coal does not mean a waiver of the terms of the contract.
That
They
is
also say that the advances you paid were post-dated checks.
that advance is the last. That is the
That
last.
was also not a
that is
good
the-
payment because it was post-dated.
Yes, but Mullah, these are all first and foremost as a preliminary point, Mullah. This is Section 37 appeal. Mullah, factual disputes are one thing, perhaps even in the pre-2015 Amendment Act, Mullah, it is a very limited scope. We are two forum away from the factual dispute which was arisen.
Yes.
The arbitrator has considered all the evidence, and the arbitrator, most importantly, Mullah, of course, the conduct which Mr. Dutt has tried to rely upon is from the documentary evidence before the arbitrator. But another crucial aspect of this matter is the deposition. There is a categoric finding of the arbitrator that the respondent's witness in the box has taken a stand which is completely contradictory to the stand taken in the documents.
What was the stand taken?
The stand taken in the box was we had stopped supply. I'll show there's a finding also to that effect that we had stopped supplies to the claimant because there were certain balance dues for prior dues for prior supplies. This is a specific stand taken on a question asked in the box. And the arbitrator comes to a specific finding that this is a contradictory stand, especially
What is it in contradiction with?
Contradiction with their stand on the documents, the letters which Mr. Dutt had placed. The stand of the respondent was that we had to participate. There's a pre-requirement of participation in a
You have
tender
to ask
process.
for it and pay for it.
Apart from that, no, Malad, the letter that is issued by OMDC, where
Participate in the sense?
participate in the tender. Malad, one of the contentions of the respondent was that for us to get any supply of coal under this contract, we had to participate in the public tenders floated by OMDC. That was one of the main stands, and that is rather the only stand that is taken on paper in the contemporaneous correspondence between OMDC and us. So, Malad, that stand is completely derogated from, rather contradicted in the
How
box.
does the arbitrator deal with that? That you had to participate in a.
It's Malad, the arbitrator has come to a finding that these two conditions, two stands taken. Number one is participation in tender. Number two is prepayment of the consideration for the coal. Arbitrator holds that both these conditions were waived and derogated from the conduct of the respondent. And also the arbitrator takes into account the fact that the respondent in the box, because or else the point of oral evidence will be nullified. Then we need not go into trial. Let us go on the basis of documents and have it adjudicated on the basis of documents alone. But the evidence specifically shows, the oral evidence, the arbitrator notes.
Be cautious, you're on the bull's eye.
Hello. Oh, yes. Hello. So this is specifically the case.
So yes,
this is the case that we are trying to make out before Muller, that today this is an appeal arising out of the dismissal of a section 34. If an arbitrator has arrived at a factual finding considering the evidence on record, perhaps Muller, it is not Muller.
Section 34 also upheld your arguments.
Yes. The Section 34 upheld the award, which was one of the grounds taken by Mr. Dutt. The Section 34 order is really a replication of the arbitral award, and it is on that basis that the Section 34. That is one of the grounds. We'll meet that, Mullah. We'll deal with that when it comes to that, Mullah. Mullah, here, this was Mr. Shah was leading me. Mr. Shah was placing the award because that is really the most important tool in our arsenal, at least for the respondent, because the award is perfectly well reasoned. It deals with every single objection.
It is the reason we cannot reappreciate, we cannot reappreciate, particularly in section 37.
Yes,
34 even we could not.
Yes, and it is not open to Mullah with the deepest of humility to
this is not a regular appeal.
Yes, yes. So Mullah, the award was being placed. May I just again quickly summarize
Unless
the
the reason is absurd or
of course
defies the conscience of a prudent man,
of course
we have to avoid by that.
Of course. So on the basis of this, the arbitrator comes to 3 findings. I'll just indicate that and take Mullah to the findings. I'll just summarize what the arbitrators find. Number one, that there has been waiver of these conditions that the respondent seeks to rely upon in defense of the non-supply, admitted non-supply. There is no dispute as to non-supply. Whether that non-supply is justified or not is the question before the
You
arbitrator.
did not participate in tender.
I
You
did
did not apply specifically for those schools because that minimum requirement
Yes,
that argument
yes,
was made,
yes. I
and you
did
did
not.
not pay.
I
But
did
they
not
still
pay.
supplied, therefore waiver.
Yes.
And they
waiver.
supplied for some months,
Yes,
not
several
one
months,
time.
several months, several tranches of coal were
That
supplied.
is one aspect. What is the other? Next complaint.
The other, my lord, comes to the question whether the respondent has committed breach of the obligation, which is really tied with the first issue. The arbitrator finds, or other arbitral tribunal finds, that the respondent has committed breach because there was still an obligation on the respondent to supply, and there is no dispute as to our, or rather no objection raised as to our breach or our non-performance of obligations. So on this ground, the arbitral tribunal finds that the respondent has breached their contract. So now the question comes to damages. The arbitrator has before it 3 claims that has been put forward by my client. One of them was on inferior quality of coal that was supplied by the respondent. We lose on that. We lose on that claim. We don't get any money. The remaining 2 claims are: number one, balance price. Because in the meantime, when the respondent, or rather the appellant, I'm sorry, when the appellant refused to supply us with the coal, we were forced, because there's correspondence to that effect as well. We're writing to them saying that our plant requires this coal to function.
Take from other persons.
We had
Other
purchased from third parties. In effect, substituted performance under the Specific Relief Act that is now incorporated.
Balance was awarded to you.
Balance price, only the balance price. So if I had purchased for, let's say, rate X, or I'm sorry, if I had purchased for X plus 100 and the rate agreed to be supplied by OMDC was X, I was awarded 100. That is one. Second point is loss of profits, because we had also placed before the arbitrator purchase orders for manufactured goods. We are manufacturers. We need this coal for our manufacturing.
But if you got it from the others, how could that be granted?
No, Malad, loss of profit was on, Malad, firstly, balance price of goods is on the basis of supplies of the raw material. Coal is the raw material I use to manufacture processed goods.
Oh, so you could not manufacture this?
Yes, yes.
But if you got it from others,
yes,
how can you get
there was
substituted price as well as that?
There was delay. It took me time. I had written to them, they had not performed. Therefore, there was delay for this, and we had placed these documents on record. There was insufficient cross-examination by the respondent, or rather the appellant herein. Therefore, on that basis, the arbitrator arrives at a reasonable, because this is a quantification of loss that is difficult to prove in evidence by every penny.
Estimate.
Malad, going back to 80 Bridgepal again, 15%, arbitrator goes and holds specifically 15%, which is supported by the judgment of the Honorable Supreme Court itself. 15% on the purchase orders, the manufactured goods. We had placed certain purchase orders which we had failed to supply. We had produced that. Arbitrator awards us that 15%, that is a profit margin on those particular purchase orders which we had failed to produce. This is the award. On this basis, Malad, we were successful in the 34, and now we are before Malad. Malad, may I quickly go to the award, Malad? Part 1 of the paper book, if Malad kindly takes. I'll just recap, Malad. I hope I'm told is on it. I'm sorry.
Yes.
Yes. 9:39. 9:30. Well, we're on 9:39 today. And Malad, one thing I'll just indicate before I take Malad to the award.
9:39 is with us.
Yes.
There are two. Why the other one?
941, Malad, we haven't commenced our arguments there. 941 is the other matter relating to a similar contract, similar facts and circumstances. But there's one difficulty, Malad. Even the exhibits before the arbitrator are perhaps not on record in the paper books in 941. I'm not saying anything.
So, what is the distinction between the two? Why separate agreements?
No, they're separate. This was for prior period. 941 was for
periods.
Yes. Similar agreements entered into 2 separate contracts. 2 separate contracts.
But what is the distinction between the two?
That was in 2003. This is 2000.
No, a different specification of iron ore, my lord.
Yes, also. Yes.
That is the main.
In arguments, what will be the difference?
Arguments, my lord, we
You did not address that.
Yes, ma'am, we addressed it.
They had addressed both.
Very short. Yes, is
the award is identical. The contract is different for different period, but the award is identical, my lord.
So your arguments are identical.
Identical, yes, ma'am. That is correct.
Our arguments for 939, whatever is there, at least documentary evidence is there for whatever. 941, my lord, I had.
You're on a worse footing.
My lord.
You're on a worse footing.
Yes. for we, in the sense the advocates are on a worse footing because the original arbitral records are lost in our advocates' office as well.
I mean, those are
Advocates,
produced
not
before the tribunal.
yes. So there 941, that is the one problem that we are practically facing.
Arguments will be the same.
No,
If
my
the
lord.
award considers the
Yes,
evidence,
my lord.
we'll
But the
proceed on that
documentary evidence is also not on record. In 941, the documentary evidence as to that prior period contract are not on
cannot give
record.
you further time for that.
I'm
Before
not
hearing,
seeking.
so you have
That's
to,
why, my lord, I'm not
the
seeking.
arguments are otherwise the same, make it.
Yes, we'll go ahead with the award, whatever is there in
The award says if there's a document, will let us proceed on that presumption that
my
there
lord.
is.
That's why we are not seeking any further time, my lord. I'm just indicating this. That's all. My lord, will kindly take.
We are hearing you together on both then.
My lord, for today, my lord, I'm addressing 939. I'll conclude, my lord. We'll try to conclude 939.
Again, you start re-arguments on
No,
the same thing.
No, 941 won't take us much time because as it is, there's
With additional points you will.
there is no. I don't
Additional
believe
point.
there won't be many additional points. No, the award will have.
That is our precise point before you. There is no additional point why segregate the arguments.
No, the award is not identical. It is not identical. It's on that.
Spellings are different.
The findings.
What is different?
Well,
Both contracts between similar contracts.
Well, I have a leader.
Clauses may be different, numbers may be different.
Yes.
Anyway, whatever.
Yes. My lord, let me place 939. 941 will come to it, my lord. We'll definitely address, my lord. We won't seek time. Page 64 onwards is the award, my lord. Kindly takes page 64 onwards of part 1. It's been heard together, my lord. I'm not disputing this.
No, who was leading you?
My lord, Mr. Jishnu Shah was leading me. He had argued at length. Mr. Jishnu Shah and Mr. Shorojit Dasgupta is also leading me. Both of them are on legs, my lord. They'll arrive thereafter.
Yes, which page?
Page 64, my lord. Page 64 onwards is the award. My lord will kindly, I won't take, my lord, through all the submissions.
আপনারটা আমার কাছে চলে এসেছে না না এই দুটো আলাদা আলাদা পেয়েছেন
ঠিক আছে
64 থেকে আবার
kindly directly come, so I won't place the entire.
No, don't.
My lord, kindly directly, I'm just indicating page.
You read your relevant paragraph because they have already placed the order.
Yes. Well, at page 83 to 89, the issue on defective supply, defective quality is addressed, which we lose. My lord, page 89
So
is.
let us not waste time on that.
Yes, my lord. Yes, my lord. My lord, 89 onwards is, my lord, the question of. I also skip that, in fact, my lord. Let us come to the findings specifically on the objections of the respondent. My lord, page 97, my lord. You kindly directly come to.
Yes, best.
My lord, 96 first, my lord.
96, para 56.
56.
Right.
Mr. Shah, please. Lord, may I just quickly just.
So this is the waiver on the premise of the
100%
previous.
advance payment point. So this is the finding of the arbitrator. May I just quickly place, my lord,
Do it.
If we consider this point first as to whether 100% advance payment was really a condition precedent for the supply of goods, we have to go back to the period between March 2004 when the agreement was made and the month of June 2004 when the last supply was made to the respondent. In response to the submission of the respondent about 100% advance payment, it was contended by learned counsel appearing for the claimant that as a matter of fact, the respondent had never given any importance to this particular term of the contract and had relaxed the same by supplying the material up to the month of June 2004 without 100% advance payment demanded of or made by the claimant. According to the claimant, the clause of 100% advance payment as contained in the agreement in question had been waived by the respondent, and accordingly the respondent cannot take shelter of the 100% advance payment. So and so. Page para 57 is the most important paragraph in this regard. If we now assess the factual position during the period between the date of the agreement up to June 2004, we find that the respondent had supplied goods in April, May, June 2004 of different quantities at the agreed price of 1915 per metric ton, which were lifted by the claimant. It further appears that neither the claimant had made any 100% advance payment towards the price of the said goods as to the respondent, nor the respondent had insisted on payment of the same prior to actual delivery of the same. It is also a matter of record that towards the price of the goods supplied by the respondent during this period, i.e. April to June 2004, the claimant had made part and or ad hoc payment by checks. Well, we'll kindly note by checks. So this is also a relevant fact because lastly we tried to make payment by checks which they returned.
This is the mode of payment you have been receiving.
Yes. So this is the accepted mode of payment. Were received and encashed by the respondent without raising any objection. 58. From the aforesaid, it can be inferred that the respondent was in fact not serious about enforcing the 100% advance payment clause as contained in the agreement as a condition precedent for supply of the said goods. Had it been so, the respondent would not have supplied the goods without receiving advance payment. Thereafter, my lord, it's recording all
There is
the
a
evidence.
qualitative difference, Mr. Mukhopadhyay, between not being serious and a waiver. Waiver has to be a conscious relinquishment of a right.
My lord.
There is a positive element to that.
Lord,
And I'm relinquishing my right.
Lord, we kindly appreciate one thing.
Not serious is something I may not be serious for a time, then I may become serious and
My
it does not suit me.
My lord. That is, my lord, the
But that too, you say, even if it's qualitative, it's an assessment by the tribunal, which we should not interfere.
Yes, my lord. And thereafter the evidence is recorded. My lord, kindly see para 59 onwards.
That
I can take
cross-examination, yes.
everything is recorded.
Yes,
I
that
can,
PW.
yes, everything is recorded. I can take, my lord, through the entire thing. I don't want to take up so much.
This reflects his correct.
My lord, it's specifically taken all the questions, my lord, are.
Yes, in those question numbers are given and
Yes, ma'am.
mutually waived was the specific.
Yes,
statement.
specifically.
That was placed also, probably.
Yes, my lord. Page 80. No, no, only
Please give us a page number of this these questions. 157.
That is not there. It is not on record.
This matter it is there.
No, it is not there. Not only the documentary evidence is on record, the entire deposition which Mr. Shah really wanted to rely upon.
What happened?
It's not there. It's not been
It was
made
there
part of.
before the 34 court.
We believe so, my lord. This was before the court at Barashat. We had applied for certified copies there as well. My advocate on record went specifically to Barashat court, my lord, to seek out the records. Apparently, they're all missing. And apparently, my lord, also my advocate's records office also does not have the original arbitral records. I also spoke to my learned senior friend as to whether
So
that
they
is
said
available.
that candidly that they
It's not there. So really, we are in a quandary to that effect, at least, my lord.
Better to proceed on this then.
Yes, my lord. We've tried, my lord. We also made a prayer. Mr. Shah had made a prayer if a direction could be made to the Barashat court, but that will take substantially more time. I appreciate, my lord. I'm not saying anything on that. My lord, we kindly see the
Your resources are more powerful than court's direction.
Uh,
In arbitration matters, at least that's our common experience. These sort of arbitration.
Yes.
Not arbitrations between
probably this
citizen
exception.
and a financial company, no. But in these cases,
this is the exception that proves
they are
the
much more powerful than you or us. Yes, anyways.
Para 61 is the finding to that effect. Kindly, may I please this? The entire evidence is recorded. Para 61, my lord, the arbitrator comes to the finding, page 101.
Yes.
Therefore, from the evidence available on record and from the oral evidence of the witnesses of the respective parties, it is apparent that although a clause for advance payment was incorporated in the agreement, as a matter of fact, the parties had not followed the said term and rather waived the same by not specifically enforcing the 100% advance payment clause. If the said clause being 100% advance payment was a condition precedent, the respondent could not and ought not to have supplied 8 rakes of goods. That's a substantial quantity of coal. 8 rakes of goods in the span of 3 months from April to June 2004 without 100% advance payment of the same. Rather, the respondent had not only allowed the claimant to take delivery, it should be delivery of the goods without payment of 100% advance payment, but also unconditionally accepted part payment. I'm sorry, unconditionally accepted part payment and or ad hoc payment towards price of goods of the goods supplied.
Don't look so helpless, Mr.
No. My lord.
Please give.
My lord, now, in this regard, my lord's query fell, my lord, as to whether a waiver or rather non-adherence or non-insistence.
Lack of seriousness is the term.
Lack of seriousness. Thereafter, relaxation also. We are on relaxation.
Relaxation is a
of the term.
positive assertion of something.
Yes,
but
my
you are saying they accepted no contemporaneous objection.
Yes.
So that is
And
on
they
a higher
accepted payment. Correct, my lord. My lord, for example, if I may draw an analogy with it, if a contract stipulates time is the essence, section 55. If, my lord, today I accept performance post that stipulated time, well, that's settled law that is waiver. Even one small act of acceptance of performance is waiver of the entirety of the clause as to time.
There's a subtle difference between the two, Mr. Mukhopadhyay. We are clarifying what is playing in our minds. In case of a time stipulation being not the essence of a contract, time stipulation is a one-time thing. It has to be finished, say, within 3 months. That is not it. Once it is waived, it has to be waived only once. If you accept something after that, so it's a one-time thing. But this clause, this is an every-time thing, meaning thereby that every time you take the delivery, you have to pay advance. So one single instance, or say 5 single instances, because an analogy, a very rough analogy, can be drawn from the Premises Tenancy Act, because I always, it's a Guru Rachana for civil people like me. So it's so therefore in those cases, even if the landlord accepts some of the payments after the date, but that's not by itself waiver. So it's like that, because this is a regular payment which is being contemplated. This is the basic difference between that stipulation the analogy and this. That has to be done only one time. That 3 months is over, you accept, waived. But here you have to waive it every time. That is being taken advantage of by Mr. Dutt when he says that no, a few times does not mean for the entirety the clause is waived. But then even that's a qualitative assessment of the evidence, and one plausible view you can say was taken.
Today, the Supreme Court says not even a plausible, a possible view. That is the term used. Possible view.
Possible. Because when you say plausible, then also my thought comes in.
There's a prima facie, some sort of a prima facie assessment.
This court's thoughts, what is plausible, what is not.
Yes, that perhaps
an impossible view. In other words, if an impossible absurd view is not taken.
My lord. Well, that is the test that has to be met today.
Yes, because it's on a higher footing than a regular 96 appeal. Section
Yes, and we've been successful before a trial court. So the scope is even more constricted.
Yes, section 34 stage is also.
This is even stage even more constricted. That is the point that, of course, that's the point of law that is generally that we will argue.
Okay.
But on facts also, my lord, as to facts.
So every time you have to think about that, you have to keep that in the back of your mind when you look into this.
But also on fact, just to satisfy my lord's conscience, despite whether my lord will go into it, as a matter of fact, this is not mere my lord, submissive acceptance of rent. This is also performance by supplying. I supply. This is a positive act, number one. Number two, contemporaneously. Yes, সেটাই আমি পুরোটা and also number two, the advance checks that we sent towards the end of the contract, which were refused finally. The point that is taken in the reply to that letter is not that, sorry, I will not supply because you have not complied with this term prior. The point that is taken is non-participation in the tender. And that, my lord, evidently that has also been waived. Hello. May I just continue, please? Para 61. Rather, the respondent had not only allowed the claimant to take delivery of the goods without payment of 100%, but unconditionally accepted part payment ad hoc payments towards price of goods supplied. It is also significant to note that until December 24, 2004, there was no whisper on the part of the respondent with regard to 100% advance for future supply, although records show that the claimant continuously made demand, kindly note, continuously made demands for supply of goods. We shall refer to these demand letters at a subsequent stage. Waiver of 100% advance payment also appears from the conduct of the respondent, inasmuch as the respondent allowed the claimant to take delivery of the goods in 8 rakes without any demand and without receipt. Had it been only one supply, though through one rake without 100% advance payment, then it could have been presumed and or considered that the respondent had allowed such solitary supply as a special consideration. But it was continual supply without 100% payment, and therefore it cannot be construed as that the respondent was not serious in enforcing its rights under the agreement. Insofar as payment of the 100% advance is concerned, the respondent uncomplainingly continued with such supply against the ad hoc payment, but not the 100% advance payment. Therefore, the contention of the claimant can be accepted without any hesitation that the parties did not agree to enforce the 100% advance clause as contained in the said agreement, being clause 5C. In this connection, another point is also significant, that the respondent had raised 8 several bills against 8 several supplies. This itself shows that it was a sale of goods under the normal term that after supplies, bills would be raised and payment to be made in accordance with the bills. Therefore, it cannot be accepted that no supply was made as 100% advance payment was not paid by the claimant. We therefore do not accept the contention of the respondent that the claimant had committed breach in terms of 5C of the said agreement by not paying 100% advance payment, and accordingly the plea is rejected. Thereafter, my lord, this is continued. So, my lord, the arbitrator also knows the general law. The general law provides that normally in a contract for supply of goods, I'm sorry, for supply of goods, my lord, the bill is raised and thereafter payment is made after supply, post supply. That is also noted by the learned tribunal, and on that basis, my lord, the award is passed. My lord, thereafter, on this, my lord, 5C is dealt with. My lord, I am not placing any further. The entirety after this also, my lord, the evidence is recorded. Para 64 also, my lord, can kindly note. I am not placing the entire thing. May I please para 64, my lord, for my own satisfaction?
Yes, yes.
Yes, ma'am. Another significant point with regard to the alleged non-payment of 100% advance is that in spite of the payment of a total sum of 3 crores by the claimant on 28 December 2004 and 5th January 2005, the respondent did not supply goods covered under the said total sum of rupees 3 crores. In this connection, the tribunal asked the learned counsel for the respondent to clarify with regard the contents of the letter dated 29th March 2005 and non-delivery of the goods against the check of rupees 3 crores. Mr. Sen, in his argument recorded in the 54th meeting dated 29 July 2009, fairly admitted that this letter at page 91 of the brief of documents does not refer about 100% advance payment as a ground for non-supply. It has been further fairly admitted by the learned counsel for the respondent that the said meeting that the claimant was entitled to receive the supply of material against payment of rupees 3 crores made by the check, which was returned on 29th March 2005, an admission made from the bar, recorded, not disputed even in this appeal. I would have been entitled, my lord, perhaps to a judgment on admission on this ground alone. Admission of counsel, my lord, is good enough so long as it's not disputed or it is not made without authority. So here will kindly, what I was saying as to the only contemporaneous document, it does not, arbitrator records specifically that it does not talk about the 100% payment clause. Only point is it is the only point raised is non-participation in tender and non-availability of the goods. Well, thereafter, para 65 onwards, again, my lord, the evidence is recorded, the questions are specifically recorded of the respondent's witness, my lord, specifically recorded what has been done. My lord, para 66 is also relevant, my lord, insofar as this point is concerned. May I just place last, this is the last paragraph on this aspect. Therefore, even if we assume that the 100% advance payment was a condition precedent for supply, nevertheless, it appears that the respondent, even after receiving an advance amount of rupees 3 crores, respondent did not supply the said goods. Therefore, undoubtedly, a breach was committed by the respondent towards the claimant by not supplying the goods. So, Muller, a finding as to breach. Although the check was returned on 29th March 2005, 2 days before the expiry of the contract, no explanation has been given by the respondent as to why the supply was not made against the amount of money already paid in advance by the claimant. Therefore, the respondent in any event ought to have supplied quantities of goods worth 3 crores, which the claimant could have utilized for its manufacturing process. Not having done so, obviously, the respondent had not fulfilled its obligations under the contract and thereby has committed breach of the same. This concludes, my lord, 100% advance.
Yes. We'll continue from the next point after we come back. Yes.
I was starting.
Oh, which has come, yes.
Yes, my lord. If my lord grants me,
I'm sorry, my lord. No, no,
if my lord
yes.
grants me leave, my lord. No, if
Whatever, yes.
I'll try not to repeat, my lord. if I am repeating anything, please, my
No,
lord.
no. Mr. Mukhopadhyay must have told you what is.
My lord, I think, my lord, one of the queries that fell from the bench, as I was being, my lord, told by my learned junior, is, my lord, with regard to waiver of my lord's supply. Now, my lord, so far as that is concerned, the relevant contractual provision, my lord, says may, my lord, supply 7 metric tons per month. Now, my lord, this is the distinction between, my lord, the two separate awards, my lord, because one is, my lord, 939, one is 941 or something like that. My lord, now, my lord, the question is whether 7 metric tons means that if you do not lift the supply within that month, then you waive the right. My lord, that becomes important. Now, my lord, this has to be viewed in the conspectus of, my lord, two things. One is, my lord, the agreement itself records, my lord, my need for a continuous supply. And secondly, my lord, the facts of the case record that, my lord, ultimately, my lord, there was a dispute with regard to supply of substandard goods. And, my lord, we were waiting for that dispute to be resolved. So, my lord, when, my lord, there are substandard goods supplied, and, my lord, an issue has been raised in this regard, then, my lord, the question of accepting further supplies during that period till the resolution of that issue, my lord, did not arise. Ultimately, that issue was also raised, my lord, before the tribunal. The tribunal did not accept my plea of substandard goods. He said, no, I don't find that there's sufficient proof or evidence of the goods being substandard, or that you have consumed a portion of the goods. Why did you do so? So, my lord, here, my lord, with the greatest respect, it is not, my lord, something that, my lord, will appear from the contract that, my lord, if you do not lift goods for a particular month, your right to lift goods for that month ceases, or, my lord, is forfeited. And, my lord, very, very importantly, that is not a point taken in the pleadings. Well, I'll show your lordship, my lord, one thing very, my lord, relevant to this in this regard. My lord, when we said that, my lord, we had called upon the respondent to supply, there's a bare denial, my lord, in the counter statement. My lord, when we said that, my lord, lifting during the months of April, May, and June 2024, my lord, was done, and thereafter, my lord, there was failure to supply after June 2004. My lord, the answer is no request made and defaults in payment. So, my lord, they have not said that you have forfeited your right because you have not taken supply during the particular month. Well, I'll just read out, my lord, the relevant portion, my lord, here. My lord, this is, my lord, my contention, my lord, in the statement of claim, paragraph 18. After the month of June 2004, the respondent failed or neglected to supply any iron ore under the Memorandum of Understanding dated 11th March 2004. And, my lord, this is how it is dealt with. In paragraph 9 of, my lord, the counter statement, it says, with reference to paragraph 18 of the statement of claim, the respondent states that after June 2004, no request was made for effecting any supply, inasmuch as there had been large-scale defaults in making payments. So, my lord, these are the two grounds canvassed. My lord, there is no ground, my lord, really taken in the pleadings that, my lord, if you do not accept supply for a particular month, you cannot carry over that for the next month. So, my lord, that is not really a point that was taken or really urged before the tribunal.
But if it's a monthly arrangement, Mr. Shah, how does it carry over?
No.
It's not for a period, for the entire period.
No,
per month you have to lift so much, they have to give you
Yes,
that.
yes, my lord. Now, my lord, today I could not lift, my lord, not because, my lord, I chose not to lift.
Whatever may be the reason, but if you don't lift for a month, then it's a monthly arrangement.
Well, this is, my lord, with the greatest respect, my lord, one has to understand the contract in its true essence. Now, my lord, I'm not saying that your lordship should disregard the 7 metric tons per month provision.
But then also it's a question of interpretation, which is the domain of the arbitration.
Not only that, my lord, the interpretation would have to follow, my lord, a canvassing of that point by, my lord, the party.
Definitely, yes.
My lord, they have not canvassed this in their pleading, that it is a monthly supply. And, my lord, if it is a monthly supply and if you've not taken supply for the particular month, you have no right to that supply in the subsequent
But it's
months.
your claim, Mr. Shaha, and doesn't the document speak for itself? I mean, the document is there, you rely on the document and you say, I have this right, they have breached this right.
Yes, my lord. My lord, I have said, my lord, you have not made any supplies for the months from June 2004 onwards. Their answer is twofold. You have not asked for supplies and, my lord, you have defaulted in payment. My lord, which means that, my lord, they have later also said.
There's a tacit acceptance that you have a right to.
Yes, my lord, with the
you have not asked and not made the payment. If you had asked and made the payments, we would have given.
Well, ultimately, my lord, we are all, my lord, aware of, my lord, the doctrine of sections 91, 92 of the Evidence Act. one has to look into the contract itself for ascertaining the meaning of the contract. But my lord, when we are looking at the contract and try to interpret the contract, if neither of the parties have read and understood the contract to mean a particular thing, my lord, then my lord, the question is whether my lord, the arbitrator was called upon to decide that facet of the matter. My lord, here the arbitrator was never called upon to decide that facet of the matter that your lordship will find from the pleadings, from the issues, and from the award.
Yes.
And my lord, so far as that is concerned, my lord, if this my lord part is not my lord staring me in the face, then my lord, the question is whether the tribunal was my lord justified in going into the aspect of my claim for my lord the remainder of the amount. My lord, my allegation that you failed to supply the remainder of the amount in breach of the contract, and consequently, my lord, my claim for damage.
Everything hinges on this. Basically.
Yes. Now, my lord, so far as this is concerned, your lordship has seen that the tribunal has, my lord, painstakingly, my lord, dealt with every ground. And my lord, in my lord, sufficient detail. Now, my lord, so far as the grounds are concerned, my lord, failure to supply, my lord, substandard goods, my lord, I'll not trouble your lordship, my juniors, please. My lord, the quality complaint is there. My lord, that, my lord, I don't know whether your lordship has been showed. My lord, there was no request after June. My lord, these are their points, canvas. 100% advance, my lord, is something that is, my lord, discussed. Now, my lord, 100% advance is something that is also, my lord, falls within the domain of section 63 of the Contract Act. My lord, that is, you may, my lord, ultimately remit the performance of some obligation, because, my lord, you have previously supplied without accepting 100% advance. And, my lord, that is also, my lord, that is something discussed here. Now, so far as this is concerned, I think that the discussion, my lord, is from paragraph 56 of the
paragraph
award.
66 has been placed.
Yes, I'll not trouble your lordship.
Yes.
Well, I think, my lord, 100% advance your lordship has been, my lord, shown
comprehensively.
My lord, next, my lord, is the question of, my lord, payment and supplies. Now, my lord, here your lordship will please see paragraph 64 onwards.
Up to 66 has been placed.
Yes. My lord, 100% advance, my lord, payment and supplies is, my lord, a part of that. My lord, here, my lord, paragraph 64, my lord, deals with, my lord, the my lord,
was also placed.
did not supply goods worth, my lord, 3 crores. I'll not trouble your lordship with that. My lord, here, if your lordship sees paragraph 66, দেখিয়ে দিয়েছো তো? তাহলে আমি দেখাবো না। ঠিক আছে। My lord, next is, my lord, the question of guaranteed supply.
Exhaustively placed with the right pauses.
No, my lord, I will, my lord, certainly not repeat. My lord, I am, my lord, here in default myself, not having been there before your lordships, my lord, on time.
No question.
My lord, paragraph 72. My lord, this is in the aspect of guaranteed supply.
Yes.
Well, this is what the tribunal holds. Well, the respondent's contention accordingly does not get support from the contract. If it was the intention of the parties that supply would be made only on participation in tender.
That tender.
Well, that is, my lord, their point. Their point was not, my lord, you don't take it for 1 month, you can't take it later.
So Mukhopadhyay says that was the only point which was taken in their objection.
Yes. Yes.
That you did not participate in the tender.
In fact, my lord, the defense case has been summarized, my lord, very succinctly in the award. If your lordship sees, paragraph 5, I'm sorry, my lord, just let me trouble your lordship with that, my lord, page 66, paragraph 5. These are, my lord, the points canvassed in defense.
Yes.
My lord, 5, Roman 1 onwards, kindly see the grounds urged. Respondent had no obligation at all to make supply as the agreement was purely of a temporary nature and there was no commitment on the part of the respondent that the respondent, irrespective of the claimant's participation in tender or becoming the highest bidder, to provide the goods. No supply was made because there was no request made by the claimant for effecting any supply, as there had been large-scale default in making payment as stated in paragraph 8 of the counter statement. Then no supply was made as the claimant failed to make 100% advance payment in terms of the agreement as mentioned in paragraph 10. No supply also made as the claimant had failed to participate in tender in terms of the agreement which was floated by the respondent. Supply was to be made subject to availability of goods. And when the claimant failed to furnish sales tax declaration forms or payment in lieu thereof to the respondent, and as such, no supply was also made. The respondent on such amount claimed these amounts. So, these are the points canvassed. And so far as these are the points, each of these points have been dealt with. And here, What I was trying to show to your lordship is now the question of non-participation in tender. That is dealt with by the tribunal from paragraph 66 end. In fact, the relevant portions are now at paragraph 70. Yes. Regarding non-participation of tender, the evidence of Tapan Ghosh, the respondent's witness in paragraph such and such, as affidavit evidence may be referred to. In answer to questions 74 to 79 in cross-examination had specifically stated that the supply was made to the claimant without participation in the tender. Therefore, in view of the above position, it was not proper on the part of the respondent to refuse to supply future quantities under the contract on the ground of non-participation in tender. It is also a matter of fact that immediately on the next date of the agreement, that is 12th March 2004, the respondent had floated tender for supply of the same goods, and admittedly the claimant did not participate in the tender. Nevertheless, the respondent had supplied the goods under the contract up to June 2004 without raising any objection. Respondent had also not raised any question by any writing or otherwise for non-participation of the claimant in the said tender or any tender if the floated or any tender if any floated thereafter, but supply was made from time to time up to June 2004. Therefore, the plea of non-participation of the tender, non-participation in tender taken by the respondent as a plea for non-supply of goods cannot be accepted. Plea is rejected. And here your lordship may also have a look at page 113. This also deals with the same thing, but I don't wish to repeat. Now, the question of guaranteed supply. Paragraph 72. This is what the tribunal holds. The respondent's contention accordingly does not get so. It was intention of the parties that supply would be made only on participation in tender. And then, if your lordship travels down about 5-6 lines, it was specific. If we specifically analyze clause 5C of the contract, it would appear that the supply of 7,000 metric tons of goods per month under the contract was in any event guaranteed, but only the price of goods has to be paid by the claimant at the price and other terms and conditions accepted by the higher bidder. So, their contention was not that, you forfeit your right to the goods after the expiration of the month, but, you have to participate in tender. And, the tribunal says that no, participation in tender is only a price discovery mechanism, nothing beyond that. Then, with regard to the availability of goods, paragraph 74. Yes. The respondent had also contended that supply of the goods under the contract were also dependent on the availability of the same with the respondent. Now, here your lordship sees, paragraph 81. Discussing this, at length, ultimately, this is what the tribunal says. The said witness of the respondent, however, finally detracted from his answer to the question numbers 84, 85 while answering to question number 130 in his cross-examination, where the said witness has stated that he is not in a position to make the same statement with regard to non-delivery of the said goods as the same were not available with the respondent. Therefore, the respondent cannot take the plea that goods could not be supplied due to non-availability of the goods. We therefore do not accept this plea. Now, no demand. It was the next point considered. Paragraph 82. Another plea was taken by the respondent as a ground for non-delivery of the goods that no demand was made by the claimant for supply of the same. The respondent's witness, Tapan Kumar Ghosh, although had nothing stated in his affidavit of evidence to that effect, but in his answer to cross-examination has stated so. In this connection, questions 31 to 36 of Tapan Kumar Ghosh's cross-examination can be referred to. While dealing with the above point of no demand, we have to consider the following. Whether the contract contains any provision for advance demand for supply, whether any demand was at all made or not, what would be the consequence in law if none of the above 2 points are available. The contract, admittedly, does not contain any provision with regard to making a prior demand for supply of goods. It is significant to note that supply admittedly was made by the respondent between April to June 2004, where without any written demand made by the claimant. Had there been such provision or arrangement with the parties, the respondent could not have supplied those goods during the span of 3 months of time without any such demand. Secondly, in any event, the demands were consistently made by the claimants for supply of the goods from June 2004 that would appear from the claimant's letter dated 14th October 2004 at page 70. Now, my lord, there is a difficulty. My lord, the arbitral records, my lord, could not be traced out. My lord, even my lord, the lower court records, my lord, could not be found.
The documents probably could be traced out, but the total
No, my
evidence.
lord, the deposition, my lord, and the documents are not all available. My lord, that is why we had attempted, my lord, to reconstruct, my lord, between ourselves, but none of the parties, my lord, are in possession of the records. My lord, we thought that the entire records would be, my lord, available with the lower court, but even that, my lord, appears to be, my lord, a very uphill task. My lord, we have to, my lord, therefore, my lord, there is no challenge, my lord, that there's an incorrect recording by the arbitrator in the
That is
my
what
lord,
we are thinking of.
my lord, with the greatest respect, we have to proceed on the premise that, my lord, this recording is correct.
Yes. That objection was not taken before section 34.
No, no.
So therefore, let us proceed on the basis
Yes.
that these recordings are correct.
Secondly, in any event, demands were consistently made by the claimant for supply of the goods from June 2004, as would appear from the claimant's letter dated 14th October 2004, letter dated 19th November 2004, letter dated 14th December 2004, etc. Therefore, these letters in any event demolishes the plea of the respondent. Irrespective of the above position, it is a contractual obligation of the seller, being the respondent herein, to supply the goods under the contract, irrespective of any demand made by the purchaser, being the claimant. Supply of the respondent in any event does not and cannot depend on any specific demand made or not made by the purchaser, being the claimant. Respondent is bound to fulfill the contractual obligations under the contract for supplying the goods, subject to fulfillment of the reciprocal obligation by the claimant. That is, my lord, the payment of price. And then, my lord, why, my lord, no demand was made? On that, my lord, your lordships may have a look at, my lord, paragraph 87. It appears from the pleading and evidence of the respondent that the respondent, in fact, at different places had taken different plea for non-supply of the goods. In some places, it has been stated that the supply was not effected because of non-payment of 100% advance, whereas in some place, it has taken the point that the claimant did not participate in the tender. Again, in another place, it has taken the point of non-availability of goods with the respondent, and finally, it was stated that no demand was made by the claimant for supply. In answer to question number 38 by the respondent's witness in cross-examination, however, stated that the competent authority had taken decision to stop supply because of long outstanding dues. The witness does not refer to any other ground in his answer. Even if we take this answer to be of the respondent as correct, it is not so factually, because the claimant had made full payment for the supplies which were made up to June 2004, which may be delayed, and had also tendered the payment towards future supply to the extent of 3 crores, which checks were ultimately returned by the respondent on the ground of non-participation in tender. So therefore, even final stand which has been taken by the respondent's witness is contrary to record. And, my lord, thereafter, my lord, your lordship will find, my lord, this is what is, my lord, really the justification for awarding the claims. My lord, one of the, my lord, factors also which perhaps might, my lord, interest your lordships is, my lord, the delay in making final payment. Why there was a delay? That's paragraph 88. It has already been mentioned above and have also been admitted by the witnesses of both the parties that against the supplies made by the respondent between April to June 2004, part payment under ad hoc payments were made from time to time. And finally, the balance payment was made by letter dated 30th December 2004, being documented page 83 of the brief of documents. The question reasonably arises as to why there was a delay in making such final payment. In answer to that, claimant's witness, such and such, in answer to question 179, stated that although the ad hoc part payment was made from time to time, the balance payment was withheld since the question of complaint with regard to inferior quality of goods was pending with the respondent. However, such balance payment was made because of threat made by the respondent by its letter dated 24th December 2004, which is at page 81 of the brief of documents. It is also a matter of fact to be noted that until 24th December 2004, there was no demand for such payment of such balance sum made by the respondent. As discussed above, while we were dealing with the issue of rejection of the goods, notwithstanding the fact that written complaints have been made by the claimant about the quality of the goods and for inspection, etc., the respondent did not give any reply thereto. Therefore, quality dispute with regard to the quality aspect was kept pending, and the claimant was under reasonable impression that there would be some sort of arrangement between the parties with regard to either diminution of the price of the goods or adjustment of the price, and on such presumption, the balance payment was not made. However, the ultimate payment was made, and that was also accepted by the respondent without raising any question. And my lord, on this aspect, my lord, also, paragraph 90, therefore, the question now remains for adjudication: what would be the consequence of such breach? Claimant has made twofold claims in the proceeding against the respondent for aforementioned breach committed. The first claim is on account of excess amount spent by the claimant in purchasing the balance quantity of ore, which is then dealt with. One is the question of excess amount spent, and the other is the question of loss and profit. Loss of profit. So far as this is concerned, the arbitrator here gives justification for both.
Now, we were thinking that we were asking some code that whether there is some contradiction between the two claims, because if you got it from somebody else, then where is the question of loss of profits?
No, I could only get part of it.
That was the answer given by
Yes.
Mr. Mukherjee. So,
I obviously cannot ask for the same thing twice.
yes,
it will
because
be double jeopardy.
So you did not get the entire amount that has that
For the part that I could get, and I bought it an excess price, for that I have claimed the difference. And for the part that I could not get because of non-availability in the market,
that will be reflected from your pleadings, must be.
That is from for my loss of profit. And here, the question when assailing an award would be one of perversity. Lack of consideration of materials on record, lack of consideration of express
on a much higher footing than a regular.
So here, with the greatest respect, if your lordship sees, so far as the proof of claims is concerned, there is adequate proof. Now, whether the appellate court would have considered this to be sufficient proof or not is not a matter for consideration.
No.
But so far as this arbitral award is concerned, it proceeds on a premise which, at least on the face of it, seems to be plausible.
It interprets the contract in a way which is not a non-plausible or impossible view.
Yes, and
not an absurd view. It is one of the possible interpretations of the contract.
Yes, and with the greatest
section 20, it does not come in that it's beyond the contract.
The interpretation that was sought to be put forth by Mr. Dotto in the course of his arguments, that was not an interpretation sought to be advanced before the tribunal.
That too.
And that is why, your lordship has seen, identification of issues requiring consideration in the award. And this is not one of the issues.
Unless it's an absurd interpretation, in any event, we cannot probably interpret.
Yes. It has to be contrary to the terms of the contract, or something that no reasonable person can ultimately infer from the contract. This is really, ultimately the summation of what has been dealt, and then the summary of the claims awarded is at page 140. That your lordships have seen.
Yes.
So far as the second matter is concerned, the only difference between the first and the second matter is, in the second matter, there is no 7 metric tons per month.
Oh, that is not there.
It is an obligation to effect supply of the total quantity. Well, that is the only difference. Otherwise, it is really the same thing. Mr. Dotto has also accepted this and made very brief submissions on the second matter. But I can give you lordship the same award. But I honestly feel that the award is very exhaustive, deals with every aspect. Unless your lordship finds that some of what has been held by the tribunal is completely absurd or unreasonable.
Only one thing, Mr. Shah, this lack of 7 metric ton, this restriction, this may be a double-edged sword, in the sense that they may argue that when there is a 7 metric ton this cap, I mean, then you may still argue that yes, they have to supply the 7 metric ton because it's stipulated there. So no demand is necessary specifically by you. But when there is nothing of that sort, no stipulation as to how much, then all the more it's necessary for you to demand for it to be given to you.
In the second matter.
In the second matter.
Yes, no. Let me.
That may go against you also. Because if there is no 7 metric ton stipulation, then they cannot give it. I mean, you'll have to make a demand for them to know how much you require.
Well, in the second matter, I don't think that problem is there. But if you will kindly see the agreement in the second matter. We are arguing both the matters together. Really.
Yes, yes, the same arguments, only 7 metric ton. And
I'll just show you.
Second matter, probably no paper is there.
No,
nothing is there. Whatever is there in the first matter, that is also not there.
That is right. That is right. Well, so far as the second matter is concerned, It mentions the period of contract. And my lord,
second paper book ta ache
এটা পড়ারই আছে না।
941. Do you need the paper book, or we can take down the points? You can put it in your written notes.
I'll put it in my note.
Only please give us the page of the contracts in both the paper book.
I'll do that.
Just in your argument, just mention the page of the contract where the contract is there. It will be a composite argument, and if there is any bifurcation of arguments, you just indicate that in respect of 941.
I think that will be better.
That will be better.
So, my lord, I'll give a composite note in both matters with a bifurcation, my lord, separate bifurcation note as to what is the distinction between the two.
Yes, that will be best.
My lord, kindly give me 2 weeks time, my lord. Well, I will have to do this personally.
Well, so, yes, anything else? We'll close the argument 7. Put it in your written notes, and you'll also get 2 weeks.
Note করে দেবো।
But for the reply, my lord, can lordship take it after recess, my lord, immediately, Mr. That is not here, my lord. Short reply, my lord. We'll also put most of them in the
Well,
notes,
I
my
have
lord.
not dealt with the judgments, Mr.
Yes,
Datta.
exactly.
I'll
There's no
just
scope
deal
of any
with
reply. Unless we want a reply, you did not give a reply.
Then,
He
we'll
has only
find-
answered your questions. You have not even relied on judgment apart from one judgment which was cited by them only.
No judgments, my lord. These are, my lord, now your lordships have laid
All
down
principles are settlers. The same few judgments do their rounds.
all principles.
So
And
there's
all
also
the new judgments, my lord, say the same old thing.
Same old thing, yes. It's like the memory game, Mr. Shah.
Yes.
First one quotes the first, second one quotes the first, and on and on. So closing arguments. So you put in your written notes of arguments. 2 weeks means today we are on 13th. So you can keep it on whenever you say 27th or.
Yes.
Oral arguments are concluded in the matter. Stop. On the prayer of learned senior counsel appearing for the parties, the matter is adjourned till November 27, 2025, when it will be listed under the heading to be mentioned for the purpose of filing of written notes of arguments by both sides.
Very good.
আপনাকে দেখতে হবে পুরো পরিচিত
Even my lord, matters Dhar is appearing.
শেষ হয়ে গেছে Seven. 7.
Appear for the writ petition and respond. Howrah Jilla Police.
Yes, my lord, we are appearing for the state.
This is where the learned single bench has held that the property is a Rayati property where the encroachers have been rehabilitated by the state agency, and since the concerned BLLRO has filed one affidavit in opposition, thereafter she was given an option to clarify herself by way of a supplementary affidavit, and learned judge was not happy with the affidavits and thought that the concerned BLLRO has tried to say this particular land has been vested to the state, and that's how she has affirmed a false affidavit, and their cost was imposed upon the concerned BLLRO, as also the higher officials to take a note and put it in the service book.
This is basically a challenge against the cost.
Yes, cost and that particular remark.
Let us see the judgment first.
Yes, I will kindly come to.
Is there a paper book? No.
Yes, there is.
Put the paper book. Okay. No paper books have come. Both of you have the paper books?
Yes.
Yes.
Paper book should
We
be.
all have the paper.
আমাদের শুধু নিশ্চয়ই আছে কোথাও ওখানে আছে
straight away come to the
দেখবেন যদি
impugned
ফাইল হয়ে
order.
থাকে তাহলে ডিপার্টমেন্ট আজকে চেয়ে নেবেন, আর নয়তো এখন একটু বাদে পিওন এলে দেখবে, আপনাকে যেতে হবে না পিওন এলে।
Impugned order, Malad. I'm
Yes, yes, yes.
facing, Malad.
Great.
This relates to only plot number 1338.
Right.
There are two Khotians. One is 9381, two 9392.
So
Sorry,
that plot covers
not two Khotians, several Khotians because of that family. There are several members. So altogether land is involved 1 bigha 11 kathas, 3 chatak, 10 square feet. Then, Malad.
So ultimately the writ petition was allowed.
Ultimately, the writ petition was allowed.
That she was disposed unlawfully.
Yes.
And you had given a wrong impression that it was vested.
It was
That
vested.
was the premise.
That was the.
You are for the Ms. Ghosh, you are for the writ petitioner.
I'm
Yes.
for the writ petitioner.
And you are for the Howrah Jilla Parishad.
Yes.
So very well. You are for the added respondent. They are. Who are they? BLLRO suffered the cost.
BLLRO has suffered the cost. Perhaps আপনি added respondent মানে BLLRO নন, আপনি DM হতে পারেন, district magistrate.
Whoever has suffered the cost are before us.
Yes, I have preferred this.
Yes.
So, Malad, kindly come to the relevant portion, Malad, that is at page.
Only BLLRO was imposed with the cost. And the
Yes.
the remarks.
The remarks.
That's very well.
I'll take your lordship to the first impugned order and then the affidavits filed by the concerned BLLR.
Let us first see that the caustic portion of the order.
Oh, Manoj, want to.
Otherwise, will because your challenge is restricted to that, will not set aside the writ petition being allowed otherwise.
Kindly come to page
27, internal page 27. Or before that also.
27. May I place it from page number 23? That is the
Whatever.
discussion.
Whatever.
Yes. The BLLRO, Ruma Sarkar, affirmed another affidavit on 25th February 2014, making incorrect and untrue statement once again before this court to the following effect. The right title and interest of the intermediaries were vested to the state.
No, let us start from the previous paragraph because this is the second instance of incorrect statement.
This court perused.
Yes.
Yes. This court perused the documents annexed to the affidavit in opposition and found not a single document showing acquisition of the property in question at any point of time.
No, it starts before that, in fact.
Yes, Manoj,
yes.
that's right. From in inner page 22, oita, the court, this court.
That page was 22, the concerned block land. BLLRO.
Yes, the concerned BLLRO officer deliberately.
Yes.
Made a false statement in her affidavit in opposition, affirmed on 13th August 2013 under paragraph 4 and affirmed true to her knowledge. The relevant statement is quoted hereunder. The writ petitioner cleverly knowing the facts that the suit plot number 1338 is acquired property and suppressing the facts and misrepresentation took money from the bank. This court perused the documents annexed to the affidavit in opposition and found not a single document showing acquisition of the property in question at any point of time. It is common knowledge that in case of acquisition of a property, there would be publication of notice, there would be an award, and there would be payment of compensation, but nothing was produced showing that the property was acquired and compensation was paid to the owner of the property in question. This court granted liberty to the concerned BLLRO who has made deliberately wrong and incorrect statement before this court to affirm an affidavit accepting her mistake. But such liberty was misused and BLLRO Ruma Sarkar affirmed another affidavit 25th February 2014 making incorrect and untrue statement once again before this court to the following effect. The right title and interest of the intermediaries were vested to the state in respect of the said lands as per provisions of section 4 and section 5 of the West Bengal Estate Acquisition Act 1953. This statement was made under paragraph 3 of the supplementary affidavit dated 25th February 2014 by Ruma Sarkar. She affirmed this statement true to her knowledge. After perusing the supplementary affidavit, Mr. Pal was directed to produce the relevant documents showing any such proceeding under West Bengal Estate Acquisition Act 1953. It is no doubt true by operation of law, all properties of big riots were vested in state subject to exercise of option using B form for retention of land as permissible under the Act. In such case, big riot proceeding is initiated and the concerned revenue officer, BLLRO, decide the case allowing retention of land as desired by the big riots as per West Bengal Estate Acquisition Act, and records are corrected showing Rayati Shatto Bishishto on the retained land. No such records were produced by Mr. Pal, learned advocate who is representing the state authorities, including the BLLRO. Mr. Pal wanted to show some ROR wherefrom it appears that the lands are Rayati lands, and copies of ROR clearly indicates that the writ petitioners are the owners of the land and they were in possession. At the time of hearing, Mr. Pal wanted to interpret some provisions of the West Bengal Estate Acquisition Act, but facts remain that no single scrap of paper was produced in respect of claim and contention of the BLLRO as made in two affidavits, once claiming that land is acquired and subsequently claiming that the land is vested in the state under West Bengal Estate Acquisition Act. It is thus evident that the concerned BLLRO deliberately and intentionally made a false statement before this court to misdirect the honorable court and in fact to justify an unreasonable and unlawful stand taken by the state authorities. Now the question arises whether the respondent authorities, including the Jila Parishad, Panchayat Samiti and District Administration, can dispossess a lawful owner. But I am not placing this part because I am not agreed. I have not filed any appeal to controvert this. Now,
normally, no appeal is maintainable against only cost.
Yes.
But here, caustic remarks were also made, so maybe we'll look into it. Let us see.
Now, Malad,
till now appears to be justified. If these were the affidavits affirmed and no papers were produced, and even the RS records do not reflect that it was vested.
I'll show the affidavit.
Wait,
the BLLRO has categorically said that though it's vested by operation of section 4.5, but Khondo Khotian was opened because this land was retained.
We'll look into that.
Then that 300A and part I am not placing.
Yes.
Accordingly, Malad, kindly come to Malad inner page 26. Last
accordingly
sentence,
allowed.
Yes, allowed with the direction upon the respondent authorities to remove the encroachers from the land of the petitioners and deliver back the peaceful possession to
the second paragraph.
Yes. This court has come to a definite conclusion that the BLLRO has made a wrong statement deliberately and intentionally, affirming affidavits before this court as true to her knowledge. These averments are not supported by any relevant documents. For these reasons, the concerned BLLRO is punished by awarding cost of rupees 10,000 and the DLLRO officer is directed to deduct the said amount from the salary of the BLLRO in the month of May 2014 and to pay the amount to the writ petitioner's service book of the said BLLRO would record such punishment. Now, Malad, kindly.
First of all, you have to contradict its stance. First, you said it was acquired and vested. These are two different things.
Now, Malad, I'll take.
And you are given an opportunity when you said acquired, no documents. You are given an opportunity to correct your mistake.
And I'll show that document.
For that, or say something.
I'll show that document.
Any explanation why you said acquired previously? Acquired is different from vesting. Under W.
Absolutely.
Yeah.
Absolutely.
Did you say something in the affidavit to say that I am sorry that was wrong?
No,
that opportunity was given. That is the finding of the court.
I never intended, or my client has never intended to say.
In the writ court, was there any order? Because there must have been a direction permitting you to file the second affidavit.
Yes. Let me place the first affidavit first.
To affirm an affidavit accepting her mistake.
Yes.
Was that spelled out in the order? We don't have it before us. Court says at page 22 of this order, this court granted liberty
I got it.
to the BLRO who made deliberately wrong and such, to affirm an affidavit accepting her mistake.
All orders
are not there. Anyway, let us go into whatever you have to show us.
kindly come to straight away to এবার এফিডেভিট কিভাবে দেখাবো?
Affidavits are all here.
Malad does not have the affidavit affirmed by Ruma Sarkar, affirmed on 13th August 2013. First affidavit.
এগুলো রিট কোটের ইয়েগুলো কোথায়? Your clerk, unless those are very thick, ask your clerks to just take out 2 photocopies of those.
I'll do that.
Yes,
I'll do that.
Because and show it to your learned friends so that they can agree that that's a correct copy.
You don't need this.
So just circulate those 2 copies of all the affidavits. In the meantime, please do that. I will take it up at
Take it up at 2 to show.
Difficulty is if we take up another matter, then if it continues, then it will be difficult for us.
No, I'll wait.
Similar matter will continue.
Let them start.
Better we'll keep it next week. We'll pass an order. Heard in part for further hearing on November 19, 2025. Push up the records of the writ court as well as the paper books be called for immediately from the department.
But I was for the appellant.
Yes.
Almost concluded. My lord, may I just recapitulate?
You can recapitulate, but Mr. Bhattacharya, don't show one single more coconut oil can. Not a single one. We are fed up with coconut and this Shalimar and whatever.
My lord, it was Mr. Bachawat had started and he had conceded, fairly conceded, it's a suit for passing off, not for infringement. But the learned judge has proceeded on the basis of both infringement and passing off. Now, if it is passing off, your lordship is aware of the advocate's case of Lord Diplock. 5 tests of passing off, misrepresentation.
Cited that also.
Yes, no, I cited a 1990 RPC, Beckett and Coleman, where that passage is quoted.
Right.
Misrepresentation in course of trade, which has caused deception and which has caused loss. So for that, first he has to establish what is his goodwill so far as the shape of that bottle is concerned. because all his registrations, I will not trouble your lordship with the papers at all. Only one paper I will show, because that prejudice Mr. Bachawat tried to create against my client to show that my client is a copier. I will show that they are doing the same thing. So what is sauce for the goose is sauce for the gander. So my lord, what is so distinct about their shape? What figure they have given is the turnover of entire Shalimar. Nobody is disputing about Shalimar's goodwill. Shalimar is a big brand. Since childhood, we know about Shalimar. But so far as that shape of goods is concerned, all their registration is in respect of a device. I had shown a passage from Narayanan. If your lordship will recall, that device means a label, ticket, or something. It is not a shape. In 1958 Act, mark did not include the word shape. It first came in the 99 Act following this Jifs Lemons case, which I have shown. Because your lordship will recall, it was oranges being sold in containers, which was in the shape of orange.
Shape had a link with the product.
Yes, and anybody could identify it. But like as I gave an example, contour bottle of Coca-Cola. What is so inherently distinctive of this shape? Nothing. Now, my lord, this has been shown. Only one document I will show, because this prejudice Mr. Bachawat tried to. My lord, this is the reply to Can 3. I'll just trouble your lordship.
Can see a reply. It is shop document. Yes.
My lord, your lordship kindly takes page 45. This is their bottle of Amla. This is a copy of Dabur Amla. Reply. Can 3. My lord, page 47. Look, this is industry practice. Then page 49. This is industry practice. So what is?
They have compared hours.
They have compared hours, and I am showing this. So what is sauce for the goose is sauce for the gander. So they and my lord, I have also showed the trademark, my lord, the manual as to how a shape is to be registered. And my lord, I had relied on Durgadat Sharma, 65 Supreme Court, 980. If it is an action of passing off, my added materials, because it clearly indicates that it is not from Shalimar, but it is from KMP. It is a KMP product.
Device is actually the composite impression which the name and the picture together.
As per Narayanan, no. My lord, as per Narayanan, if I may just 8.06, my lord, it's the 6th edition.
Yes.
My lord, will kindly take this. Shape is completely distinct. .06 at page 147, my lord. Various meaning. It's basically a pictorial representation of object. Pictorial representation. My lord, may I just hand up my call?
No. Thank you. Yes.
My lord, device in trademark sense, device includes pictorial representation of any object or things, pictorial representation of objects like animals, birds, landscapes, buildings, and so on, individually or in combination, are commonly used as trademarks. Such devices are obviously capable of being represented graphically. So, my lord, if a shape of goods fell within the meaning of device was there under the 58 Act. There was no need for the legislature to separately bring in shape of goods under the 98 Act. And so far, it's a passing of action. Once I show, my lord, page 980, if your lordship, my lord, will kindly consider.
Their case is mostly on the bottle. The
shape of the bottle.
Not on the cumulative image given by that coconut trees and all those things.
No, but they also do have that. But I have pursuant to what fell from the court, I had given
Cumulative impression that you get from that entire.
but that label which is
Pictorial
pasted.
representation means
Yes, we have given
yes.
apropos the year of
label
the court, my lord, we had given a proposal that
That's a device.
That's a device. That's a device. So I'm willing to change it. But so far as shape of goods is concerned, my lord,
shape of bottle is
the shape of bottle, my lord, that, my lord. And Durgadatta Sharma is very clear on this, that if there are certain differences which shows that it emanates from a different producer.
Pick them one from your collection and tell them to emulate that on a different product though. So that will look distinctive and classy. I use the same bottle for everything. Coconut oil also has a character. Anyway, so what else? You have argued at length.
Yes, yes. No, my lord, so far as that manual is concerned, my lord,
yes.
how is it to be registered in case of a, my lord, I had given that is 4.7.1. I will not. How a shape mark. And what are shape marks, my lord? 4.2. I had given a spiral.
One. You had given one.
Yes, my lord, two. Duto diyechileন.
Manual.
We are marking and give us the page number of that.
My lord, first is, my lord, 4.1, which is at internal page 16. The types of mark has been enumerated. Now, just below that at page 17, if your lordship kindly sees the second. Yes.
Yes.
Description of the trademark, whether it's a shape or a color mark. Now, my lord, 4.2 at page 17.
Yes.
Representation of a trademark. My lord, additionally, the second last line, additionally, consists three-dimensional mark. Three-dimensional mark would be a shape.
Yes.
Or color combination. It's necessary to make a statement to that effect in that application. Their applications do not have any such statement. The representation must be durable and satisfactory.
Yes.
Then, my lord, 4.7.1. My lord, requirement from the applicant. 4.7 talks about shape mark.
Right.
Applicant must state on the application is for shape mark. If this is not stated, but it is clearly clear that the trademark is three-dimensional, which has not been done, is a shape mark. My lord can take my notes. And 4.7.2.
4.7.2. Thank you. Yes.
And my lord, so far as color marks, combination of colors, that is 4.8 requirement at page 20.
Yes. Combination of colors is not important here, probably. Because they yellow, blue, green,
yes,
all have.
Yes. And my lord, only once more I want to trouble with that Durgadatta Sharma. My lord, it is 1960 AIR. It is AIR 1965 Supreme Court 980. I had given a printout of SCC.
Just check.
Copy 1964 SCC online, paragraph 4, page 14.
Mohideen we have.
That has been cited by them.
By you?
By them.
No, by by you. Oh, yes. Sorry. Right. No, that must be here.
iPad ko Roma ba?
এগুলি সব কাগজ তো পেপার মানে এমনি কাগজ এটাই সব তো
I will make sure that my
Please,
junior,
please just
my lord, I'll just mark this portion if your lordship kindly.
This is the area.
65 Supreme Court 980. My lord, this is the portion, my lord, which I want to.
983.
980, my lord.
0, yes.
Paragraph 28, last few lines. My lord, may I just hand up?
Please, you can read out. Para 28.
28, last few lines. It's a very longish paragraph,
Right.
just before paragraph 29.
Right.
Expressed in another way, expressed in another way, if the essential features of the trademark of the plaintiff have been adopted by the defendant, the fact that the get-up, packaging, and other writing or marks on the goods or the packets in which he offers his goods for the sale shows marked difference or indicate clearly a trade origin different from the registered proprietor of the mark would be immaterial. Whereas in a case of passing off, the defendant may escape liability if he can show that the added matters are sufficient to distinguish his goods from those of the plaintiff. My lord, will kindly have.
What are the added matters here?
My lord, it clearly shows it is from KMP.
Yes.
I'm not showing your lordship the bottle again. No. This is KMP. No, my lord has said no. No,
Not a single bottle.
Not a single
Because
bottle.
The bottle loses.
But bottles used at home are very different from this.
Yes, we are saying that. We are suggesting to Mr. Bhattacharya he can
I heard
take care of that.
From his. Yeah.
Coconut oil will also have some character.
বারণ করেছে।
We remember it KMP written there.
And my lord, he is edible oil and I am coconut oil. He pays a lower GST, I pay a higher GST.
Oh, acha.
5% GST on edible oil.
At this point,
এটা দিয়ে দিন। Yeah.
My lord, and I had shown that Gibbs Clemens case to maintain an action in respect of a shape, the standard is too high. And it's a passing off which Mr. Bachawat had admitted, but the order which has been passed is in respect of infringement and passing off.
Yes. Very short introduction first, because I had started my submission on the on the last day.
Does your lordship
I'll
have this
just
compilation? My junior says he had handed over a compilation like this, which was a spiral one with judgments, my lord.
These two compilations are before us. One is by the respondent. Another is by not written anything. Compilation of documents. It's apparently by you. We don't know.
May I have a look at
Plaint
it?
and this is not of judgment. It's plaint, petition, the paper.
My lord, we will hand up a compilation of it.
And this spiral binding was the manual of trademarks.
give us a copy of what?
Judgments
Judgments copies were cited. Copies were cited.
Compilation
No other compilation is there in our This was given by whom?
Can I have
Probably by Mr. Bachat.
No, this was.
It was by.
We had separately handed it.
This was by Mr. Bachat's client, probably.
But can I have a look at the first judgment in that other compilation?
Because it appears to be from the same shop. Or
they all go to the same shop.
Oh, acha, right.
But everyone in this area.
Yes, right.
My lord, this was by us. It is wrongly written as because we were the respondent before the trial court.
Oh.
So it has gone as
That is
commercial.
creating the
But
confusion.
this is our compilation.
Must be there then.
Yes.
It is.
65 is not there.
Yes, my lord, the first one. The first one.
Oh.
65.
We are not looking into that because we thought
My lord, we will have it corrected.
No, we'll just take a note. No difficulty. Just right now do it.
Actually, the lower cost title has been wrongly given.
Yes. You are edible.
I am
edible products. Yes, yes.
But first, not I'll not one apology, not which I'll seek not at the beginning. Not I'm post lunch. I'll probably be not. I'm on legs in another bench where it's likely to be taken up at 2:30.
Oh,
So
one
if
matter
possible-
we made it parted and kept.
No, I'll continue till not. I'm told that not there's a little responsibility. I'm appearing
No
for
difficulty, no
a
big
court-appointed not committee. Not, so I have to
be there.
I have to be there. Not,
Very
but
little,
I'll
one of the-
continue. I'll
no
continue
difficulty.
till that. Now, I'm not to give you a lot of very, very short overview. Not very short overview. Not case of two bottles which are similar, same colors adopted, looks and feel alike. Now, the trial court first passed an ad interim order of injunction in our favor. It was restricted to passing off and not to infringement, and I will not stress upon this because 90% of my learned friends' argument has been not based on 7 different reasons why it's not an infringement. So that not I can get rid of in one sentence because the ad interim order and the final order are on passing off alone. So each and every one of the judgments which he has showed, not and the trademark manual and things like that are completely irrelevant. Before your lordships get up, I'll just point out the 5 points in relation, or rather 6 points in relation to not infringement, not that he has taken, which will go away in one line. But first he has said, I don't have registration of shape. I don't have registration of color. Now, all these are irrelevant in an action for passing off. So, that was one major chunk of his argument. The next limb of his argument is that my mark is subject to a disclaimer. Again, my lord, completely irrelevant in a passing off action. Then he argued there's a different class of products. One is hair oil, class 29, the other is class 3. So therefore, there can be no infringement. Again, not completely irrelevant in an action for passing off.
Classification in the registration, trademark registration is irrelevant.
Completely irrelevant in passing off.
Yes.
And Lord, I showed your lordship that one judgment only to start off with for that reason. But unfortunately, my learned friend has again repeated those same things. Then he made an application. Yes, but not I had already taken care of it, saying this is irrelevant. 2.5 days went by on this. Then, Lord, was his section 17 argument again, Lord, which is material only in a Lord infringement action. Lord, shape and color was not registrable under the old act. That was also another argument he made. Again, Lord, completely irrelevant in a passing off action. And then he relies on the trademark manual, which is again, Lord, all these would have been relevant if not I had got an order for infringement. But I intend to show even that is long. I won't extend it. I'll show 1 or 2 judgments to show. Not assuming this had been an action for infringement, I would still have been entitled to an order. So that's one part of his argument. The second part of my argument, which I had started with again on the last day, Lord, he has applied, that scan 3 for permission to change the label, saying I'm changing my label. So, Lord, on that, Lord, I had already showed your lordship that there is no change. That application is based on a misleading, on quite a few misleading things, and I had started off on that. Not, I'll repeat that. Not, I'll start off on that after lunch. Not, but not whenever I ask for leave. Not your
Yes,
lordship, kindly permit me. Not if your lordship doesn't mind.
No.
तीसरी कंपनी की ब्रांडिंग जब आ गया सबसे गंदा है साहब। हाँ 2 साल से चल रहा है। आप देखिए ना इसके डेली हेयरिंग आता है। लास्ट 1-2 महीने 7-8 पे तो हेयरिंग होगी। आपको देख के क्या लगा रहे हो? हम तो 2-5 में फिर भी क्या लगा रहे हो? इसमें तो हम जब आया ये लेकिन गलत बोला है कि जीएसटी रेट हम लोग फांसी लगा रहा था। जिसका सब्जेक्ट उसको अभी वो तो आउट ऑफ द मैटर में जाके रुद्रमन बोला। हाँ ये तो वो हम लोग को ना वो उसका 5%, उसका 5%, हम बोलते हैं 12%, ट्रेंड ऑफ द मैटर जो था वो कर रहा है। वो ऑलरेडी बचौत पॉइंट आउट कर दिया उसको। चलेगा नहीं तो हार जाएंगे। और जज भी कन्विंस नहीं कन्विंस कैसे होगा? तो बोल दिया तो कि आपका सपोज आप इस पेपर लेके बात करेंगे इसमें क्या है, आप वो बाद में ये सब पेपर लेके इसमें क्या लिखा है इसमें क्या लिखा है बोलने से क्या होगा? जिसमें तो अपने को उसका पेटेंट जो इसका सब्जेक्ट का लॉयर है करना सब्जेक्ट का लॉयर है कि ये कॉलेज तो है नहीं। हाँ ना सब्जेक्ट का लॉयर पहले था हाई कोर्ट में करना चाहिए चीज पता ना उसमें जो वो जो रुद्रमान अपने हर जगह चल रहा है। रुद्रमान को ही तो ये लगा के रखा है लेकिन उसका पीछे वो जो है ना ओरिजिनल एकदम ट्रेडमार्क पेटेंट कॉपीराइट में चोस है एकदम चोस। एक्सपर्ट है यंग लड़का है तो बोलता भी है बोलने दिया नहीं ज्योतिष का भंजा है आगे जाके बहुत बड़ा साइन करेगा ये। और इसको हर चीज में बहुत स्टडी करता है और एकदम ये कॉपीराइट पेटेंट पहले तो हम लोग जो इसको रखे थे रुद्रमान का अप्रोच देखिए हम बोलना नहीं चाहिए कैजुअल अप्रोच है। हाँ वो सीरियसली लेना नहीं है और इसको एकदम लोग इतना चढ़ा रखा है आप गॉड बना रहे हैं। रुद्रमान को ये चढ़ा के रखा एक रुद्रमान हो गया और एक हो गया जो अवधूत हमको भी अच्छा नहीं लगता है।
ठीक है, just give me the page now. Order. Order. ব্রিফটা তো এখানে দেয়নি কোথায়?
First হচ্ছে pair B টা page of 43 তে pair টা রয়েছে।
If your lordships would take page 143, I just want to show your lordship that the order is only in passing off. Volume 1, page 143. Briefed over. 143. Yes, 143. Oh, and Lord, if your lordship takes prayer B.
Yes.
The lordship will find that the prayer is in passing off. So it's a prayer for passing off. Now please see the ad interim order, which is at page 544.
103 টা দিন।
549 para 12.
Now, if your lordship comes to page 543 is the in order, and the relevant portion is 549, para 12.
Yes.
So, my lord, it's prayer B which was granted. Now, this order is what is confirmed, Lord, which your lordship will find at page 576. 576, you know. 826. Okay.
Volume 5.
Not at 834. The order is at 8. Starts at 834.
Volume 5.
Volume 5. And if your lordship comes to para 17, which is at page 834.
Yes.
Bottom of para 17, the ad interim order of 16th August is hereby confirmed in this part. So, my lord, the order is restricted to passing off, not for infringement. Number 1. Okay. So, my lord, the entire argument which has been based on infringement, my lord, is really completely meaningless.
Your prayer is restricted to trademark and trade dress.
Yes.
Not exactly the shape of the bottle in that sense.
The trade dress includes.
Trade
This
dress
is a question
includes.
which your lordship put. My learned friend had argued that not trade dress cannot include shape. I'll show your lordship to the contrary. Not without getting into detail, let me just not look at not what is happening. Not forget not whether it's infringement or passing off. Not the law has always been that not the statute only recognizes a pre-existing common law right. It does not confer any higher right.
Yes.
Now, as far as not, and that is why the section specifically preserves common law rights, and then says, look, if you obtain registration, the only advantage perhaps is that one need not show user from a particular date because it's deemed that the day you've applied or the day you got registration, by then there is user or adoption, one of the two.
It's a legal right, basically.
I show the certificate, it means that I have a right unless someone comes and proves the contrary, which is why the Trademark Act contains the exceptions, that a prior user will have a defense. So, let's not forget the Trademark Act. Now, let's go to the common law. But common law, this is governed by the law of passing off. Now, this evolved in the early 1800, or rather mid 1800s, and by 1890s it begins to get shape. And the basic test is this: are you trying to filch the goodwill of someone else? In other words, are you making a misrepresentation to people who buy it? If you are, and there is only likelihood of deception, there need not be actual deception. If there is likelihood of deception, then it's a tort, and it's stopped under the tort of passing off. Now, my lord, over time, a number of tests not developed. And my lord, the test as we know it today is that when comparing products in an action for passing off, the test is not that of a technical person, it is that of a lay person, not a person of average intelligence and imperfect recollection.
Yes.
Who does not have the products in front of him to compare what is the difference between
Cannot
the two.
keep it side by side and
So that's the
recollection.
Correct. So, my lord, and that too, it need not be a searching examination. So, my lord, that's the test which has grown around it. Now, my lord, two things over here. Your lordships are faced with two things. I have two bottles. He has got two bottles. Shape is the same, color is the same. My learned friend says, look, it's a different mark, therefore, you can't get me. Whether it is infringement or passing off, you can't stop me. Now, this is one part. Now, when he is not succeeding on that, then he comes up with an application saying, please permit me to change my label. This is my new label. Now, again, the design remains of the bottle or the shape of the bottle remains the same. The color also remains the same. He changes the picture inside.
But Mr. Bachawat, he is not restricted to some color. Your prayer is also not restricted to that.
It's straight dress.
Because they have both of you have similar bottles and these labels in different colors.
No.
Green, blue, yellow.
No. Not different products. Yes. I'll show that to your lordship, which is why I want to show your lordship that an incorrect impression is given. Not first, not argument of my learned friend is, my product is different. Yours is edible, mine is a hair oil.
Yes.
Number two, impression is given that his sale has been entirely stopped. Why? Because the injunction is not just on edible oil, but on hair oil. This is two. There is a third misleading thing which I'll show your lordship, not just so that one can finish off the matter quickly. Please take can 3 once. So your lordship takes can 3. It will be very helpful and the opposition to that. What about Got it. I've got mine. Now, please see the manner in which he tries to.
Can 3 কোথায় এখানে আছে can 3 পেজ অপোজিশন আছে এটা can 3 রিপ্লাই পেজ সব এখানেই আছে দেখুন অপশন পেজ রিপ্লাই পেজ অপশনটা পাচ্ছি না country reply you have got opposition did you file the opposition?
Yes, it was shown. Prepared. It was shown on the last day. It was shown on the last day. But I have copies. Color copy though.
Can we find the
it was there. I showed it on the last day also. I remember. Opposition दिए तो a petition तो नहीं होगा. Lord, is a petition can 3 with your lord?
Can 3 is with us, reply is with us.
And very good. That should take care of it. Now, let's first take can 3.
Yes.
So, para 1 is his present bottle. That's annexure A, page 7. This is what he says. He doesn't refer to the other colored bottles. Remember there are 2 colors. Now, green and yellow. Now, my lord, please take para 2. I'm just showing your lordship. In the course of hearing, referred by the appellant against the impugned judge, Honorable Bench was pleased to grant leave by an order to the petitioner to take out an application seeking leave to manufacture advertised oil with a modified trade dress. So he made a statement saying, I want to modify. Court said, can't be done like this. You make an application. So, my lord, the order is annexed. Now, please see para 3. The petitioner states that though in respectful submission there is no likelihood of confusion or similarity whatsoever in respect of the products in dispute, inasmuch as, please mark this, as both the products are essentially different and fall under different classes of the Trademark Act as amended, but in order to avoid controversy, he proposed to use modified bottle. And then he annexes a photograph of it. Now, my lord, please see, my lord, compare this with his modified bottle. Page 11. So, my lord, bottle missing. This is the so-called modification. So he tries to get a snatch interim order without even not showing the bottle. Please see this.
Instead of brown, they use blue. That is what.
That's all. So there is no change. What I'm trying to show your lordship, there is no change in anything. They've just changed one color inside. Now, your lordship will remember two statements over there, particularly the one saying that it's a different product. Now, my lord, please take my opposition to this.
Opposition copy. The difficulty is we have only one copy which has been given. Opposition file করেছিল
হ্যাঁ দাও দাও আরেকটা দাও তো ওকে বরাবর এই ওটা কোথায় আবার প্রবলেম আমারটা নেই আছে তো আরেকটা দেন আই ওন্ট হ্যাঁ দাও দাও দিয়ে দাও but could we give an iPad copy or I'll give my copy done.
Then how can you argue then it will be?
No, Lord, it's there on soft copy. We have a soft. Lord, I'll just tear my back sheet and give it to your lordship. Lord, there may be some folded and marked pages. Please forgive that.
এখানে আপনার কাছে দুটো
হ্যাঁ একটা আছে
দুটো রয়েছে
আমি আরেকটা দিচ্ছি
এটা কি লাস্ট লোকেশনও দিয়েছিল তাই নাকি আপনার কাছে দুটো রয়েছে এটা পাতলা
I'll just hand over my copy.
ডিফারেন্ট হয়ে যাচ্ছে আগের বারে তার মানে পাওয়া যায়নি তখন কপি দিয়েছিল
But is there a mix-up between can 2 and 3?
No, can 3. Both are can 3. So on the last occasion, something was handed over. Must have been. These are also photocopies. Could not be traced out apparently, but these are
copy
thinner than the one which we will follow your today's copy.
Lord, I'll hand over one more copy, Lord.
No, we have after
the lordship has got two. Only one.
No, these are thinner copies. I mean, probably without the annexures or something.
Lord, could be one side photocopy and both sides.
Oh yes. We'll এটা ফেরত দিতে চলে আর যেটা দিলেন সেটা ফেরত দিতে এটা কি দুটোই আপনার ওখানে ঢুকে গেছিল ঠিক আছে
both your lordships have copies, no?
Yes, we have two copies.
Yes, ma'am. Now, my lord, first thing.
Your lordship, excuse me for 2 minutes.
Yes, sir.
Now, my lord, impression given was that this is his only product. Now, my lord, please turn to page 4. Now, it's interesting because page 4, your lordship has found two photographs.
Page 4?
4.
Yes.
Your lordship has found two photographs.
Colored.
They are all, Lord, is it a colored copy?
No.
Lord, then let me hand up mine. Lord. Please take mine, Lord. It's important.
What color?
Duto color. But please come to page 4.
Yes.
Now these are his products, and the not impugned products are the ones on the left and right of the blue bottle. So my green bottle and my yellow bottle are being not copied by him.
So these are all his products.
Yes, these are all his products. Now, but the reason I was saying, please stop there. If your lordship sees all the other products once, and
Apart
then
from the blue.
Then your lordship will find that these are all copies of others. Your lordship will also turn the page, but I'll show your lordship. And for identical products also.
But the others are not before us, so.
No. It is important. I'll tell your lordship why.
Yes.
Now, my lord, please turn to page 6.
Yes.
Now, what has he done? KMP, red oil, Navratna. Lord, please see how closely he tracks the opposition bottle. Then Amla. He colors the Lord oil the same color. Then Lord, please turn the page. KMP and parachute. Parachute. Lord, it's remarkable. It can't happen by choice, not by chance. Lord, people say lightning hits once, but 3 pages, it's hit 3 times. Turn the page. Lord, he tracks everyone's product and he makes it. Now,
but these are somewhat generic shapes.
Maybe. I'm just coming. It doesn't matter. In passing off,
passing off over this shape, then
well, it's not
there'll
just
be
shape.
thought of shapes of bottles.
Not shapes. Not it can't
be
be
the usual
coincidence.
shape of a bottle.
Not,
If you
can't
take,
be, not each of these is a different shape. Please see this.
If they cannot use these shapes, I mean, it's
I'll deal with that part later. I'll deal with that, but please just see that
they'll be thought of shapes. And they'll actually have to do what you suggested in the moment.
I'll deal with that part later. All I'm saying is at the moment, just look at this.
Very well.
He's tracking the shape and the color, both. Color scheme also. Please see that.
Yes, but we are not sure about the others because we don't know anything.
But please have a look only once at page 7. Then please have a look.
We don't know who copied whom. So that also.
I'm not on that. But please comes to page 7. I'll tell your lordship. It will be clear.
Page 7 is
KMP and parachute. Not if your lordship looks at it, even the drop. He has 1 drop, so he's put 3 drops. He's put 3 drops. Now, whether it means that, well, where parachute oil, if one needs to put 1 drop, one will need 3 drops of his product. That I can't say, but he's closely tracking. No, that's not the end of it. Now, Millard,
these are extraneous in a sense.
Yes, now Millard comes to page 8.
Yes.
Page 8. Now look at the bottom photograph. Mine versus his.
Yes.
This is what the matter is about.
আমি ওনারটা দেখেছি কিছুদিন আগে তারপর একটা বাজারে তখন আমি গুলোতে পারি পাশাপাশি রাখলে একটু মোটা একটু ছোট
Now, although side by side,
আমি বাজারে দেখি তাহলে whether I can recollect this is
but although side by side comparison is not to be done.
No, but yet we understand. Yes,
it's not to be done. I appreciate. Now, Millard, see more important, far more important. Millard,
we are smelling coffee beans in between, so that you can. Yes.
Millard, that smell, that there is some element of dishonesty and fraud doesn't go away. Not even with coffee beans. Now, from Millard,
we are only thinking that if you claim this, that you have a prior right of user regarding the shape of the bottle. This is a very generic shape of the bottles.
But I'll deal with that also. But my learned friend says generic.
Too wide. Too
but
wide.
Where is he getting this generic shape of bottle? I have not got this. He has not showed.
If you think about a bottle,
my lord,
what shape do you think if you think about a bottle?
Lord, it will have a body, it will have a neck, it will have a cap, right? Now, Lord, in this case, or in any of these cases. Now, my lord, why would one think of a bottle with these spirals? Lord, no whiskey bottle has these spirals. Lord, for example, no thumbs up bottle will have these.
Yes.
No, so we are on that. Lord, it's this also. Lord, the color is the same. The shape is the same. Lord, this could have been elongated and this long, or it could have been this short. Everything is the same. Which means he is shadowing.
Yours and which is theirs.
No.
Exactly.
No, we are not seeing.
This is a smaller bottle. My learned friend will give the bigger one or smaller one. I don't have it today.
That might not depends on legal metrology.
But we have a smaller one. But Now, my lord, where is the difference? I'll hand it up to your lordship, although my lord, side by side compare. Nothing different.
So then he has
no,
to
these
do-
are empty.
then he has to do-
No, your lordship,
loses.
Lord, your lordship's hands will not become dirty. Let's put it this way.
Oily is worse.
Lord, we are coming with clean. We are coming with clean
Coming
hands.
with clean hands.
Clean hands, Lord. So, Lord, this is the situation. It's the same with the green. Now, the other thing I want to bust. He says the entire operation is gone, although they are different products. This is what he says. Lord, he said it in writing. He's argued it 25 times over. Please see his balance sheet, which I'm annexing. Please see it. 99.5% of his products and sale. 99.5% is what? Your lordship will be shocked.
Edible.
Yes. 99.5% his balance sheet.
He's portraying only the hair product before us. That is what is.
Now, please come there, which means that he is not selling any hair oil. He's selling edible oil only. Lord, please come to.
Yours is edible oil.
Yes. Not as your lordship knows, any pure oil can be applied to the head. It can be used for cooking. Now, his case is, his can be used only for the hair. It can't be used for cooking. That's his case.
That concept has come from this. So anyway, we understand this.
Now, Lord, please see his sales figures.
Page 19.
Lord, please come to page 19.
That's the starting.
Lord, that's his balance sheet.
Yes.
And page 22, which is relevant.
And if your lordship turns to page 22,
What the percentage of
at the top, refined edible oil, 98.80%. Herbal products, hair and body oil, 1.2%. And it goes down.
separate 23 pages?
Comes to page 23, the next year's balance sheet. And at page 26, your lordship will find Lord, edible oil is now 99.41%. Herbal products, 0.5%. And my learned friend keeps saying, he's in a different line. It's a different product. There can't be any infringement. There can't be anything. Business is stalled. So therefore, remove the injunction. Now, these are things which one should have come with clean hands about. Now, the reason, my lord, I show your lordship this, as your lordship is saying, it's not a question of monopoly or anything. Question is, what is his intention? He is closely tracking every major product in the market. Lord, if he is selling hair oil, why does he need to also copy parachute of Dabur in blue? He will copy mine yellow. He will make the same oil, sell it in the same oil, not in a green packet. He will also sell it in a blue packet, which looks like parachute. He will sell not something else, which again looks like Dabur's package. Not dishonesty is writ large. This is all I'm trying to show your lordship. It's not a question of about whether Dabur has monopoly over a particular bottle or parachute has monopoly. But this is a dishonest person.
But aren't there anyone else than them using this sort of a bottle?
My learned friend should have showed your lordship.
Yes,
He has
I have
not.
shown it. I have
Yes,
shown it on the
yes,
page.
please do. I now want to deal with it.
He brought out 4 or 5 bottles of different companies.
Yes, let these be kept over here and then.
That when we got fed up with the bottles for the first time.
Now you are trying to keep clean हो जाएगा, unclean hand हो जाएगा. Now, my lord, your lordship will have these in front. আরো আছে দে না.
Mr. Bachawat,
Yes, my lord, I'm sorry.
fact is that the words KMP
Yes,
all are prominent.
yes.
If one goes to purchase, he can identify that the words KMP.
Absolutely. Absolutely. Now, therefore, my lord, we will come to the law on this, that one can have not what is a action in trade dress. But the trade dress says that my trade dress is mine, even if you sell it under a different trademark, and I'll show your lordship the judgments on that. I'll come to that. I'll just come to that. The law does not come in the way at all. At all. And even
what my
even
is saying KMP can be identified.
Yes, absolutely.
Then it's not trying to pass off.
Lord, your lordship will remember most of the judgments in our country are also based on this, that the purchaser, Lord, may be uneducated. The class of customers becomes very important. Who's buying it? But I can't think of when your lordship would have gone to the Parad Dokan and bought a coconut oil.
I also can't think of.
I doubt.
Now it's all Blinkit. It's all Blinkit.
No, not I still walk down and buy. But the point is, not most people send someone to get it.
Yes.
And that man, Jay Narkel, I'm sorry, get the oil that I use. Go get it. Now, someone who may not be educated, he would say, oh, that
One thing
chai boy,
I
Neil bottle
can
at
tell
my
your
store.
lordship, he sends his peon to get his, and he gets the exact packet. There he makes no mistake.
Those
No,
are
it's
different
because I've
products.
been
Right?
smoking the same brand now for 20 years.
We are speaking about different products.
Other products
He does not make that mistake.
other products I
Coconut oil,
other products I don't send any.
with our hairlines, we don't think we are much interested in coconut oil now.
But I still use it for many purposes. Not for massage, if nothing else. Not in winter, there's no greater pleasure than sitting in the sun after applying a little.
Yes.
Uta kori na.
So, very well. So,
that part I'll deal with. Now, the intention was first to show your lordship dishonesty. Now, when your lordship see the trademark, judgments on not passing off, your lordship will say, we'll find dishonesty is not necessary. But if it's there, that's the end of the matter. That's what the judgments say. And if
whether we can look at other products, them emulating other products, or
I have the law on that. No, I have the law. Lord, I have the law on that also. I will
Extraneous
deal
in
with
the
it.
sense, Mr. Bachao, then you have to establish that theirs came later.
I don't. Because the law on this is established. Because these questions come up every day. What do people do? They say, look, I'm using it because there are 20 others in the market.
For example, we cannot use our own knowledge. It might very well be that Parachute is emulating them. The others' products we cannot look at.
Maybe.
Say that he is dishonest.
Maybe. But the law on this is very clearly, this I'll show your lordship the judgment. But again, to use a parallel example, but a thief can't say that, look, there are 20 other people stealing, so you can't catch me. And that's the parallel used in these matters. Your lordship will find that if someone comes and says there are 20 other people in the market,
No
that
negative
is,
equality.
that is firstly, no help at all. Number two, I have no duty to go after every small manufacturer. Your lordship has never heard of any of these manufacturers. Number three, if my learned friend says that there are other rival products, the judgments say he must show that these are commercially available. He must produce the date and the scale at which it operates. You can't, but someone who has sold, let's say, one bottle of this, he can't claim a defense on the basis of that. He has to necessarily allege that there is commercial use of it in the market. It's available everywhere.
It's his defense, his burden to prove.
Correct. That's the law. I'll deal with each of these. I'll come to it. I'm first trying to get rid of the major aspects of the case that he has made out. So, first point that he made out was, look, there cannot be infringement. Why? The reason I deal with it, although it's not necessary, like I said, the order is only on passing off, but it's necessary to get rid of some of these concepts. Number one, Millard, your lordship will find he has argued. Please give me a moment. I've noted it somewhere to keep it very short. He has said, I don't have registration of shape, color, and design of the bottle, and subsidiary to that, it was also not registrable under the old act. These were the two arguments he made. Now, therefore, I can't claim infringement. In any case, he says, those are disclaimed in my registrations. Now, apart from the fact that I don't have an order on infringement, the law has been both before the new act and not after the new act. It always has been that this is actionable in passing off. It always has been. I'll show your lordship, judgments going from the 60s. In fact, my learned friend himself has relied on Jif Lemon's case.
Yes, he does not deny that even.
So, therefore, an action on the shape of a bottle lies, even with a different name. That is established by his own judgment. So, to say it's not actionable just because I've put KMP on it is perhaps not putting one's case a bit too high.
He says there's a nexus between the shape or the product and the bottle. So, it's not tied up. That the bottle, like that orange shaped bottle.
There need not be. It doesn't say. In fact, that would make it to the contrary. That would actually, if a trademark,
suppose you had a coconut shaped bottle, then That would be, if they had a similar bottle, then it would be
doubtful. I'll tell you, Lordship, why the law seems to be this. That, my lord, if I, for example, my lord, if I call my coconut oil product and give it a brand name called coconut, answer is you can't have it.
Yes.
Because it is purely descriptive of the product.
Yes.
So something which is descriptive of the product, you will generally not get it without many, many years of user. That's
also something which is too generic, Mr. Bachar.
Again, generic can't
Too
be
generic
can't be granted. I agree. I agree, except there's one exception to it, may not be applicable in our case, but not the law seems to recognize, well, 5 categories of products, some which are completely non-registrable, some which are always registrable, and in between lie 3 other classes.
Areas.
And not those areas would depend on the kind of user there has been, really speaking. So, I'm not getting into it, but the fact is not whether I have a registration or not is irrelevant. So that point goes. Now, whether there is a disclaimer in the trademark which is registered
also goes with it.
against, that point goes with it. Now, what I'm pointing out is not, in fact, passing off is a higher right than infringement, and the Supreme Court says so. It's established for a long time, but I think on the last day I had handed over a judgment, 2016 to SCC.
Yes.
Syed Moinuddin. And your lordship has seen it. I'm not placing it again.
You have.
But if your lordship wants,
Paragraph did you rely on any
I'll give your lordship the para numbers.
The paragraphs that
Yes, para 30.4, 30.5, 31.1, and 31.2. Took is good enough. Why overburden the court? Now, so 3 of his points I've lumped together.
Yes.
His next one. Now, with regard to his other argument, different classes, so there can't be infringement. First, I've showed your lordship, it's not different classes. The entire impression given to court is wrong. It's the same product. 1. 2. The law is that even if they are different products, there can be infringement and there can be passing off. And that is covered by a special bench decision of our court. So I'll rely on that. I'm just giving your lordship the overall structure. Overall structure, if your lordship forgives me, not in 5 minutes or so, So, that judgment, can be given to your lordship. The reference is 2009, 1 CHN 852. And the relevant paras are paras 15 to 24, 27, and 28.
Later on, you can hand over photocopies.
I'll hand it over now. I'll place it. I'll place it on the next day.
Yes.
Now, the next argument which he made was section 17. That registration of a mark will not give you a right over the individual parts unless you have applied for or obtained registration of the individual part.
That is also an infringement.
That is also infringement defense. It is not available in passing off. And the court decisions on that are very clear. Not that a disclaimer is completely irrelevant in a passing of action. The 3 judgment, or 1 judgment only, 1 Supreme Court authority, I'll give your lordship on that. Now, on this theory,
yes,
not on what a disclaimer, I'm just giving you a lordship a common sense answer. Assume that there is a disclaimer in a trademark. Now, what is the purpose of a disclaimer? It is to restrict the rights one will claim qua registration.
Yes.
That the registration of mine is confined only to this. So, that's the reason it does not apply in a passing of action, because I have not sought protection under a registration, but under my common law right that I enjoy a right over the whole. So that's the reason that disclaimer argument will not apply.
You can simultaneously have overlapping infringement rights and
of course,
passing off.
Of course, absolutely. There may be times when there will be infringement and no passing off, and there will be times when there will be passing off and no infringement. It would be rare, but there may be.
Or as in your case, you may say infringement on a lesser scale, restricted to the registrations, and on a wider scale, passing off. That may also be
correct. Not the easier case is obviously passing off, so that's the reason not one does it. Now, lastly, on not this infringement, the last argument he had was not he placed reliance on the trademark manual, trademark manual. Now, there, my lord, I just want to make 3 comments. Your lordship will find in the manual itself, it says it is for guidance. And it is to do with the process of registration. It can't be an authority on passing off.
It's a draft.
It's a draft is the other thing. And please see not the first page of it, which is page 3.
Yes.
Now, please come to the second last para. Lord, it starts with the manual is in the nature. I'm sorry, page 3.
Got it. Yeah.
The manual is in the nature of a guide. If any of the statements are at variance or inconsistent with the provisions of the Act or rule, the latter shall prevail. Then, wherever appropriate, reference to case law regarding representation of courts have been made to facilitate better understanding of law, the manual will be finalized after receipt of comments from stakeholders. So this is only a draft. And not right on top, your lordship will find the draft manual.
Draft, yes, we have marked that.
So, my lord, this is nothing. Lord, can this override the law, which is not established law of the country? It certainly can't be my learned friend's argument that this will replace judgments.
No, that was not my argument.
No, but then what's the object of showing it? So, my lord, this, my lord, takes care of the argument on, my lord, infringement, on which he took 2.5 days or so. One section only I show your lordship before I conclude this aspect into the. Please have a look at section 27 once. I'll just give it to your lordship. Or a copy দিয়ে দাও. I'm giving your lordship 2 copies.
ওদের কাছে নেই, টাইম ওয়েস্ট করে। দীপঙ্কর নিয়ে না ওদের কাছ থেকে, টাইমটা নেই।
3 বাজে। আচ্ছা, আমার হাতে 10 মিনিট আরো আছে। But I've given 2 copies.
Yes. Section
27. But I've opened it to the relevant page.
Yes.
Yes. Now, my lord, no person shall be entitled to institute any proceedings to prevent or recover damages for infringement of an unregistered trademark. And next, not is more important, nothing in this act shall be deemed to affect rights of action against any person for passing off goods or services as goods of another person or as services, etc., etc. Or so, my lord, common law rights preserved. Nothing in the Trademark Act will not affect a passing of action. So, reliance on section 17, disclaimer, this, that, all of it is irrelevant. দাঁড়াও, মামলা করা হয়নি, বোতল কেন দেবে?
Yes.
চেঞ্জ বটলটা দাও, চেঞ্জ যেটা চাইছো, চেঞ্জটা কই? কোথায়? Now, my learned friend wanted to change his bottle. Now, let's have a look at it. This is what they wanted to change it to.
This is the one.
Yeah, this is the one that they've handed up. Now, please see, but what is the difference? It's the same thing.
The change bottle in which is there.
So everything is the same. This is what they handed up.
This is
brown and blue.
Yes.
Maroon and blue.
Yes, then he's attached it to the bottle to show it.
Yes.
So these are the corresponding bottles.
Yes.
So, there's no change at all. Now, to get to the meat of the matter. Now, but therefore, there's no change which he's seeking to make at all in any way. Now, the question therefore lies is there passing off? And if so, what is it that I'm seeking? What am I seeking to protect? Now, this is the, now, the case is we are trying to not protect a get-up. Now, what does the get-up comprise of? Get up can include not the color scheme, maybe
dress, you have said.
trade dress, not these are used interchangeably often, not so, but it can include the shape, it can include not markings on it, it can include marks,
the entire appearance, which
the
gives an
entire
impression.
appearance. Not that is the position.
Entire appearance.
Because my
whatever
learned
gives an
friend's
impression.
argument was not based on the fact that color can't be protected, shape of the bottle cannot be protected.
So we cannot dissect it into individual components.
Correct.
You see the impression which is given.
Correct.
That is the
It is the composite
get up or dress.
but it's the composite whole.
Composite
This is
whole.
number one. Number two, even otherwise, I say my learned friend is completely wrong when he says color cannot be protected. Number two, when he says shape cannot be protected, but even that is the subject of any number of decisions. Shape can be protected, not under trademark law, under passing off. And their judgments
It's
not right.
under trademark law, provided you have a registration.
No, passing off.
Passing off, yes.
Yes, so get up. Not we are on the get up under.
For infringement, if you have to have a registration specifically on shape.
Yes.
But for passing off, no.
No. But what I'm saying is, my learned friend's cases, you can't claim a color, either in under infringement or otherwise. I am saying protection of color is now not widespread. Now, this argument that, look, it will mean monopoly on colors, there are 7 colors. This is the argument which one has to meet. But that is also answered. It's nothing original that I'm coming up with. But today there are no 7 colors. But if your lordship goes to the iPad or to the computer or even a LED screen, the TV, your lordship's choice of colors is running into 3 million colors.
No, but then the shade would be so subtle. The distinction will be so subtle.
I know. But I'm just
and
coming.
This impression, recollection, imperfect.
Correct.
That will come.
Correct. What I'm saying is this old aspect of not the 7 colors being there is no longer correct. It's no longer correct. Now, please also remember, I'm not claiming it for every product under the sun.
Exactly. The color tied up with the rest.
With a particular product. With a particular, I'm
total
saying,
combination.
if he wants to sell Coca-Cola in his bottles, well, maybe he's free to do so. I'm not claiming that, look, you can't sell Coca-Cola in these bottles or whatever. Or not grants whiskey in these bottles. That's not my case. I'm saying, look, in this area, my product is known. You can't now start treading on this territory. Now, but at the back of your lordship's mind, please keep 2 facts. One is, I am the prior user, admit it. Because his date of user he has claimed. My date of user, I have given bills. I'll show that.
Your previous volume of business also you have given something to show.
Yes. Now, so therefore, Lord, I have given your lordship advertisements, Hema Malini, Lord, and coconut oil. Well, I thought it was a, good catch, as they say. So, Lord, that is all there. And Lord, the fact of the matter is everyone knows Shalimar to be very well known.
Yes, we are being very careful not to introduce our own personal knowledge into it. So that's why we are asking you. It has to. Those were there on record.
But it has to creep in. If I was doing a matter for
even then,
not a product I don't like, let's say. Let's say. Not one does sometimes feel it. One can't avoid it. Not for example. But
you have to be careful.
But that's not the point. Not because I mean, one is not looking at it as a user from that side or this side. One is not looking at it as a user of that particular product.
So whatever is there on the record, we have to go by that only.
Correct.
Whatever may be our personal.
So I'm not bearing in mind that I am the long prior user by far. Now the question is, if someone else comes in and I am well known in the field, is it or is it not his obligation to avoid selling close to my product? Answer is, as far as trademark law is concerned, a honest trader will always do that. A dishonest
one selling these products?
Going back to 1960s, plastic bottles in 2000s. Now, therefore, there is duty on him not to sell close to mine. If you do and you make some changes to avoid a charge of infringement, that's infringement. To avoid a charge of infringement, the court says, look, this is dishonesty. You have deliberately changed a little to stay out of the ambit of an infringement action. The second aspect of the matter, my lord, is that if you come close to a product, then you must give a very good explanation about this coincidence or how you came about it. Here there is no explanation, none. But if he is the later user and I'm established in the market and there's nothing to say he didn't know of Shalimar being there, then you have to explain. Why did I choose this exact same bottle in the exact same color for the same product? Can't be coincidence. Right? Like I said, lightning strikes once, twice, 3 times. And then he's doing it with every manufacturer. But after that, for him to say that he's entitled to use this bottle in the same color because he has written KMP on it, not very difficult, not for him to succeed on that. So, শেষ করতে হবে আমি জাস্ট একটা জিনিস ছেড়ে শেষ করে দিই So, Lord, I've made general sweeping statements before your lordship. I will show his pleadings. I'll show his pleadings. I'll take 5 or 10 minutes on showing those pleadings before I go to the law. Now, the other thing is not this application which is pending. There's some very interesting judgments which we have when he's asking for change of user. There's a body of case law which says that, look, I came, the one they're using now, when an injunction jeta hol. But I asked for an injunction against this. I have got it. Now someone else comes, or rather the defendant comes and he says, I want to change it. Now, is that new bottle the subject matter of the suit? Is it for your lordships to judge whether that will also be a passing off or not?
Either they comply with the injunction or not.
Correct. Then they take the risk.
Can be German in a contempt proceeding or
correct. No, this is not a advance ruling tribunal where your lordship will rule in advance whether that will also be a passing off or not. So they are judged.
Not also in the nature of a dynamic injunction that we have to look into that.
Correct. Court says, look, this one is bad. I've stopped you. Now he wants to come up with some other bottle. He'll do so. And there's some very nice lines in these judgments. There's the English judgment and the Bombay judgment also. I'll rely on that. So that has to go in any case. But on the next day, what I'll do is I'll now deal with the law of passing off, show your lordship all the cases where not the products look the same, the get-up was, or rather the get-up was similar, not to use technical language, not get-up was similar or the trade dress was similar, but the name was different. So the court not passes injunction.
Just please remember that you have to start from there on the next day.
No, I have to show the judgments and the pleadings.
From the judgments.
Yes. So I'll start there and then go on. I won't take long, brother.
Hard in part for further hearing. Let the matter be listed on November 19, 2025.
Next.
কিছু আছে এদিকে চলে আসছে এদিকে মনে রাখছে অনেক কিছু এই তিনটেও নিতে হবে
But your lordship has kept it on Thursday. Thursday will be 20th. Unless your lordship intended to keep it on Wednesday.
Oh, no, sorry, by mistake.
Yes,
20th.
that should be 20th.
20th.
Perhaps not.
By mistake.
But someone is very alert.
No, they are. All of them. সকাল থেকে সব 19th করে গেছি বোধহয় বেঁচে থাকি এবার থেকে আপনারা একটু খেয়াল রাখবেন কারণ করছি যখন এই ভুলটা 20th হবে পাঠার গুলো সব 20 একটা হয়েছে দেখা যাক কি করা যায়
Lord, before your lordships heard this matter by earlier bench.
And I think my lord has
He has concluded,
yes,
but
and
I
he
have
also
not,
concluded.
No,
Yes.
I have not started argument.
No, you have started. Kindly check that. আপনি দেখুন Sir.
No, I have not concluded, or I just started. Only one thing I want to point out, your lordships, before my learned friend starts. The documents which have been annexed to the stay petition were not part of the trial court's record. No application has been filed for bringing on those records, and in the stay petition, he has not disclosed the documents, means opposition and reply. That has not been included. So pleadings are, so far as stay petition is concerned, that is incomplete. Milord, most of the documents.
He is taking time.
I am not taking time. If your lordship wants to proceed, I can proceed on that basis. But normal rule says you cannot use the documents which are not used before the trial court. And in that case, you
Take that into consideration.
your lordships will take that.
That is one of your arguments, so we cannot look into them. That is one of your arguments that we cannot look into them because there are those are new documents.
Yes, yes.
Without satisfaction of order for 2027.
Yes, yes.
Yes. Yes, Mr.
Yes, my lord. Kindly come to the page 133 of my stay application. That is the impugned order. My lord, I only
Sengupta, just give a
yes,
very
yes,
brief sketch for my learned
yes,
brother.
yes.
Just
Yes,
the appeal against.
yes, yes. Right.
For my brother, just a
Yes.
short sketch.
My lord, admittedly, the land acquisition proceeding was initiated under the West Bengal Land Development Planning Act 1948. And my lord, section 4, 6, 7, and 8 was invoked at the material point of time, and in which all such proceedings, his lands, along with others, were being involved. My lord, no decree was passed, admitted.
No
decree was passed.
It was
on
not a civil suit.
No, it was not civil suit.
No award under the LA Act.
LA Act 11, because in the West Bengal
Proceeding
land,
lapsed.
their
case is proceeding lapsed.
Proceeding lapsed.
What is your answer to that?
But my lord, my answer would be that proceeding didn't lapse because, my lord, the West Bengal Land Development Planning Act, section 4, section 6 has been invoked. My lord, I have handed over the copy of that. My lord, 2 copies, my lord. Kindly read section 6, my lord. Only thing, my lord. Section 6, section 8. Kindly come. First, my lord, kindly come to section 8.
8, yes.
Yes. Then, my lord, it will be clear.
Right.
My lord, got it, my lord?
Yes, yes.
Yes, yes. After making a declaration under section 6, admittedly it was done. The state government may acquire the land and thereupon the provisions of the Land Acquisition Act 1894 in this hereinafter in this section referred to as the said act shall also so far as may be applied. If any case, my lord, this is important, provided that if any case the state government so directs, the collector may at any time after declaration is made under section 6 takes position in accordance with the rules of any bill, bar, tank or other watery area or any waste or arable land in respect of which declaration is made, and thereupon such land shall vest absolutely in the government free from all encroachments. Here is the point. And my submission was to that effect, my lord, at that point of time. Once land is vested, section 11A is not applicable. Why? Because it is parameteria or similar, in other words, similar to the land section 1714 of the Land Acquisition Act. And where, my lord, on the basis of that judgment of the Honorable Apex Court, that is the constitutional main judgment, makes it very clear, even if no compensation was made, even if no, my lord, the award was passed, vesting remains, and there is no provisions in the either in the LA Act or in the, my lord, the in the LA Act, that is relating to LA Act 1, that is, but in the very West Bengal Land Development Planning 1900 there is no such provisions. After acquisition, the government has the power, or the authority has the power to release. Once it is
Because
this,
8A says, 1 says, based
yes,
absolutely.
absolutely, FIFA, and the para and the
This will take over.
yes, this will take over, and government has become the owner of the land.
But the exercise remains only for assessment of compensation.
Compensation and making an award. And my lord, at that point of time, my lord, kindly recall, my lord, that there is no provisions either in the Land Acquisition Act, because so for compensation part, it will be governed by the Land Acquisition Act. So my lord, Land Acquisition Act, the argument was canvassed that 11A is applicable because you did not pass an award. That's why the proceeding lapse. That at that juncture, my lord, that and 2013 Act is applicable. My lord, first of all, my lord, 2013 Act, my argument was, my lord, at that point, 2013 Act is not applicable here. 2013 Act is applicable only if the initiation has been made in terms of Land Acquisition Act. That is one, that now repealed. But my lord, in the 2013 Act, Section 6 of the General Clause Act would be approved as per Section 114. So whatever this right is created, that is saved. And unless there is a provisions for divesting by dint of statute, then they have a case. If it is there, then have a good case.
The case is also not of divesting.
Yes.
They say lapsed.
Lapsed. So, my lord, I will show that as per section, my lord, the section 4, 6, 7, and 8, my lord, even if, my lord, I just put that question to myself, here, in that, my lord, the annexure which I have made in my stay application,
yes,
these are all part of the records. This is a public document. And my lord, kindly see, not that, my lord, they are not aware of that. My lord, first of all, my lord, 4, 6, 7, they made a point at that point of time, my learned senior friend. My lord, first of all, that the Section 11A is squarely applicable, number one. That's why if the award is not passed, as per the section in 11A, that is the amended portion, that if you do not pass any award within a statutory period of time, then proceeding lapse. Well, in the Acquisition Proceeding Land Act, well, there is two type of taking possession and passing an award. One is under Section 16 of the Land Acquisition Act, and another is Section 17(1). And there is a much difference which was discussed by the Honorable
this is
Apex Court.
Akin to 17(1).
Akin to 17(1). And it was nicely discussed by the Honorable Constitutional Bench latest judgment, which says clearly that once it is vested
in the development.
Yes, yes, I have this. In the development, my lord, they are clearly held in respect of Act 1, because I am saying, I am making a humble submission before my lord, that the section 8 is parameteria to Section 17(1).
So the same principles should apply.
Same principles should be applied, and there is no such provisions in that. It is my lord, this act is in subsistence. It is not repealed. This act. My lord, now kindly consider the West Bengal. I am not saying that I will not make an award, I will not make any compensation.
No,
but under which provisions of law compensation? On the last occasion, my lord made an observation. Yes, of course, under Act 1. Because if it is vested, then there is no question of provisions for application under the provisions included in 2013 Act.
No, if you have to reconcile Section 8 with A, 1 with A, then the rest of the exercise will be only for assessment of compensation
and passing an award.
Yes.
My lord, here why I am
held in the other judgment.
Yeah, held in the other judgment. My lord, only one thing, my lord, I will show, my lord. And my lord, above all, my lord, there is no such provisions in the, my lord, even in the West Bengal Land Development Planning 1900, after vesting, my lord, kindly recall, my lord, Section 4(1) of Act 2, my lord, kindly, my lord, already made over a judgment, my lord. There, my lord, held the Honorable larger bench held
Section 41, yes, it is vested, but with a rider section 7A, because at that point of 7A was there. But at that point of time, my lord, I have made a submission because that the once amendment has been taken place in the Act 1, because there is no existence of that Act 2, because Act 2 died temporarily, where that is expired, Act 2 expired. But however, since my lord, the larger bench was there and my lord, the review application was for, that's why my lord didn't entertain and my lord made an observation, you can go for appeal. My lord, here, my lord, what I am on, that I could have understood that like Act 7A in the Act 2, it is inbuilt in this Act. The Act is in subsistence.
Right.
It has not been repealed. Now, my lord, kindly see the another submission was made before my lord that the definition of land, my lord, he made a point. He may kindly recall, my lord, he made a submission before my lord that definition of land at that point of time, in 1951, my lord, the first notice was issued. And my lord, here I should say, my lord, the authority, once it is acquired, once it is vested, and there is no such provisions in the Act itself, neither in the West Bengal Land Development Plan in 1948, nor in the Act 1, my lord, there is no question of relinquish the land.
No, there is no, sir.
No question, but authority has done it. But my lord, yes, my lord, I will show, my lord, because of the certain portion of the land was left out. But they cannot.
After taking possession?
After taking possession, certain portion, my lord, I will show, and then, so far their land is concerned, my lord, possession remains. Possession was taken long back, my lord, 1961 or something. I will show, my lord, it is annexed in my stay application. My lord, kindly see once in, and even 2013 Act, my lord, kindly read. এই জজ সাহেবকে রাইট টু ইনফরমেশন শো করছে, নতুন একটা আছে।
আছে দেখুন, রাইট টু ফেয়ার কম্পেনসেশন 2030।
My lord, I have handed over one copy, my lord. My lord, section 24, my lord. And my lord, kindly, sorry, my lord, my lord, kindly see, I have
পুরো বই পড়ে যাবে কিন্তু দেখে যাচ্ছে অ্যাক্সেস।
My lord, kindly see, I am hand over another.
No.
Kindly see. My lord, because I know, because I have read, my lord, and that's why I can.
No, one book is there.
Yes. My lord, kindly see the wording. My lord, the legislature on its own, my lord, thought it fit what is to be the suitable word, unless my lord can say that there is a there is no meaning. Then my lord can read down the law and my lord.
24th word.
My lord, I am handing over.
We have books, if please continue.
Yes. My lord, kindly see, land acquisition process under Act 1 shall be deemed to have lapsed in certain cases. Kindly see, 1. Notwithstanding anything contained in this Act, in any case of land acquisition proceeding initiated under the land use. So initiation, first of all, my lord, as per the, my lord, the.
We continue.
Yes. As per the, my lord, the Indo Development Authority judgments, the constitutional main judgment, that initiation has to be made first under the Land Acquisition Act, 1. If the initiation is not being made, then there is no question of applicability of section 2013. Above all, the section 24, while interpreted by the Honorable Apex Court, that is the constitutional main judgment in the Indo Development, held that both are being fulfilled. Possession has not been taken and compensation was not paid. These are the finding of the constitutional main judgment. And after that, my lord, another judgment, that is 2023, my lord, I have, because that is not part of, but my lord, the law regarding, my lord, development of the law regarding there in that judgment, my lord, I will, my lord, I have that, my lord, I can.
Mr. Sengupta, it's high time you had some quality assistance also.
Yes,
I
my
don't
lord,
manage it
my
together.
junior is actually, my lord,
Other
he is,
court.
because, my lord, there is small, because I have actually.
You require assistance.
Yes,
only. It's
yes.
difficult to manage.
Yes,
by
yes,
one
my lord.
side.
Only thing, my lord, what I am on, my lord, I will place that. My lord, the development, my lord, after that, after this constitutional man judgment, question arose before the Honorable Apex Court. My lord, there is the three-man judgment. That if the Section 4(1) notice was issued by the state authority, any state government or something like that, prior to 1/1/2014, that is 2013 has come into effect on 1/1/2014. Whether the land acquisition proceedings to lapse or not. If Section 4(1) was issued prior to coming into effect of 2013 Act, that is 1/1/2014, Supreme Court held that lot of arguments were being canvassed, and ultimately the Honorable Apex Court held that no, whatever provisions is there, that acquisition proceeding didn't lapse, it will be governed by the Act 1, 4, then 6, then 9, then 11, but the only word was
Determination of compensation.
Only word was used that in determining the compensation, only the 2013 Act is to be applicable, only, and only
Language
was,
also. There is a language also.
that was the language also.
Of
And
24(1)(a), there is a language.
yes,
Exactly.
only. And my lord, only this compensation part, my lord, under which provision I just put that question to myself, that is Section 26. And I kindly see Section 26.
Yes.
Though it is not relevant, but why I am submitting, my lord, kindly see, because after that, my lord, or so many cases will come up before my lord. That's why my lord, so that my lord can recollect. My lord, kindly see Section 26.
These criteria are to be adopted.
Yes, determination of mark. Why I am submitting, my lord?
Yes.
26 and 30. And there is a provision, because, my lord, kindly consider, if the proceeding be not initiated under the 2013 Act, then Schedule 2, Schedule 3 is not applicable. Only Schedule 1, it is because it is inbuilt in Section 26. It is inbuilt.
Yes.
The everything is, my lord, so my submission would be, this is not the case here, but my
Let
lord,
us
it will
not
come
deviate
here.
from the present
Yes,
case. Let
this
us
is
open it.
come later.
Otherwise this
And now, my lord, kindly consider my lord, the Land Acquisition Act.
আগে দিলেন এটা রেখে দিন এটা রেখে দিন So this is, you are addressing which point?
My lord, why I am addressing? Because 17, my lord, because Land Acquisition Act 17, I will show the verbatim words.
No, 17(1) is similar.
Similar.
You did not show it. Yes.
Yes.
You have
And my lord,
already taken note that this is akin to 17(1).
akin to 17(1). And my lord, kindly see that 11A, my lord, 11A, why it is not applicable? Because it is vested.
There is nothing to lapse.
Nothing to lapse.
If it lapsed, then the compensation, he
yes,
would get the compensation.
Compensation as well as initiation to be made under the 2013 Act.
So therefore, now it has been more or less settled that the purpose of continuation with the proceedings would be after vesting to calculate the compensation and pay him the
and pay the award. And my lord, kindly one thing, my lord, I always.
So is there proof on record, Mr. Sengupta, that you actually took poison under 8(1)(a)?
Yes. So kindly see,
There are
my lord.
materials on record.
6(7), it is an admitted fact, my lord. Kindly see.
All right.
The original order, the single bench order, my lord, that is clear. My lord, it is stated, whatever I have only annexed the documents. Because, my lord, kindly see in the
Documents you cannot annex new documents.
I didn't annex any new
Those were to be there before the writ court also.
Yes, my lord, kindly see the declaration under section 6, declaration under 444 is all there. I have only annexed in annex all these documents to show that this is the, my lord, the.
If the documents are not before the learned single judge.
No, my lord, but it is recorded. Kindly see, kindly come to page 133 of the stay application. My lord, these are all recorded. One. Page 33, my lord, the second paragraph. 12.40 first. Under section 4 of the West Bengal Land Development Planning Act. My lord, the last two, 3 lines from paragraph 2, from bottom. My lord, kindly see, notification under first 12.40 acres in Mauja Satansa.
Yes.
It is a fact. Then, my lord, notification under section 4 of West Bengal Land Development Planning Act referred to was published, giving rise to prosecution of LD number such and such. Declaration under section 3 was published on 19. Possession of land was taken 12th November 1950. By subsequent notification 1950-90, a portion of the land 404 was withdrawn from. Thereafter, a fresh notification under section 4 area 4.9 was published. It is the specific case that no award was declared. I have only annexed all those documents. And, my lord, I pointed out at the, kindly recall, my lord, I pointed out at the material point of
These
time.
are
Even
the narration of their case only.
yes, I am not coming, or I am not making any something new.
Even if you don't look into these new documents, these facts are there.
Yes.
Their repetition.
These are the facts. On the basis of this, the honorable single judge passed this order.
Yes.
Since their all contention was just acquisition proceedings stood lapse, because 11A is 11A is to be applicable, because 2 years time was specified in the 11A after amendment. So 2013 Act is to be applied.
Actually, the plinth of your argument is that this subsequently withdrawn from acquisition, there is no provision.
Yes, my lord, I pointed out before my lord, is a void one. It is a void ab initio. Authority has got no right.
But you have yourself done it.
Maybe, but it is a. It is.
How can you challenge your own action?
I cannot challenge because it is absolutely contrary to law. However, it is not, my lord. So far this case is concerned, my lord, it is not related because so far his portion is concerned with others. It is written.
No withdrawal.
Yes, no withdrawal. My lord, kindly come to my the stay application. My lord, kindly come to. I will show, my lord, the page. First of all, my lord, page 15. That is page 14. That is under section read with section 7. First, 19th May 1950. My lord, kindly just takes a bird's eye view, my lord. Section that is 1/4 page. That is written in the learned honorable single judge order. 19th May 1950, where, my lord, the second paragraph, this declaration is made under the provision section 6, read with section 7 of the land planning in 1948. My lord, the schedule, my lord, the kindly say next page 15. That is the notification, 19th May 1950. Well, under the provision on the 4 of the land development, notification is, my lord, the land schedule is there, my lord. Cadastral survey land schedule is there. Then, my lord, kindly come to the next page 16. My lord, kindly see. 24 Pargona, that is applicable so far. It is applied so far. My case is page 16.
Yes.
Such and such 17th March 1951. That is after the notification, section 6 and 7, although already declared. Kindly see. Power conferred by section 8 of the West Bengal Development Planning Act, read with subsection 1 of section 48 of the Land Acquisition Act 19. Governor is pleased to withdraw from the acquisition 4.04. That is total land 12.40 acres. Total land. Possession was taken over total land. My kindly see. 12.40 out of 12.40, my lord, 4.40 yes was withdrawn. Is it not permissible? It is absolutely.
So this plot numbers 3043 and all these plots mentioned here,
Yes,
That is
3075, may I kindly see his plot, my lord, that is some,
not some portion of this.
yes, my lord, kindly see his writ petition I have annexed, my lord, that is, my lord will find.
Which plots are common in his?
Yes, I'll show, my lord, because he has. Yes, my lord, that is page 50. Three zero four seven 3074, my lord, page 6, page 50, 50, my lord, of the stay application, his writ petition. My lord, the plot was being involved, my lord, the description of the plots are being given.
Yes.
3074, 3075, 3076, 3077, 3078, 3080, 3081, 3083, 3085. Moja same, my lord. Kindly see, kindly now compare, my lord. Kindly see.
Yes, 30765 and 7 are common.
3058 to 3063. 3076 portion of plots 3075 and 3077.
So
3057
76 and 77 are common.
common. 3075 3075 is there, and 3076.
3075, 76 and
Yes,
77.
yes, that these two plots are common.
3.
Yes, certain portion. Mala, kindly see, out of 12.40 acre, it was, but my lord, I think that is not permissible under the, my lord has gone through the, has read the section 8 of the West Bengal Land and Development Planning Act. There is no such provisions. Once it is vested, you can relinquish or you can withdraw. However, my lord, it is, if there cannot be estoppel against any statute. My lord knows that. My lord, if the government thinks anything contrary to law, my lord, that cannot be accepted. Even if whoever I am, my lord, that is doesn't matter. My lord, kindly come to, sorry. Because once it is vested, my lord, unless there is a statutory provisions, you cannot, my lord, withdraw or you cannot eliminate. The section doesn't provide. After acquisition, after vesting, yes, you have a power. And that is very clear, my lord. I will show the judgment of the constitutional bench judgment in the development. I will show that portion, my lord. My lord, kindly come to, sorry.
Yes.
Kindly come to, my lord, page 17A, because 17 is, my lord, is not readable. That's why, my lord, 17A, my lord, I have 17A, my lord, it is. And now, my lord, kindly consider. Certified 17A, my lord.
17A.
Certified that I have this day on 24/5/52 received position from Subodh Ranjan Das, surveyor of 8.73 acres of land situated, my lord, 12.4 minus 4, that is, it will come to 8.73 acres. Now, land such and such in district Chausa, which has been acquired under the declaration under section 1951, published at page 11 Calcutta Gazette 1951. For the, because not all plots are being withdrawn. Only 4.08 out of 12.40. It comes to 8.73. Acres, my lord, possession was taken. My lord, kindly see what position, my lord, circumstances, control in the police station, Parganas, plot number 3066. My lord, kindly see 3074, 3078, 3082, 3086. And portion of 3067, 3075, 3079. Now, my lord, compare to his plot. That is page
Only
50.
3075 is common.
3075. 3075 is common. Only 3075, my lord.
3076 and 3077, as per this.
As per this,
was entirely
only
deacquisition.
Only, yes. No. This is
The remaining portion.
Remaining portion, sir.
After
relinquishing 4 point.
This is the remaining portion. This comprises of the entire portion which remained acquisition.
Acquired.
So this, if this excludes totally 3076 and 3077, then that regarding those plots, they were entirely
entire plot And my lord,
this does not mention 3076.
portion, my lord, kindly see. Portion of
3076 and 77 are not mentioned in the portions. Only
Yes,
3076.
3076.
3076 and
3076 is not there here. My lord, kindly looking at.
half a minute.
Oh, sorry.
Let us make
Sorry,
you
sorry,
understand
sorry.
what you are saying. Plot number, insofar as plot number 3076 and 3077 are concerned, those do not find place at all in this list. Therefore,
In this list, yes, one is here. There.
3076 and 3077 are not there.
No,
Therefore, those were
307.
not retained. Those were entirely relinquished.
Yes, 3075 is there.
That is what we are saying.
Yes.
3075 portion was
Yes,
retained.
portion.
But as
But,
far as
yes.
3076 and 77, totally deacquisition
Deacquisition, yes,
was
yes.
permissible.
Yes, yes.
So your argument that portions were, that holds good only in respect of a portion of 76 and 77, you have to argue independently that
Yes, yes.
no estoppel against
Yes,
law.
yes. My lord, kindly consider then, my lord, page, my lord, next page, my lord, page 18, my lord, kindly come. This is important. Oh, my lord, kindly straightway, kindly come to page 19. Straightway. My lord, 8th November 1979. My lord, page 19, my lord.
Yes.
8th November, my lord, 1979. Whereas the governor is satisfied land measuring 7.80 of or 3 point such as equivalent described in the schedule below. Now, schedule below, kindly see, check it. My lord, the declared to be notified area by the government, such and such, published at such and such, Calcutta Gazette during 1st June 1920 is needed for public purpose, namely for the settlement of emigrants who have migrated into the state of West Bengal on account of circumstances beyond their control. It is hereby declared said land is needed for purpose. Declaration is made under the provision of section 1A. My lord, kindly read. 1A of section 6 of the Act and Planning Act.
So only 0.16 of
My lord, kindly see 30 in here plot, my lord, kindly see cadastral survey, full plots 3066, 3074, 3078, nothing, no.
0.16 is common.
Yes.
As this is a reflection of the previous page.
Yes. Now, my lord, kindly consider, and my lord, we have paid, my lord, kindly come to page 20, 32, page 26, my lord, this is like that akin to my lord section 17, that 80% payment has to be made, my lord, 80% payment as well as 20% also.
Which page?
My lord, it starts from my lord page 22. That is this his predecessor is there, my lord, name is there. And my lord, kindly come to page 32. That apportionment has already been paid. My lord, there is the signature of all the concerned authorities. LAK same, my lord, 93. And my lord, kindly consider one thing now, my lord, kindly see the judgment. My lord, the Supreme Court judgment, that is the constitutional bench judgment, where my lord, page
This deacquisition, Mr. Sengupta, happened after you took possession.
yes, after position. No, position has already been taken. 1952. My lord,
deacquisition is after possession. Withdrawal of acquisition, this is after.
No. Position was, kindly see my, kindly see.
We are saying this withdrawal of acquisition is after you took possession.
Well, kindly see position date is there.
You can just tell us.
Yes, yes. My lord, just my lord, I recollect, my lord, because position was, my lord, that is in the year 24th May 52. 24th May 52. And my lord, that is 17th March, that is, my lord, is just now 4.404 acres. That is in the month of 17th March 1951. After that.
1951?
That is 4.04 acres that was withdrawn That is in the month of, my lord, kindly see page 16, 17th March 1951. And the position, my lord, kindly see the 17, page 17, that certified that I have this day 20, that is second line from top, 24th May to 52, receipt position. And my lord, the portion is there, my lord, the my lord, the this is not legible, that's a legible copy 17A. My lord can check it up.
Then in that event,
yes, my lord.
8(1)(a) would not come in at all. 8(1)(a) would not come in at all. It would not come in because 8(1)(a) is only on position. But if before position it was D.
No, my lord, I am talking about, kindly see 1979. My lord, kindly see the next, the page.
No,
8(1).
How can you take? I mean, you de-acquired the property. De-acquisition.
Not all. Possession remains.
Regarding at least 3076 and 3077, entirely those were.
My lord, kindly see, not 4.04 acres comprising cadastral plots number such and such and portion of plots.
Mr. Sengupta, we just now, why repeat the entire
Yes,
discussion?
sorry.
We already discussed previously that
Yes,
3076, you agreed also. 3076, 3077 was not one of those plots which were retained. Therefore, after deacquisition, entire 3076 and 3077 acquisition was withdrawn. 3076.16 was retained. The rest was deacquisition. But then your argument does not apply because if deacquisition was prior to taking possession, then under 8(1)(a) only it will vest absolutely if possession is taken. But then possession is taken afterwards. Deacquisition took place on 17th of March 1951 when there was still no vesting. Because possession had not been taken, it had not vested. So there is no question of divesting. There is no question of divesting.
My lord, sorry, my lord, kindly.
Where is the question of divesting? It did not vest at all.
My lord, kindly consider one thing.
Before taking possession, it was deacquired.
Kindly consider D, first of all, my lord, the notification where 4.40, my lord, my submission would be, my lord, kindly record my submission, that 4.04 acres, because already before that, 4, 6, 7, 8, that is already there. Because 8, my lord, kindly consider, this will, I will read that section 8. Section 6 is declaration is made under section 6. So, my lord, if the declaration is made under section
But
6.
only made declaration under section 4 or 6.
6, my lord, kindly see. There is an admitted fact that, my lord, kindly see.
Yes.
That is page 14 of my stay application. 6, read with section 7.
19th May 1950.
Yes, 19th May 1950. My lord, second paragraph, my lord.
Yes, under 6.
6 and 7, read with section
6 and 7.
So, my lord, this is 1951, 1950, and my lord, this is position was taken 52. My lord, kindly consider. Position was taken 50 because section 6, my lord, position was taken that is actual figure 52. And my lord, even if, my lord, my submission would be regarding 16, that the authority, once it is vested.
It is not vested before possession is taken. Under 8(1)(a), it vests only when possession is taken.
Yes.
As on 17th of March 1951.
Yes.
Possession had not been taken because possession was taken in 1952.
So portion of the land. Yes, my lord is.
We'll come to that portion later.
Yes.
Just let us first check.
Yes.
19th of May 1950, section 6(7) notification. 17th of March 1951, withdrawal of notification regarding portion. What portion? Regarding 3076, 3077, the entire property was deacquisition, which is clear from your next page, 17A. 17A does not mention within the retained lands 3076 in its entirety, 3077 in its entirety, within that 8 point something. So therefore 3076, 3077 were entirely deacquisition. only 0.16 of 3075 remained insofar as their property is concerned. Their three plots are under consideration here. 3075, 76, 77.
Yes.
Those were only acquired. And out of those, deacquisition happened in respect of 3076 and 3077 entirely.
Yes.
Because 17A you do not mention to have retained
Yes.
3076 and 3077. Therefore, 3076, 3077 and the rest of 3075 apart from 0.16 before vesting you deacquisition. So there was never any vesting, no question of divesting. Your argument fails. Your argument is successful, can be successful only 0.16 of 3075.
Yes. Mala, kindly consider I follow.
Divesting, there is no question of divesting. There was no vesting before possession.
Mala, kindly consider, then Mala, kindly consider one thing.
Deacquisition.
Yes, yes, kindly consider one thing. Then, March 1950, in exercise of power conferred by Section 8, is there any provisions in the Section 8 that the authority has got power to derequisition or withdraw certain proceeding which was under the Act, that is under there, which was already the notice has already been under Section 467. Well, 8 is, kindly see, after making declaration under Section 6, government may acquire the land. Well, kindly see, this is the reading. Well, kindly see, after making declaration under 6 is the very important thing. Well, kindly see, well, the book.
Yes. Let us see under Section 6 language.
Yes. Section 6, my lord is looking Section 6.
Section
Yes.
6 of the
Yes, 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 kindly see. When a kindly see, when a development is sanctioned under Section 7, state government is justified, then land sanction is needed for the purpose. Declaration is to be effective on the public unless already made in Section 7 be made by the state government. When the state government is satisfied after taking consultation report submitted Section 4A, any land notified in the need for public was specified under Section 3, declaration to be effective, such land needed for public works shall made by the state government. Be made by the state. Declaration shall be published in the official gazette, shall serve district authorities, land is the purpose for is needed fixed area where a plan is being prepared, the place where such plan is inspected. Where the state government makes a declaration under Section 1, Section 1A, if it may, if it thinks, insert in the declared statement that the mines of coal, iron, steel, melody, this is not our other minerals lying under the land, any particular portion of the land are needed for the public land is required. But it's not. Section 7, kindly see.
Mr. Sengupta, there is a fallacy in your argument. Section 6 1A says that the notice will be, the declaration will be to the effect that the land is needed for the said purpose.
Yes, sir, that is
But Section 8.1 says,
yes,
8.1,
after making
a declaration.
Before that, kindly Section 7, kindly see.
7
in case of urgency.
That is if you,
because in case of urgency, kindly see, even if make a declaration, even if such notified area,
a different thing. Although no
development scheme, whether it is there or not, immaterial. Now, Section 8.
Section 8 says
that after making a declaration under Section 6.
When we say, please let us.
Sorry.
Section 6, the scheme is Section 6 1A. The notice is for the declaration is for the purpose that the land is needed.
Yes.
For some purpose.
Yes.
That declaration.
Yes.
8.1 says after making a declaration under Section 6,
yes,
the state government may acquire the land.
Yes.
And thereupon the provisions of Land Acquisition Act may apply.
Yes.
So
if any
the
case,
acquisition takes place after Section 6 notice.
Yes, Section 6.
Here, there was no acquisition because before that, Section 6 notice was withdrawn.
So no, Section 6 total, what I am on, in total, kindly see.
Again, you are confusing the two concepts. We are not speaking about total. We are speaking only about 3075.16. 3076, 3077, where the acquisition? You say the state government does not have any power to withdraw notice under Section 6. How can that be correct? Because Section 6 says its intention, state government declares the intention that it is required for such purpose. Yes. 8 says after 6.7, state may acquire the land. So here, state says I won't acquire the land. Even after 6.7 notice, state may say, it may acquire. It may also say, by necessary implication, I don't require. Yes. I won't acquire.
Yes.
Therefore, the second withdrawal of the notice is very much valid. It's not a divesting. No possession was, after possession is taken under 8.1A. You are right. Yes. Here, possession was not taken at that point of time when the notice was withdrawn.
My lord, may I submit, my lord? My lord, kindly come to page 15, my lord. The declaration is, my lord, is notification is there, is needed.
এটা তো বলছে 8-1 এতে একটা মেয়ে মেয়ে বলছে কখন আফটার মেকিং তার ডিক্লারেশন ইটসেলফ কিন্তু অ্যাকুইজিশন নয় ডিক্লারেশনে বললো ডিক্লারেশন দ্যাট দিস ল্যান্ড ইজ রিকোয়ার্ড ফর সাচ পারপাস ডিক্লেয়ার করলাম তারপর সেটা উইথড্র করতে পারি তার পরবর্তী স্টেপ হচ্ছে অ্যাকুয়ার করতে পারে গভর্নমেন্ট অ্যাকুয়ার গভর্নমেন্ট চুজ করতে পারে না অ্যাকুয়ার করতে তো উইথড্র করে নিল সেকশন 6 নোটিফিকেশন যেটা বিশেষ সেনগুপ্ত বলছেন সেটা ইজ রাইট যদি ভেস্ট করে যেত যদি পজিশনটা নিয়ে নিত 8-1 এখানে পজিশন 52 তে আগেই তো নোটিশটাই উইথড্র করবে সে চুজেস নট টু অ্যাকুয়ার
My lord, I followed, my lord. My lord, kindly come to page 90. Page 90. 19. My lord, 8th November 1979. Whereas the governor is satisfied the land measuring about less than, my lord, before that already position was taken. 7.819 acres or 3.7 hectares equivalent described in the schedule below. My lord, being land in area declared to be a notified area by this department notification number 19th May 1950. My lord, kindly go back to, my lord, page 14. 1950, 19th May 1950. My lord, kindly see. Go back to, refer to, that is published in 1st June. Yes, my lord. Is needed for a public purpose. Calcutta Gazette, my lord, that is page 15. Needed for public purpose. Namely for the purpose of settlement of immigrants who have migrated into the state of West Bengal on account of circumstances beyond their control. It is hereby declared that the said land is needed for the aforesaid public purpose. My lord, kindly consider. Now, my lord, let us see, my lord. My lord, kindly look at this in that angle. My lord, kindly. Position was taken, my lord, in the year 1952. All respect of all lands in question, including the petitioner's land. Well, now, my lord, the 8 November 1979, here, my lord, declaration under subsection, declaration is made under the provision of subsection 1A of section 6 under the Original Planning Act, to whom a plan may be inspected in the special diagnosis, and the, my lord, the plots in full and plots in part. Here, my lord, only one plot. Well, now, my lord, let us visualize.
How could you do this? It was never acquired. No notice under section 6.
Yes.
3077 notice you had withdrawn. 3076 and 3077 you had withdrawn the notice.
30
by page 16 notification. Plot number 3076.
Yes, my lord, I'm just coming.
You, Mr. Sengupta, keep in hand one finger in page 16 and one finger.
50, yes.
16, page 16 and page 18.
3067, 3075. 3075 is there, my lord, and 3077 is there. So only 0.16 and 1.03. Let us forget, my lord.
Be kind enough to hear.
Yes, sorry. My lord, I'm sorry.
You don't know the question, but you start answering.
Yes, sir.
Please keep page 16 and 19 together.
16
and 18. Page 16, these are the this is the notice by which you withdraw the acquisition in respect of 3075, 76 and 77. We are bothered with only those plots for the timing because those belong to that. 3076, 75 and
3077.
All these are withdrawn.
Yes.
You say portions of plot number 3075 and 3075. Very well.
Yes.
Now you have shown us the next page.
Yes.
Which clearly demarcates, which says that these are retained. In exercise page 17A, sorry.
17A, yes.
17A, you give a certificate.
Yes.
Receipt portion of such and such, which has been acquired under declaration number such and such for the purpose of settlement of immigrants. That is the rest of the land.
Yes. Only 3075 is included. Only. When other spots are not included. Can you see?
Exactly.
Yes.
So if that be so, if 3075 is only included.
Yes.
So then 3075 a portion has been retained in acquisition. It has been acquired.
Yes.
But 76 and 77 are withdrawn.
Yes.
They fall on that withdrawn. Now, then how can you do this at page 18 in 1979? How can you come back and say that This also covers 3077.
My lord, page 18.
Page 19.
19,
Sorry,
yes.
9.
My lord, 3075. That is
75.16, yes, you are
yes,
right.
0.6 and 3077 1.03.
77.
At best, Malaka 307. Malaka, kindly see his 50 page 50 of his writ petition. 3077 it is there, and 3075 is there. So two portions and the written the Malaka, kindly see 0.16 and 1.03. Malaka, kindly see only these two portions.
So these are also cancelled.
Malaka, kindly consider.
But
Now,
this cancellation is after position being taken, you were saying.
after position was taken, that this 8 November 1979, that 61A was published. This is a public for public purpose.
By this,
Yes.
even the acquired plot of 3077.
Because I was already in position, my position. That's why, my lord, yes.
This portion you say cannot be divested.
Yes. My whole ambition would be, my lord, kindly consider. Otherwise, it would be no value. It have got to kindly consider. Then, my lord, there will be a
This
flat
79
gates.
is a fresh notification under
Yes.
under section.
61. That is written.
It's a fresh notification.
Fresh notification.
But this you have annexed for the first time before this code. This was not before the writ code.
No, it is not there.
How can we look into it?
Page
19.
Page 19, sir. 19. না 19টা খুলুন না, যেটা এই
These two pages.
Yes. Yes. I have. My lord, kindly consider one thing.
New document.
My lord, after all, my lord, this is a
This was
my
not
lord.
before the writ code.
My lord, what I am on.
Order 14 Rule 27 applies.
Yes.
State what could be the reason you did not.
My lord, kindly consider. It is a part of the record. My lord, kindly consider one thing.
Not a part of the record.
No, part of the record. Man, it's the records, public record.
Your record.
It is my records. It is a public documents. It's a notification.
Writ court is not supposed to look into it if it is not produced. It may be a part of whatever. This is not a judgment of a court or a law.
Then, my lord, remand this case, my lord.
Why should we? At the asking, we cannot permit you to fill up your lacuna now in the appellate court.
My lord,
It's
then,
your
my lord,
lacuna. You have to satisfy under Order 14 Rule 27 AAA.
Yes, order 14 because additional evidence, my lord.
Show us that despite due diligence, you could not produce this. Where is the due diligence here? You have not even filed an application under Order 14 Rule 27.
Then I will file that application. My lord can consider. My lord.
Writ court passes on the basis of whatever papers are before it. And we are just backstabbing the writ court by taking in looking.
Not only one thing, because in the
backstabbing the writ court.
In the single judge, my lord, honorable single judge.
Learned single judge had to have these documents before him.
My lord, kindly consider. There is, my lord, kindly only consider that the state, my lord, who appeared in this case, my lord, kindly see. Here, there was no exchange of affidavits. My lord, it is an admitted fact. Kindly consider.
He could have asked for that.
He contended the sins not
Has been filed in the trial court. That has not been annexed.
Has been filed.
Yes, we have used reply.
Then
they only disclose one estimate saying that 80% compensation has been made.
My lord, opposition, my lord, kindly consider. Kindly consider.
Opposition, they have not taken.
They learned advocate appearance said strenuous to dispute the contrary. He contended the since notification under section 4 and declaration was made. Original owner compensation 80% and contending the writ petition are entitled to compare 20% has already been paid. Now, my lord, only consider, my lord, I order, my lord, this my lord is sitting in appeal bench. My lord, this is my lord continuation of suit. My lord, kindly consider. Order 41, my lord, Rule 27, my lord, is squarely applicable. My lord can take note of it. My lord, this is a public documents. This is not this is a private document. My lord, kindly take into, otherwise, my lord, there will be a flat gate and state, my lord, there will be a loss of public exchequer. Only one they are tested. My lord, this is the thing, my lord, only one they have come forward with one case, and if it is tested, if they are testing that, and if they win, my lord, there will be, my lord, a lot of litigations.
Mr. Shenitha, let us first see the impugn order. Please,
Yes.
please the impugn order.
Yes.
Just start with that.
Yes, my lord.
After that, if necessary, we will
Yes,
see
yes,
whether
yes,
we can
yes.
invoke 47B.
My lord, I am press 133. My lord, I am ready. My writ petitioner has prayed for issuance of writ of mandamus to command the respondents to initiate fresh proceeding for acquisition of lands in accordance with law and to declare the award invoking the provision right to fair compensation transparency act, land acquisition and settlement act 2013. Petitioner claimed that their predecessor interest, namely Ankur Chandra Ghosh, was the absolute owner of CS plot number 3074, 3077, 3083, 3085, 3075 of Mauja, Belegata, such in the district of North Chobbish Pargana. During the kindly see here 3074, 3077, 3083, 3085, 3075. Only Mallet kindly see, and during the lifetime predecessor interest, aforesaid plots with the other plots measuring about 12.4 acre in Mauja Satansa, jail number Satansa, was sought to be acquired by the state for the purpose of settlement of immigrants. Notification under section 4 of the West Bengal Land Development 1948 Act was published giving rise to the acquisition proceeding being LAD case number such and such. Declaration under section 1948 was published on 1/6/1950. Possession of the land was taken on 12/11/1950. By a subsequent negotiation 1950, portion of the land 4.04 acre was withdrawn for acquisition. Thereafter, a first notification under section 6 of the for an area of land 4. was published on 1/5/1980. 1st May. My lord, kindly see this is there. Because it is a declaration, what I have annexed. My lord, kindly see that page 19.
Yes.
Page 19 kindly come. This is a declaration.
That is 79.
So that is notification. Huh?
That is 1979. They're speaking of
That is 1979. So this is declaration. Then my notification has to be published. Then my lord, kindly see, my lord, the 4.950 acres was published section 1980. In this is the specific case 4.94 section 6 published on 1/5/1980. Where from he got it?
From page 125.
Page 125.
Notice to the landowners. Page 125.
125.
Yes. Notice to the landowners.
Yes.
Area award declare finding.
Comprised to take an area believed to be interested and entitled to person to under section given 4.9 moral list in Belghoria, such and such PS and association described below recently made about the government of settlement under LTP Act with a declaration 1970-11. Yes. 8/11/90 published in Government Gazette such and such. Kindly see 1/1/9 Then my lord, kindly come. 8th November 1979 declaration. My lord, page 19. Kindly come. This is very much there. 8th November 1979. Kindly see. This is very important.
That has been referred to there.
Yes. 8th November 1979, published in Government Gazette 1/5/1980. So the Lawrence Singh has taken into consideration.
Yes.
Now, there is no question. The date of declaration under section mallet is absolutely right. If I do not go through the mallet, because I was under the impression that
Yes, because the order will say whatever was produced.
Yes.
So you will get an additional ground for your producing this document.
Yes. Mallet, kindly consider that 1/5/1980. That is the Gazette notification.
Yes, please continue.
And my lord, page 127, my lord, that is the entire part. It is there. Page 127 of the writ petition.
Yes.
It is there. My lord, there is no question because they are saying 3085, 3075 part. Well, kindly see 127. It is not
77 3075.
Yes, they are in the dark. There because it is their petition. My lord, kindly come to.
Let us
then
continue
my
the order.
Order, yes. My lord, was published on 1st May 1980. Then my lord got it, my lord. There is no question because it is already.
You sometimes forget what you are doing. Yes.
It is the specific case of the writ petition. No award was declared. On the basis of the said declaration, writ petitioner claimed the entire proceedings to lapse by operation of law since the property of the petitioner has been utilized. Respondent authority should be directed to initiate fresh proceeding under the Civil Right to Information Act, Land Acquisition Declaration 2013. Mr. Bera, such and such, submitted a notice under section 9 was issued to the petitioner, calling upon the petitioner to appear personally by agent on 22nd January 2013 at the office of magistrate, collector, and also to state the nature of the interest of the land. Well, this is before that, my lord, 1/1/2014. That come and what is the amount interest you can claim your, what is the share and justify it. The department state the nature of the interest on property of any claim. Writ petitioner may wish to prefer in respect to lands and may have any objection to the measurement of such lands. Mr. Bera Content said notice was 11/1/2013 and it is therefore evident till that issuance of notice no award has been declared. Simply on the basis of premise that no award was published. That's why, my lord, 2013 Act is to be applicable. By referring section 8 of 19, Mr. Bera contended that after declaration is made, state government may acquire the land and thereupon the provisions of the land acquisition 18 Mr. Bera contended in view of 8, 19 and the time limit fixed by making as provided under section 11A shall be applicable to them. This is their whole argument. Absolutely fallacious, if I am permitted to use. Initiated under 1940, he submitted since no award was made within the time contemplated under section 11A of the 1894, the entire proceeding for action stood lapse. He concluded by submitting since the lands of the petition has been utilized, state government should be directed to initiate proceeding under the 2013 Act. Mr. Bera placed that it is the kind of where land has been utilized for public purpose, the acquisition proceeding stood lapse. Proper course is to initiate fresh acquisition. This is 2016. I am referring 2022. This is a constitutional bench judgment. All those judgments prior to that. Mr. De Learned, Hard Learned Counsel, record reveals. Notice dated 11/1 Form A was issued 1948 Act to the occupiers and other person behind to be interested to be entitled to from the same it is evident. 4.1 more or less situated in such and such district are to be taken by the government settlement and the declaration under section 6 was published 1980. 1/5/1980, my lord. Again, my lord. Then there is the case of the state. It is further appears that the state notice of the plots number such and such entire CS number such as entire present part of was involved in the declaration published under section 6, 1/5/1980. In course of hearing writ petition 1970, Bera restricted his claim of combi in respect of the aforesaid plots of land only. The issue that falls for consideration is under the acquisition of section 4 on entire declaration had lapsed. False, kindly see, these are the consideration, the issues, whether it stood lapse or not. 1948 does not provide time limit for which the collector shall make an award. Under section 8, the making a declaration under section 8 may acquire the land upon the land shall apply. Section 11 of the land was added to the statute in September 1984.
So in 1980, the rest of the of 3075 and 3077, which had not been acquired previously, yes, those were acquired.
Yes.
So he restricts his compensation only to that. What is the difficulty in that?
My lord, kindly consider.
This portion was.
My lord, kindly consider.
The notice was withdrawn before taking possession regarding these parts.
Yes. Then after that, my lord, kind of what? My lord, I am leaving it to my lord. My lord, my submission would be, first of all, this is the law. My lord, kindly.
No, you are saying if possession was taken, we have a very good point. It could not be divested.
Yes.
But regarding admittedly by your admission also, that 75, 3075 and 3077, some part
only some portion
were left out.
Yes, my lord can, if my lord decides. Yes, my lord, kindly.
That is what the land.
But my lord, kindly lay down the law. Otherwise, they will come with several writ petition and get an
single judge has already laid down the.
No, my lord, kindly see. 11A is not applicable.
Oh, he has said
so
that.
Yes.
Softer, please. Otherwise, the learned single judge will be able to hear it.
Sorry. No, my lord knows that.
No, he'll be
Mr.
directly.
Bhattacharya knows. Mr.
Not through our judgment.
Yes, knows me. My lord, only one thing, my lord, 1970. 11A of the land was added to the statute 1984. 11A provides collectors shall make an award within a period of 2 years from the date of publication. If no award was within entire proceedings stand lapse. So on the basis of the premise, the honorable single judge has come to a conclusion because since you did not pass an award within a stipulated time, that is 2 years, that is described in section 11A, that's why 2013 Act is applicable. My submission would be very specific. There is no application of
that the entire acquisition proceeding has lapsed.
Entire acquisition. Then my lord, kindly consider.
Whatever you have already got, that also goes.
Everything gone. That's why, my lord, I have made a humble submission. Then everybody will come forward and take the matter because after all, this is the highest bench of the state. Then honorable single judge has to follow. Entire acquisition proceeding then means, my lord, everything goes.
But even after because 1980, there was a new
Yes, Section 6
declaration.
and notification.
So regarding the previous land which was acquired, the learned judge is not touching because we are very restricted to portions of 307577 which are part of the 1980 declaration. So that 1980 declaration was not followed by any position or any. So that has lapsed. That the learned trial judge is correct. The learned single judge is correct.
But at the same time,
1980 notification lapsed.
My lord, kindly consider, learned judge, honorable single judge,
he is only
did not
restricted
take
to 1980.
My lord, kindly say, my lord, kindly take into consideration. Learned judge has taken into consideration 1 May 1980. That is, my lord, page 19 of my, that is declaration followed by.
He has not held lapsed. You please come to para 11, Mr. Sengupta. Please come to para 11. What he has held to have lapsed.
11. Now turning back to the facts, and court finds that the declaration under 6 was published on 1/5/1980. Then, my lord, kindly consider. Then, my lord, kindly here only 3075 and 3077.16 and 1.03.
Yes.
Only, my lord.
Only that.
Only that. But, my lord, here I am this is my humble submission before my lord, because unless this is set aside, my lord, not honorable single judge did not consider to that fact that whether the acquisition stood lapse or not. Honorable single judge has taken into consideration on the premise that since no award be passed within a statutory period, that is 2 years, from the date of declaration, so entire proceeding lapse.
We are giving you the entire narrative, Mr. Shenukta. Just consider this. 1950, there was the first Section 6-7 notification. After 1950, 1951 occurred. Some of the plots were withdrawn. The notice was withdrawn at that point of time. No position was taken. Therefore, no question of divesting. That notification was withdrawn. That could have been done according to us because under Section 8 it says subsequent.
I agree.
So that within that portion, a part of 3075 and 3077 were also covered. Now, regarding that, you took possession, whatever happened, happened. What was left behind is this 0.16 of 3075 and a portion of 3077.
Yes.
That was left behind. Now, that was also a Section 6 notice was issued in 1980 regarding the left out portion. So that also you start acquiring.
Yes.
They claim they restrict their claim to this portion only, 1980, this portion.
Yes.
Now, that 1980 Section 6 declaration was not followed up by any either possession or any award. So, therefore, learned single judge says regarding 1980, that minuscule portion, part of 3075, 3077, which was subsequently in 1980, it was declared, notification was issued, that portion, that lapsed. So, that is a correct proposition of law because 1980 was not followed by any possession or award within 2 years. Because learned single judge says, after coming into force of the Amendment Act of 1984, this 24th September 1984, from then on, at least it should have been, award should have been passed. Otherwise, Section 11A applies. We are speaking only of the 1980. That is the only scope of the writ petition.
Yes. That's why, my lord,
while discussing, learned single judge discussed all these things.
Yes. But, my lord, the fact remains, my lord, kindly consider if
previous notification has not lapsed.
No.
Learned single judge has not held that also.
Yes. No notification because previous
single judge does not
touch it. Yes, God
does not touch it.
Does not touch
it. He says only that 1/5/1980, that declaration that has not been followed up by 2 years this award. So 11A applies. This court therefore holds that entire acquisition proceeding commencing with the publication of the notification under Section 4 of the. He speaks about 1980 notification.
Yes, my lord.
Only there.
My lord, yes, my lord, kindly consider then, my lord, then if the judgment is to be read as a whole, then the ratio of decedent would be that the Section 6, this vesting, that so far vesting is concerned, because I am referring page 19. My lord, kindly see.
Those are not the subject matter of adjudication here before this learned single judge.
Well, it has taken into consideration requisition
Yes, but
proceedings to lapse.
no adjudication on that. It has been taken. It has not been said that that also lapsed. Here, what has been said is now turning back to the facts of the case that this 80 notification has
Now, my lord, then kindly consider the honorable single judge should have taken into consideration of this the consequence of the declaration and the gazette notification of section 6 is vested.
Which one?
That is if 11,
1980.
19,
1980.
19. Page 19 of my.
That is not declared to have lapsed even.
No, my lord, this is part of that. 3075.6, this is part of that.
Leonard Single Judge says only the declaration of 1980 that has lapsed because that was not followed up by any award.
That's why, my lord, kindly consider. My lord, honorable single judge has taken into consideration of page 19 declaration followed by gazette notification.
So many things might have been considered, but we have to look at the adjudication. What is the adjudication?
Adjudication,
the narrative of the entire facts, what happened.
But my lord, learned judge first has to take into consideration what is the consequence of. My lord, kindly let me make a submission, humble submission. What is the consequence of issuance a notification?
The challenge was to the 1980 notification, not even challenge. Mr. Bera had restricted his claim for compensation in respect of part of plot number 3075, part
And
of plot number
3077.
3077 and 3083, which are the other plots. Those are different. In course of hearing, he has restricted to that only.
But my lord, the declaration is there and notification section 6 is there.
Of 1980.
1980.
That has actually lapsed. Because 1980 notification was not followed up by any award.
And a position has already been taken over.
1980, no. Not taken over. That de-requisition after the de-acquisition,
yes,
these parts were saved.
My lord, I am on. My lord, what I am on. My lord, kindly consider. Then, my lord, kindly consider.
Position was never taken in respect of this.
My lord, position was already taken over by that point of time in the year 1952. There is no such.
This part of 3075 and this 3075.
Yeah, no, this is there. 3075. Kindly come back to my lord the position notice certificate of position. 3075 is there. Kindly see page 17A. And 3082 was there.
Mr. Bera has just, if you see para 2, the learned judge narrates everything and possession of the lands was taken on 12/11/1950.
Yes.
Now declaration of section 6, the possession of the lands was taken on 12/11/1950.
Yes, that is wrong, 52. 50, yes, 50.
50 also possession was taken.
No.
Stated in the representation on the basis of that, we had no records in that time.
That is so far my
in
record.
1950 entire complexion changes.
Yes.
The representation they have said.
But if you have said 1950,
yes.
Even you don't have any papers of 1950.
No,
because just
we have said, but we must confess because we started from 1950. That's why what was stated in the representation to claim compensation at that time, no problem was there. That was written long prior to that, in 1960s, etc., like that.
My lord, kindly consider
Yes,
page 17A. My lord, the honorable single judge order.
Maybe on the basis of records or maybe on the basis of their own statement.
Let us see.
Kindly consider 17A, my lord, that position. Kindly see, only 3075 is there. My lord, kindly consider 3075 position was taken. So, my lord, position was taken long back. My lord, that is after demarcation, portion, after, my lord, kindly see that 4.04 out of 12.420 acres. That this portion of land has been, my lord, after my lord withdrawal. Admitting.
This does not mention 3077.
Yes.
3076.
Yes, only 3075 is mentioned.
Portion of.
And portion. So, my lord, let us see, my lord, in the declaration, page 19.
Only retained by the state.
Yes, my lord, kindly see page 19. Then only 3075 position was taken. 3075, 3077 is not there in the position. At best, my lord can segregate that.
You took possession of only a portion of 3075.
Yes.
So 3076 and 3077 go out. You never took position of 3076 and 3077.
Yes, that is well clear.
If that
3076.
then 3076 and 3077, your
Yes.
argument entirely fails because no position taken, no question of any divestment.
That's why I am.
So 3076 and 3077 were part of 80 notification,
Yes.
which was not followed by award,
Yes.
and that vested.
And my lord,
Lapse.
3075. My lord.
Portion of 3075, yes.
Yes.
You are correct.
Yes. So, my lord, kindly restrict to that, segregate that. And, my lord, I want a, my lord, judgment, because otherwise, the whole premise on the learned honorable single judge has proceeded with, my lord, kindly consider, then the ratio decision will be, there is a lapsing.
So, decision is only on what is held by the judge, not by whatever is discussed or whatever is.
No, my lord, kindly make it clear.
That is the definition of ratio decidendi.
My lord, my submission may be noted, and my lord, fine.
One can be a proposition can be ratio decidendi only if that is directly decided.
Yes.
Came up for consideration and decided directly.
Yes.
Not what can be inferred from it.
Yes, then 3075 is there. That is the in the honorable single judge order.
Whatever is a part of 1980 notification, you yourself notified.
Yes.
1980 notification was your doing.
Yes, and followed by Gazette notification 150. My lord, the honorable single judge has taken note of it. But he didn't take into consideration of that whether the section 8 clearly says that the position, the section 6, once it is there, that is vested to the state. There, section 11A is not applicable.
Section 6 is not vesting to the state, definitely.
Position, yes.
No. Section 6
May
is
at
not
any
vesting.
time after declaration is made.
Section 6 is not at all vesting. Section 6 of this Act, 1940.
No, it's not section 6. And there is section 8. It says, yes, sorry, I stand corrected.
Section 6 notification
Yes.
is only.
Section 6
That
notification.
only was published.
Yes.
And that was withdrawn subsequently in respect of part of plot 3075, 3077, and
Only.
entire 3076. And then subsequently, those were sought to be brought again under this 1979 declaration.
Yes. And followed by, well, that is under section 6. Yes, yes. Now, my lord, kindly see.
So their contention is restricted to 1980 notification, which covers 0.16 of 3075 and 1.03 of 3077.
Yes.
Learned single judge says this was not followed by an award within 2 years. Therefore, 11A applies and it's lapsed.
My lord,
that is correct.
My lord, may I submit, my lord, in a different, kindly look at in different angle, my lord. This judgment, if, my lord, I want a judgment from this honorable court. This after
Get a judgment.
Yes, my lord. Only thing, my lord, what I am.
Dismissed.
Yes.
You will get a judgment, definitely. We have a duty to pass a judgment. Once a matter is moved, we have to pass.
My lord, 3075, that position has already been, my lord, kindly consider. Only the 3075.
Whatever was the subject matter of 1980 notification,
yes,
that has lapsed.
But I must not interrupting, but not only possession certificate includes also other plots mentioned in page 127.
But the bone of contention is 3075, 76, and 775.
We have 5 plots, but my learned friend what is saying, some of these plots are included in the possession certificate.
Some of these 3075 and these also.
Including and other plots also. So we have to go into the question of vesting, whether the vesting has been rightly done.
Well, that's why, my lord.
Ultimately, because I must not say anything beyond record. I should not be misguided. But I have to check it. I have checked it. Some other plots are also there in the possession.
So can we have a chart, Mr. Sengupta? We have heard your arguments.
Yes.
And if you want to say something, you can add right now.
Yes, well, only thing, well, just 2 minutes. Well,
yes, next day we'll just please both of you compare. Ask your juniors to compare a chart so that we can get a chart of what regarding which portion possession was actually taken out of these plots.
That I will prepare
only there
next day.
And please exchange a copy with Mr. Sengupta so that he can also verify.
With that, I pursuant Lordship direction, Honorable Lordship desire, I will prepare that. Also the list of dates also.
Dates of
only thing, kindly direct them to produce the records in absence of order 41 rule 27, because only for this reason one patent irregularity is there. They have disclosed, I have not. Kindly come to page, I am not disturbing you. Kindly come to there to explain. Just a minute. Kindly come to page 14. kindly come, 2 pages, your lordship, kindly come. Page 14. Kindly see, this is declaration dated 19th of May 1950. This is in the before withdrawal. This is in respect of 12.440 acres. Then kindly come to section 4. Page 60, page 40 has page 15, 14A is there. The notification dated 19th of May 1950. This is section 4.
12.40.
12.40.
Yeah.
What I am saying.
The Gazette notification.
Just a minute. Both dates are same. 19th May 1950 and 19th May 1950. Can that be done? On the same day, section 4 and section 6 declaration. Only after hearing objection, after giving 1 month's time, declaration can be published. So records are to be seen by your lordship. This is very anomalous, mirror. Can't be relied upon. On the same day, section 4 say you can publish section 4 notification. Then 4A say you must give opportunity of 1 month's notice. Then mirror 5A say you must prepare a sanction plan. Thereafter you can publish the declaration. On the same day it cannot be.
Yes, Mr. Chen.
Absolutely.
Yes, sir, I am coming. I am coming.
If this is, this declaration is invalid, then taking of possession on the basis of declaration is invalid. And I think, your lordships has observed the judgment passed in daily air tax services case. The possession taken is illegal. 11 doesn't apply. That there is distinction between Satinder Jain that has not been accepted by because my lord Mr. Justice Ganguly sitting with other differed with the decision of that Satinder Jain and ultimately come to the conclusion if possession is taken illegal, then my lord 11A will doesn't apply. So possession certificate is absolutely illegal. If possession goes, everything goes. Then I will make my submission, ask them to produce the record. But I will prepare the list of dates, and these are also I will highlight in my written
These are the
notes.
judgment which
Yes,
my
both
learned
stick on
senior.
the same date.
Yes, my lord.
The same
My lord,
How?
these are the judgment. My lord has my senior learned friend is relied upon. These are now being settled by the constitution.
Get the judgments. How can the declaration?
Yes, my lord. Declaration, my lord, on the same day, this is Gazette notification. My lord, it can be done. Where is the bar? Say,
Look
my
at
lord, kindly
section
see.
4. Look at section 4 and section
4
onwards, in fact.
4 onwards. 1 month's time, objection is must be given.
4 and 6 cannot be.
4 and next subsection 5. Then sanction plan.
Otherwise, 4 would lose meaning.
Yes. There is no right of objection will be, right of audience.
Purpose of 4 is that.
So kindly ask them to produce the record. I don't stand in the way. Let them satisfy that the proceedings.
Yes, where do you get these papers? Then the records must be there.
Yes.
Well, 1950. Well, yes.
But
Produce
you
these
have
papers,
annexed
the
these
records.
papers.
Yes, I think well, some may not be there, but well, something has to be there. Well, yes, I have no hesitation to to place the records. Well, I have not done. But my submission would be well, kindly see. These are not well, kindly see. I could have understood section 6 well, development scheme is sanctioned under section such and such. If it is not there, even if section 7 says yes, it can apply. If the state government thought it fit. Public purpose, malad here, malad kindly see. He just made a submission that hearing is to be given. Where is that? In section 6, there is nothing. But kindly see section 6.
4A, 6.
Baba Dharan. But here development scheme is sanctioned under section 5 and state government satisfied the land.
Please read 4A once.
4A. Any person interested in within a notified area within the trace of notification specifying the notified object to the land in which he is interested.
Even
if every objection, kindly see.
Read the letters separately.
Yes.
Words. 4A, please read slowly, a bit slowly. You will yourself understand.
Yes. Any person interested in the land within a prior notified area may within 30 days within date of notification specifying the area to notified object to the acquisition land.
30 days of date of issue of which notification, Mr. Sengupta?
My lord, kindly consider every objection.
So you consider which notification? 30 days from the date of issue of which notification? Which notification is being spoken about?
30 days, my lord, notification.
30 days from the date of issue of the notification means which notification?
Madam, they kindly see that is, madam, kindly
Tell
see.
us which
Here,
notification?
state government may officer declare any area's notification to any area in the notification to be notified area. This is something
We are
notified.
asking you a simple question. Don't confuse yourself.
Yes.
We are asking you 30 days from the date of issue of the notification. Which
Yes.
notification is being referred to?
My lord, if it is not a notified area, my lord, kindly consider only one thing. My lord, I will bring the records. I will show that, my lord, that there is a distinction.
Even a child of 5 years will know that it is speaking about the notification of the previous section. That is section 4.
Section 4, yes.
We are expecting some honesty from the state.
My lord,
some bit of honesty.
My lord,
section 4 says state government may by notification in the official gazette declare any area specified in the notification to be a notified area. Section 4A says any person interested in any land within a notified area means notification under section 4 within 30 days from the date of issue of the notification. The notification must refer to the previous notification, which is section 4 says declare any area specified in the notification to be notified area. 4 says state may by notification in official gazette declare any area specified in the notification to be a notified area. And 4A says any person interested in any land within a notified area may within 30 days from the date of issue of the notification file an objection. So obviously it refers to section 4. 30 days has to be given in between.
My lord, may I humbly, my lord,
4, 6 on the same date, we missed out the date.
6, my lord, kindly consider one thing. I will bring the records. My lord, I only one thing, my lord.
In the morning we were hearing about an appeal against costs were imposed on a BLR for swearing a wrong false affidavit.
My
Your
lord,
officers will be in trouble, we are telling you, because you have already filed these on oath. This section 4 and section 6, same date. We'll take serious steps if we find ingredients of perjury here. You are being very candid. We are very strict on these. 14 and 16 mention the same date. This is not a gazette notification.
This is under declaration under
This
section
is
6.
not publication in a gazette. No, this is just a paper.
That notification.
This you can get typed. We don't know what is the rate per page now.
My lord, kindly
but at that cost outside the court.
My lord, may I submit?
This can be typed anywhere. This is not a gazette notification. Sorry.
My lord, kindly consider. I will bring the records. My lord, kindly see. My lord, section again, page 14 for the draft. My lord, I am.
14 is not.
My lord, kindly see. No.
It's a typewritten.
No, my lord. 14, page 14. This is a declaration. My lord, kindly see. This is declaration. Under section 6, read with section 17.
Declaration does not have to be under section 4 in a
section 6. My lord, kindly see declaration. Declaration is under section 6. My lord, kindly see. When a development scheme is sanctioned under subsection 2 of state government is satisfied any land in notified area for which the such scheme has been sanctioned. Section 6, my lord, kindly see. Is needed for publish or executing such scheme. A declaration to the such land is needed for unless already made in person section 7. So, my lord, kindly consider this is the difference between section 4. My lord, kindly consider one thing. Then, my lord, kindly come to section. My lord, kindly come to section notification, page 15. My lord, kindly come. This is section 4. My lord, kindly consider. Page 15. Page 15, kindly come.
Page 16 is the section 6 notification.
Section 6, 7, yes. And my lord, kindly see.
To be in an official gazette.
Official gazette.
That is the official
gazette. Declaration has been sent to the press for publication in the Calcutta Gazette.
We want to see the gazette notification. It has been sent to the press. That's your headache.
Yes.
If it was actually published, we don't know.
But I will bring the records. But my lord, the fact remains that notification just now he made a submission that 30 days. My lord, kindly see. This is notification under section 4. Kindly see next page 15.
Yes.
This is section 4. The second paragraph. That is relating to 12.40 acres. This is notification. Notification under section 4. So what my learned senior friend just made a submission that is entirely that is not tenable. He made a submission that section 4 where this same day say public gazette notification section 4. Where is that section 4? This is declaration under section 6 and 7. I will bring that, my lord. Again, it is declaration has been sent to the press.
You could not follow what Mr. Bera said. We are making you understand that.
Yes.
Please come to page 14 and 15.
Yes.
Simultaneously, first come to page 16. 16.
16.
This is 15. 15.
15, yes.
Pagination is very illegible. Page
Yes.
15 is a section 4 notification.
Yes.
See the date, 19th May 1950.
Yes.
Please come to page 14 now.
Yes.
This consequent to this section 4. This is under section 6 and 7.
Yes.
What is the date?
19th May 1950.
Same date.
Same date, yes.
Section 4 and section 6 notice are being published on the same date.
Well, that's why, my lord, I will bring the records, my lord, because there is a.
Therefore, these documents are forged.
No, these documents
These documents are correct. This was entirely bad, and probably that is the reason why it was withdrawn. Because section 4A is very clear of your act, 1948 Act. Has to be 30 days at least between the two, 4 and 6, for objection.
Section, my lord, whatever.
Objection after 4A, 5 is there. Yes.
My lord, 5, my lord, kindly see. State government directs the person
30 days for this
company or local authority to prepare in accordance with development scheme. 5A is not, it's development scheme. My lord, kindly read section 17. 7, section 7, kindly see.
First you overcome 4A.
Yes, 4A.
First you overcome 4A,
Yes.
then go to 5.
Yes, within a notified
days,
area.
30
Within a
days.
notified area.
Oh, there has to be 30 days.
Yes, I
plain English.
I
There is
follow. I
difficulty-
follow.
So great a difficulty in understanding that 30 days.
Well,
are
I
necessary.
follow 30 days notice.
So when
But
is the 30 days?
to what circumstances I will bring the records?
Under no circumstance there be a simultaneous publication of section 4 and section 6 notice on the same day under this act, under the scheme of the act. Under no circumstance. Minimum 30 days has to be there in between.
Well,
Your notices say only on the same day they were
I will.
notified.
Yes, I understood.
Then
I understood. I will bring the records.
if
I
the
will.
gazette notification is required,
Yes.
maybe the gazette notification of section 4 was made on the same day.
Yes.
And this was sent for publication, but that also could not be. But maybe that was published 30 days after considering the objection.
That's why
We
I
never know it.
I
But
will.
those are not before us.
Yes, I will bring the file, my lord. I will bring the file, my lord. I will check it up, and my lord, then my lord, kindly fix a date.
Next Thursday. Within that, can you bring the records?
Yes, there is house not to push for one. I can bring the records.
Next Thursday.
Next Thursday. Just have to next Thursday kori nai.
Hard in part, during arguments, it is pointed out by learned counsel for the respondent that the papers annexed to the stay application were not a part of the records before the writ court. For sub next para, accordingly, it is submitted that the records may be directed to be produced. For sub next para, upon hearing learned counsel appearing for the appellant, we also find that there are certain discrepancies in the papers annexed to the stay application. So one of such discrepancies, as pointed out by learned counsel for the respondent, is that the notice, the declaration dated, the declarations under sections 4 and 6 of the 1948 Act, as annexed at pages 14 and 16 respectively of the stay petition, are both dated May 19, 1950, full stop. However, under the contemplation of the scheme of the 1948 Act, there has to be at least a gap of 30 days between the two, full stop, in order to thrash out such incongruencies and discrepancies, the records, we are of the opinion, are required to be produced. Full stop, next para. Accordingly, the state stroke appellant shall produce the records, the connected records on the returnable date. Full stop, the matter shall next be listed on November 20, 2025 for further hearing.
Obliged.
Thank you.
I will try to prepare a list of dates.
Do that unofficially, you're not putting it, both of you.
Unofficially, because
you also give a copy to Mr. Sengupta so that if he has some difficulty on that.
On the next day, I will have it. I will try. If possible, I will give him advance copy. But other points are raised also regarding.
No, we have not completed hearing him. He has.
Let him complete. Then I will submit.
Then he will submit.
Then I will read in notes.
No, Mr. Sengupta has so many other things to say, because if we get the records, we will find there are other things also.
Yes.
In his favor or against him, whatever.
Yes.
Obliged.
No, no. If the record says that the acquisition is right, then we'll have
Whatever
no
the record
case.
say, we'll go by that.
Certainly.
Obliged.
In my lord, I am actually my lord, led by my senior my lord.
You are?
My lord, your lordship heard this matter at length.
Yes, but we'll just give the background so that for
I'm
Master.
filing the exception to the report submitted by learned senior friend. I'm handing over a copy also.
Oh, now it is being handed over. Now let me file it. Then my
report.
Then my lord,
Supplementary.
Next day.
supplementary affidavit. My lord,
একটা কাগজ অ্যারেস্ট করা আছে।
আমি জানি না কি করেছে, আমি দেখিনি এখন।
কি এসব?
My lord, the issue is whether the
Let's open the case, Mr. Dotto, for my learned brother, so that we can have a background.
yes.
What is the case about?
The issue
We
is
can spend the next 5 minutes in that and
Yes,
then come
that's-
back the next.
now the issue is whether my lord, this the alleged licensee for
FPS.
FPS could be granted the license, and if because of non-fulfillment of the basic eligibility criteria, the we have made out a case that he was not even a valid applicant because he did not fulfill the eligibility criteria. So his selection or his license is void ab initio. And the learned judge, this is just the gist of the matter. The learned judge proceeded on the basis that since license was issued to him, the licensee, he should have been given an opportunity of hearing before cancellation. Now, in the present case, hearing was given not in the fashion that natural justice principles observe after observed natural justice principles. That is the contention of the petition, of course, and the learned judge also accepted that. My submission was since the license was given through inadvertence or by mistake.
It is not a formal cancellation of a valid
It's a
license.
revocation.
It's a revocation or recall of the license
Yes,
granted
yes.
because it is void ab initio.
Yes.
That was your
I
argument.
cited 1985 Supreme Court where in elaborately the Supreme Court has
Authority
explained.
which has the power to issue license can also.
Lordship, I am grateful. Your Lordship
Okay,
remembers.
that was your principle.
Yes. And in this case, one of the observations of natural principles natural is not at all required.
No. Because it is void ab initio.
Yes, that's because it is void. And one of the learned, one of the another, one of the your Lordship, one of the coordinate bench passed an order in this matter itself. My lord,
That is there in your supplementary affidavit.
no, that's not there in the subject. That is in the order sheet. Order sheet there.
Oh, in this appeal itself.
Yeah, in this matter, and it was about to be dismissed, but then my lord, on the prayer.
And Mr. Shahara came in.
Yes, no, my lord, he was all through there. My lord, if I may praise this, that will cut short the matter. This is 19th of June 2025. It's a coordinate bench judgment, a order. I mean, sorry. My lord, having heard the letter, I just hurriedly I am going through it. Malad, yes, I missed one factual aspect. Malad, they applied as cooperative society, but then the requirement was the
কোঅপারেটিভ সোসাইটি বলে অ্যাপ্লাই করলো কিন্তু কোঅপারেটিভ সোসাইটি না।
yes, but it is not a cooperative society. And malad, that mistake was was perpetrated throughout the process till the the revocation. So that mistake was corrected.
They were not a cooperative society even at the time of revocation.
No, they were.
Subsequently,
but the requirement was otherwise, not a cooperative, not from a cooperative society.
Not cooperative society.
Yes, but I just press the fact. Lordship kindly sees the order itself. I just read out for Justice Month. But having heard the learned counsel for the parties, this court is of the view that the appellant has suppressed material facts while applying for license as the FPS dealer in the vacancy notified for the location Radhakantapur, nearby Radhakantapur SSK school. Against the details of the applicant has been entered as a registered cooperative society. The name of the society is also mentioned in the application. Admittedly, Aadhaar number of the secretary of the society has been mentioned in the application. Admittedly, the rate petitioner is a society registered under the West Bengal Societies Registration Act. Yes, and and not under the West Bengal Cooperative Societies Act. The application was expressly ineligible, I'm sorry, my lord, ineligible to participate in the process of selection of APS license of the advertised area. The appellants while processing the writ petitioner's application appear to have clearly committed an error by deeming the writ petitioner as a cooperative society, despite recording that the petitioner is a society registered under the Register of Firms and Societies. Since the error committed by the appellants appears to have been actively induced by a misrepresentation by the respondent writ petitioner, the license of writ petitioner is liable to be revoked. But this is the coordinates bench finding. Then the mistake on the part of the appellants in issuing license to the writ petitioner cannot create any right in favor. I have got the judgment in favor of the writ petitioner, applying the principle that there is estoppel against the law. The similar cases of other registered societies being granted licenses cannot be cited by the appellant in view of the principle against negative equality. Then it is clear to this court that the learned single judge misdirected himself by holding that the procedure under section 24, that is that perimeter with the principle of natural justice, of the control order is required to be applied against the petitioner for termination of his license. The instant case is not a case of termination of license, but revocation.
It's not a case of termination.
So, and I cited judgment of what is revocation.
We'll take you cited on the last occasion also.
Yes, 1985. I handed up 2 copies. I did remember.
You'll just conclude your arguments, and on the next day, and we'll start. We actually started hearing Mr. Shaharawas.
Yes. Now, my lord, the
supplementary affidavit. What has come in new?
My lord, the supplementary affidavit I just placed before Lord Simon.
So we'll start with the supplementary affidavit on the next day.
Very well. Very well.
We'll just record that you have filed it and the exception.
Only few facts, my lord.
We'll start with that.
Very well, my lord.
Supplementary affidavit filed. The supplementary affidavit filed by the appellant and the exception thereto filed by the writ petitioner stroke respondent today be kept on record. Full heard in part for further hearing on November 20, 2025.
2025
কোনো 19 যদি এখন বলে থাকি তাহলে সকালে বলে থাকলে হবে না এখন 19th কোনটা ফিক্স করছে সব 20th হবে
That's a grateful one.
Thank you.
Lordships, kind leave, my lord, leave of my lord Justice Supratim Bhattacharya, my lord, there's a matter which has been listed tomorrow, though it is item number 8, my lord, the Dalmia Securities matter, my lord. It's listed as item number 8. I've also served a notice on my learned friend, my lord. Tomorrow morning, both me as well as Mr. Rai is in some difficulty.
Somebody, if you're in difficulty, will.
Yes, my lord.
Tomorrow, when if it is called on, then just.
Yes, it's a little lower down, my lord, but.
Not be reached also, but if you reach it, then if somebody keep somebody who will.
Yes, yes. Very well, grateful, my lord.